Programme motion, Minister to move. The question is that the Criminal Justice Bill Programming number 3 motion as on the order paper. Minister?
Thank you very much, Mr Deputy Speaker. It is an honour to open this debate and to bring the Criminal Justice Bill back to the House for discussion at report stage. This is an important piece of legislation focused on countering...
This is the programme motion. Does the Minister wish to speak to the programme motion?
No.
We've done that bit. Does anybody else wish to speak to the programme motion? Yes. Hi, go.
Thank you, Mr Deputy Speaker. I rise to speak on the programme motion that was tabled yesterday afternoon, shortly before the rise of House, relating to the consideration of hundreds of amendments and new clauses to what is a serious and substantial bill. These relate to some of the most fundamental issues affecting our constituents. Today there is a debate on amendments and new clauses covering domestic abuse, to human trafficking, to transfers of prisoners to foreign prisons. Yet the House was only aware that this was the case yesterday evening. I am sure that members from across this House will have been up late trying their best to prepare as I was. But my duty to my constituents compels me to place on record my shock and worry about what this means, not only in terms of parliamentary democracy, but the quality of legislation that will actually be passed. Last week, there was an absurd situation where there was a deadline for the tabling of amendments and new clauses for a debate that we did not know what the business of which it would cover. And then I come to the 134 government amendments from my last count, tabled virtually at the last minute. These are not unsubstantial or merely technical, but include measures relating to new offences which would have potentially significant and wide-reaching consequences for our civil liberties and could even result in imprisonment. Mr Deputy Speaker, these amendments literally include things like further powers to the police to exercise without accountability. And I'm sure I don't need to remind this House that many of our constituents are very worried at the powers that the police already have and how they use them. It's no secret that trust in the police, particularly amongst women, survivors and people from diverse backgrounds, is already very low. And whatever the different views are across the House, surely there is consensus that measures of such significance, measures that could have very severe, potentially life-changing consequences for our constituents, should not be passed without appropriate scrutiny and without many of us even knowing of their existence. Certainly there has been very little public awareness or debate accordingly. Now, as members of Parliament, we have a profound duty to those who elect us regarding the scrutiny of legislation. It's not only about having a functioning democracy, but having workable and functioning laws. There are many questions about impact assessments and disabilities and equalities implications about which we do not know the full implications. For example, Government New Clause 96 prohibits wearing or otherwise using an item for the purpose of concealing identity in a locality designated by the police. And before even getting to a fundamental assessment of this measure as a whole, there are many questions and points of clarity that I know that my constituents would want at the very least to be publicly established. Just to raise one such question, how will this impact Muslim women who wear the hijab or the niqab? Because the phrasing of the new clause refers to using an item wholly or mainly. And Mr Deputy Speaker, in my closing remarks, I just want to place on record my alarm at this government's now fairly frequent tabling of large numbers of amendments at report stage, the short notice, the compressed time for debate and scrutiny, and to be honest, what many of us experience as utter confusion regarding timetabling, which is very dangerous in terms of the precedent that it sets. It's not in the spirit of parliamentary democracy, and I urge the government to withdraw these extra substantial amendments and allow for proper, democratic, sensible and transparent scrutiny that I know our constituents do expect of us.
Maria Miller.
Thank you, Mr Deputy Speaker, and I rise to follow the Honourable Lady, and I understand the point she's making, though of course we would want to make sure that people listening to this debate were aware of the fact there's 2 days of debate on the bill this week and next week, which I hope will afford some of the scrutiny that the Honourable Lady is rightly calling for. Can I, however, perhaps gently suggest to the Treasury bench that they may want to do some one-to-one meetings with those of us who are interested in a number of the areas that the government has now laid amendments on just a couple of days before this important report stage, so that we can get a proper understanding of what the government is trying to do, and perhaps it would have been prudent to have done that before the report stage.
The question is the Criminal Justice Bill, programme number 2 motion, as on the order paper. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Clerk will now proceed to read the orders of the day.
Criminal Justice Bill, as amended in the Public Bill Committee, to be considered. Now.
We begin with Government New Clause 86, with which it will be convenient to take other new clauses, amendments and new schedules as listed on the selection paper. Minister to move New Clause 86. Laura Farris.
Thank you, Mr Deputy Speaker, and I have heard what both of the honourable ladies say and made a careful note, actually. I want to say I think the fact that this is split over 2 days may have contributed to that, but I will take this away and I have listened carefully. Mr Deputy Speaker, it is an honour again to open this debate and bring the Criminal Justice Bill back to the House for this discussion at report stage. It is an important piece of legislation. Its focus is on countering developing criminal threats, intercepting serious organised crime and protecting vulnerable victims. And I want to thank members from both sides, all sides of the House, for their constructive engagement in this bill, as well as the police, leading academics, practising lawyers and campaign groups, some of whom appeared before us at Bill Committee, who have all contributed to its development. There are many topics to discuss today, and I do look forward to hearing the views of members. The Government is bringing forward a number of amendments which we believe are both appropriate and necessary to punish offenders and enhance the protection that victims deserve. I will briefly explain the key government amendments that are before the House. I will start with those about which I anticipate there will be no dispute. The extension to Northern Ireland of both our new spiking measures at Clause 13 of the Bill and the statutory aggravating factor for grooming activity in relation to child sexual offences at Section 30. New Clause 88, which provides for equivalence in sentencing for terrorist offenders between England and Wales and Northern Ireland as a consequence of the irregularity that was identified in the case of the Crown and Perry. Mr Deputy Speaker, may I begin by addressing our provision on the unduly lenient sentencing scheme, which is Government New Clause 89. This extends the time limit for the unduly lenient sentence scheme. Under this amendment, we are extending the overall time limit to 6 weeks. A request must still be submitted by any prospective appellant to the Attorney General's office within the usual 28 days, but the Attorney General's office will have an additional 14 days to consider whether the case is appropriate for submission to the Court of Appeal. In recent years, we have seen the number of cases that are referred to the law officers increase. I think that's in part due to a better awareness of the scheme. We consider it to be in the interests of justice that each application is given due care and attention, even when it is submitted close to the 28-day deadline, and we believe that this clause is a proportionate way of achieving that. Mr Deputy Speaker, let me turn to the issue of attendance at sentencing hearings. A change has been initiated already in this legislation in response to public concerns about high-profile cases such as that of Lucy Letby, Jordan McSweeney, Thomas Cashman, all of whom refused to attend their sentencing hearing.
Will my honourable friend give way on that point?
I will, of course.
Does my honourable friend agree that those cases which rightly have gained a huge amount of public traction are ones that it is absolutely appropriate for the government to be making further announcements and measures on at this stage of the legislation?
Well, I agree with that sentiment entirely. We are creating an express statutory power already at Section 28 to compel an offender to attend that sentencing hearing if they have been convicted of a crime for which the maximum sentence is life. But we have also listened to those who are concerned about offences that might not have been caught by this. And I want to confirm that the government has tabled amendments 148 to 150 to extend the measure to all offences that might attract a maximum sentence of 14 years or more. I will, of course.
My friend for giving way, and I'm very grateful to the Lord Chancellor and for the Minister and for other ministers for listening to the case I made at second reading to do precisely this and extend the power. I had a case in my constituency where an offender was convicted of sexually assaulting a child under 13, which carries a 14-year sentence. They hid away in their cell and didn't come to court. Under the original provisions, they wouldn't have been captured. Under these amendments, they would be, and can I welcome that?
Yeah.
Well, can I thank the Honourable Member for North West Norfolk? It was the speech he gave at second reading, Mr Deputy Speaker, that played a major role in the change that we're introducing today. I want to reassure him that the change we're bringing brings into scope most sexual assault cases, terrorist cases and racially aggravated offences, and I can confirm to him that the specific case he raised at second reading will be or would have been brought into scope by the change that he has campaigned for. Just to remind the House, the sanction for non-attendance at a sentencing hearing is up to a maximum of another 2 years in custody. Government new clause 86 creates an offence of creating a sexually explicit deepfake of an adult without their consent. Honourable members will already be aware that sharing of intimate images, whether they are real or fake, is already prescribed under the Online Safety Act. But we consider that we cannot complete the task of protecting people, principally women, unless we add the creation of pseudo-images or deepfakes to that package of protection. Mr Deputy Speaker, in taking this step, we are the first, or if I'm wrong about that, we are among the first national legislatures to do so. Yeah. And we do so because we recognise the inherent risk that is posed by the creation of these images, both to the individual that's depicted and to society more widely. I will give way.
And I know she will have given thought to this, but does she agree with me that there is a problem not just with deepfake sexual images, but more widely deepfake images which purport to show individuals, people, potentially even members of this House, doing and saying things that they haven't, which have no sexual connotations whatsoever?
Minister. I am very grateful to the Honourable Lady, my honourable friend, for raising this. We are encountering a rapidly changing world of deepfake images that can be used for the purposes of manipulating voices to try and influence political attitudes and choices. And I have to make clear that this is a confined amendment which goes only to the creation of sexually explicit images. However, it is my hope, humbly expressed at this dispatch box, that it may provide the gateway and the lever for future development of more law around this. And I thank her for her intervention. Yes, of course.
I'd like to thank the Minister for giving way, but I'd particularly like to thank her for this amendment. It obviously only covers adults because producing such content of children is already illegal. But I'm told that since the government announced their intention to do this, both Apple and Google have already removed from their app stores a number of apps which were enabling the users to produce deepfake nudes. And those applications have been used to create indecent images of children as well as adults. And disabling those apps has already helped to keep the public safe and to significantly improve the safeguarding of children. So just by tabling this amendment, the government has already forced the industry to act in the UK. So thank you.
I thank the honourable member for Chelmsford. That is music to our ears. It was not lost on us that within days of making the announcement, 2 of the major deepfake/nudify sites had blocked access to UK users in anticipation of the fact that even the act of using that site would become a criminal offence under our impending legislation.
Will my honourable friend give way?
Of course I will give way, yes.
I'm grateful to my honourable friend for giving way. Can I thank her for her personal championing of this new clause? As she knows, the Science and Innovation Technology Select Committee recommended this, and we benefited from a seminar conducted with the campaigners that Glamour magazine brought together to bring the experience of people right across the country to this focal point. And they deserve credit themselves for having brought this to the House, but the Minister, my honourable friend, does for championing it so brilliantly and bringing it today.
Minister.
Well, I thank my right honourable friend for his intervention. I have to also thank the team at Glamour magazine because they led an excellent campaign. I was actually halfway through trying to make this change myself when I became aware of it, but I read the material that they put out. It totally chimed with our objectives, and I know that he welcomed them to Parliament just a few weeks ago. Yes, I will give way.
Can I thank my honourable friend for giving way? And it's an important issue to be dealt with, intimate image abuse. Can she explain why she hasn't approached it in the same way as her colleagues approached intimate image abuse in the online safety bill? Because it was a long-fought battle to have the online safety bill recognise consent as being pivotal in this issue, yet she's chosen not to take that approach at this stage, which I think many will find disappointing.
Well, I want to be very clear, and I thank the Honourable Lady for her intervention. I want to be crystal clear that the new clause does require that the offence is committed if the pseudo-image is created without the consent of the person who is the subject. That's at subsection 1C and also at subsection 2C. Let me talk for a moment about intent. The clause does differ from some of the content of the Online Safety Act. So it is not a clause that relates to intimate images, for example, a person wearing a swimsuit. It applies to sexually explicit images, which is defined in legislation. It requires that not only that the image is sexually explicit and that it is created without the consent of the subject matter, but that it is done for the purposes of sexual gratification or with the intent of causing humiliation, alarm or distress. I simply say gently, when this clause was debated at the Bill Committee, I think it was the Honourable Member for Nottingham North who had tabled it, he will recognise the intent provisions that the government's adopted are the same as those of the opposition. I am very much aware of what she's saying about the base events, and perhaps I can allay her concerns by simply saying this. This is a novel new measure for the government to take, and in fact for any government to take. I think she makes very sensible and compelling arguments on this point, and I hope she will feel reassured if we take for the time being an iterative approach. She will recall, of course, that the Law Commission recommended that we didn't introduce legislation at all, and I will come on to say a little bit about that. But I think it is right to say that other countries are looking at us very carefully. The Justice Secretary was at the G7 in Venice just last weekend, and other G7 Justice Ministers had noticed that we had made this change and were observing carefully. But we make this change because we recognise that the inherent risk that is posed by these images, we recognise the offence to be overwhelmingly targeted at women, predicated on an absence of consent, and as such to be a gateway to more serious offending. We make 3 points by way of clarification. We did carefully consider the recommendations of the Law Commission in their excellent report on intimate image abuse, which has informed much of our recent work, although respectfully on this we have diverged from their point of view. In response to some of their concerns, though, I simply would like to reassure the House on this. First, we recognise the amendment could criminalise young people, particularly teenage boys. To reduce the risk of over-criminalisation, we believe we have set pragmatic parameters. Creation alone will be a non-imprisonable offence, although it will incur a potentially unlimited fine. The offence of creation alone would not attract notification requirements, meaning that the offender will not be placed on the sex offenders register. As honourable members will know, all of this changes if indeed the image is then shared. Victims of this offence will be entitled to automatic anonymity in line with all the other sexual offences, and they will also be eligible for special measures at trial. And I will just simply conclude by saying we are delighted to see major deepfake websites withdraw from the United Kingdom, and we would encourage the others to follow their lead. I turn now, Mr Deputy Speaker, to Government New Clause 87, which introduces a statutory aggravating factor for manslaughter involving sexual conduct. This clause corresponds to and potentially should be read in conjunction with Section 71 of the Domestic Abuse Act 2021, which says it is not a defence to argue that a victim consented to the infliction of serious harm for the purpose of sexual gratification. Mr. Deputy Speaker, we have long held concerns about killing of this nature where, by definition, the victim cannot give an account of consent, and yet, on occasions, the court has implicitly sought to categorise the killing as a consequence of sexual choice, as opposed to the consequence of the development of social norms based on structural inequality. We invited the eminent criminal barrister Claire Wade Casey to consider this issue specifically in her domestic homicide review last year, and she said that cases of this nature must be viewed through the prism of coercive control, and the policy underpinning the law ought to consider the wider harms which emanate from the behaviour which can and does lead to this category of homicide. We agree, and we are increasing the punishment for degrading and abusive conduct of this nature. Following careful consultation with the Sentencing Council, we are tabling a statutory aggravating factor so that sentences for manslaughter involving sexual conduct must be more severe. It will cover all cases where the act is directly attributable to sexual conduct. Honourable members will know, or the Honourable Member for Birmingham Yardley, I wanted to provide one point of reassurance from this. She will know from all her work, but particularly the research that was conducted by We Can't Consent to This and the team, that of all these homicides, almost 60% of them are strangulation cases. I know that's not the point she wishes to make with her amendment, but it does have some overlap, and I wanted to provide her with that reassurance today. On the issue of parental responsibility, as members will be aware, the government has already amended the Children's Act 1989 via the Victims and Prisoners Bill to provide for the automatic suspension of parental responsibility in cases where one parent kills the other. We are making an amendment to develop the law further, providing that where a father is convicted of child rape, parental responsibility he may have for any child will be automatically suspended. I want to pay tribute to the Right Honourable Member for Camberwell and Peckham. I think she's in the wars actually at the moment. But I want to pay tribute to her for the way that she's presented this issue, and she has advanced the compelling argument that we have long established principles to protect children from sex offenders by placing people on the sex offenders register and protecting them from working with children. But while we have measures to protect other people's children, the same protection doesn't exist for the children of the offender unless the mother goes to the family court to remove his rights. I want to pay tribute to Sancha Berg, the journalist who revealed this issue through her work and highlighted the practical obstacles that some mothers had faced in making this application, and to other families who have talked about their experience of this, including via their Member of Parliament, one example being the member for Meriden. I'm not sure if he's in here. I want to add the father will still be able to apply to the family court to have the suspension of his parental responsibility lifted, but it's obviously fair to assume that if he's been convicted of child rape, it's an application that is unlikely to succeed. And we've also included a clear requirement for this measure to be reviewed after it has been in place for 3 years. Of course, I'll give way, yes.
The Honourable Lady, and it is a pleasure actually in the gallery to see some of the families who have championed this, certainly from the West Midlands. But I just want to ask, am I right in thinking, and I really hope that I'm not, that it is only the rape of a child, convicted of the rape of a child, not other sexual offences against a child, and it's a child over 13 and over?
You are correct in that, and I simply want to say, again, this is a novel power that we're extending to Crown Court judges who don't typically have any knowledge of family law matters or the family law background. And once again, we think it's right we take an iterative approach to this. The mother of the house actually agreed with that approach. There was a dialogue between her and the Lord Chancellor on this point, and I don't want to put words in her mouth because I'm keenly aware of her absence when she should be speaking to her own amendment, but I believe that she is satisfied with this. Okay. I believe she is satisfied with where we've got to. So I commend this amendment and would urge all colleagues to give it their support. Turning next to new clauses 94 and 95 and Schedule 94. And I want to commend my right honourable friend, the member for Chingford and Woodford Green, for his excellent campaign and dedication to crafting a new offence. And I have to mention also the member for Eastbourne and the member for Hertford and Stortford, who also came to see me about this and made a really compelling argument. When it comes to cuckooing, although there are a range of current offences that can be applied, the government has listened carefully to concerns about weaknesses in the existing legal framework. And so, new Clause 94 provides for a bespoke criminal offence to tackle cuckooing. This offence criminalises the control, whether exercised by means of coercion or otherwise, over another person's home for the purpose of using it as a base to commit specified criminal activity. The specified offences are listed in the new schedule, and they include drugs offences, sexual offences and offensive weapons crimes. This is, I want to stress, a non-exhaustive list which the Secretary of State can amend as modes of criminality might develop. I want to give some reassurance to the honourable gentleman, the member for Chingford and Woodford Green, about the issue of consent, which of course is a defence if a person has allowed somebody into their home. The issue of consent will only apply if it is determined to have been given freely and to have been given on a continuous basis. Of course, coercion would be the principal test that would be applied in assessing that freedom of choice. Yes, I will, of course.
I'm grateful for that, because the key bit about cuckooing is that the police have never been able to arrest somebody because they've taken over the house. They have to prove criminal activities inside. So this will break new ground and protect them. But there is an important point about coercion. Will she guarantee that in the guidance notes that are attached to this bill, it will be very clear to police that they should be checking that they are not being coerced into saying that they have given their support and consent? That's very important for the police to know that.
I can confirm that, and actually I think that is an excellent suggestion, and I thank the honourable gentleman once again. Before I conclude, I'd like to address a number of other matters that have been raised by members and tabled as amendments, and I would like to start with the amendment that was tabled by the honourable member for Chatham and Aylesford and the right honourable... Sorry, yes, of course.
She has addressed this already and I missed it, but can I get from her an explanation about Government New Clause 102, which seeks to remove the protections of the Human Rights Act in relation to the effectively excludes the defence of lawful or reasonable excuses. This is now the fourth piece of legislation that the government has brought to remove the protections of the Human Rights Act. Surely, we understand the reasons why they couldn't proceed with a Bill of Rights, but surely if they are going to remove human rights protections, it should be done in a proper, considered manner and not just salami sliced like this.
I thank the honourable member. I will have to just double-check that clause, but I would simply say that the right to make certain... with two exceptions, all the Convention rights are qualified rights and can be restricted in reasonable circumstances. I promise I will check that clause and come back to him in closing, if I may. I was in the process, though, I think, of paying tribute to the honourable members for Chatham and Aylesford and the right honourable member for Tunbridge Wells, if I may return to that subject, and for really the outstanding representation who they have given to their constituents who were affected by David Fuller's acts of depravity. This is reflected in the amendments they've tabled and which the government supports on the offence of necrophilia. It is perhaps a rare thing in 2024 that an offence can be identified which Parliament has not even previously considered. But such were the extent of Fuller's offending that we have had to do so, and the government is pleased to confirm that the Sexual Offences Act 2003 will be amended under this legislation to capture the sexual touching of a corpse with a new maximum sentence of 7 years for penetrative offences and 5 for non-penetrative acts. I will, of course, yes.
Very grateful for the Minister for her very kind comments, and I know my honourable friend for Tunbridge Wells is going to try and catch the speaker's eye later and will speak in more detail on this, but can I just take this opportunity to pay tribute to her for taking a lot of time to work this amendment through thoughtfully and correctly so that it can give greater protection for the future, and also some comfort to the victims to the victims' family of David Fuller, that justice, has been thought about, and and she has listened very sensitively and carefully to these comments from our constituents.
Yeah.
I thank my honourable friend for her comments. I mean, these were truly appalling crimes, and I did have both of their constituents in mind when I thought about how we might, both the constituents of both of you in mind when I was thinking about how we could develop the law. Of course, we can't change what happened in the past, but I hope we can send the clearest possible message about this in the future. I want to just come on to a couple of other matters, and I'm not going to preempt what honourable members might be inclined to say, Mr Deputy Speaker, but I wanted to touch on a couple of them. First, I wanted to talk about New Clause 9, which is the issue of one-punch manslaughter, and I want to pay very special tribute to my honourable friend and my friend, the member for Bishop Auckland. This was not an ordinary campaign for her. It was one that was born out of the deep tragedy of her childhood. I know that she's going to speak on it, and I'm going to respond in detail when she has done so, but I hope she won't mind me saying I think her dad would feel very proud of the way that she has conducted herself on this issue, and he'd be pleased with the changes we are making. And the final matter I wanted to discuss, Mr Deputy Speaker, before I sit down, were a number of the amendments that have been tabled by the Honourable Member for Stockton North, and that's in relation to prisoner transfer to prisons overseas that are set out in the bill. I want to set out the government's position to these in general, and in particular in relation to the criteria for transfer. The government agrees that not all prisoners will be appropriate for transfer to rented prisons overseas. Indeed, the Honourable Member has set out some very sensible principles in his own amendments. But I would like to say this, to give him 3 points of reassurance. The proposal for foreign prisoner transfer will extend to approximately 600 prisoners. This is equivalent to just under 0.5% of the entire prison estate. I can confirm we will not be negotiating a prison transfer agreement with a women's prison. We will only conclude a deal with a country who can demonstrate that their prison conditions and capabilities meet the applicable human rights standards, and the Secretary of State retains responsibility for each prisoner, which ensures that any transferred prisoner retains all their rights, irrespective of where they may be transferred under the European Convention on Human Rights. However, when it comes to negotiating further terms, we do believe that legislation is the best place for this, with the appropriate involvement of experts. And the Lord Chancellor has already confirmed that honourable members may be assured that the use of these powers requires there to be a valid international agreement, and any such agreement would be put before Parliament as a treaty subject to ratification procedures contained in the Constitutional Reform and Governance Act 2010.
Would the Minister give way?
I will give way on that, yes.
I'm grateful to the Minister for those reassurances, because some of us do have marked misgivings about the whole concept of this, which frankly speaks a little bit more of gimmickry than it does of anything that's likely to assist in the real pressures on our prisons. But that said, I can see it might be a tool in the box. But can she help me on 2 specific matters that the Law Society has raised? If the agreements are used, what will be arrangements to ensure that prisoners are able to access legal advice in a proper way? Perhaps in relation to appeal or other proceedings. That is essential to ensure a fair approach, and also are able to participate remotely if necessary in any ongoing legal proceedings. And secondly, what is to be done about family visits? Because, as the Minister will know, the retention of family ties is particularly important and recognised universally as being one of the key factors in rehabilitation and preventing reoffending. We wouldn't want to disrupt those opportunities for anybody being transferred.
Well, I thank my honourable and learned friend for his very sensible intervention. Which engaged 2 issues: Article 6 considerations, the right to a fair trial, and Article 8 considerations, the right to respect for private and family life. We are keenly aware of those obligations. I'm sorry I can't give him more detail on this. Only the extra reassurance that the Lord Chancellor has insisted that they will retain all their rights under the Convention. These will be principal considerations, and I could ask the Lord Chancellor to write to him actually to perhaps flesh out some of those responses. In closing, Mr Deputy Speaker, I want to thank all members on... Yes, of course, yes.
Well, apologies to my honourable friend who's given a very wide-ranging opening speech, but there's just one more issue I wanted to press her on, and that is the issue of spiking. And firstly, I'd like to thank her for recognising the importance of creating an offence to cover this. We had a spate of spiking attacks in Nottingham, and the stories from the young people affected were really chilling. I'm just seeking her reassurance that we will create the most robust possible legislation in this area, and in particular that she'll be looking kindly on the amendments tabled by my honourable friend, the member for Gloucester, who has led a fantastic campaign to get this recognised in law, because it is so important that we cover all the intentions somebody might have when they set about spiking someone, even if that intention is just that they thought it might be a bit of fun, because it's certainly not fun for their victims, and it's really important that we don't create a loophole where offenders might be able to wriggle off the hook.
I thank my honourable friend for her intervention, and I hope I can provide her and also the member for Chelmsford and, of course, the honourable member for Gloucester too with a bit of reassurance on this. So the offence is drafted so that actually I think it covers all possible outcomes. We've looked very carefully at the wording, and I want to provide one specific bit of reassurance because she mentioned attempt, and that was something that the honourable member I know is very concerned about, and it is in his amendment. It's not necessary to put on the face of this bill a separate offence of attempting to spike, because it is captured as an inchoate offence under Section 1, subsection 4 of the Criminal Offence Act 1981, which covers all forms of attempt of a crime that is on the statute book. So I hope that provides her with some reassurance on this. Mr Deputy Speaker, can I thank members on all sides of the House for their engagement in this bill, their joint commitment to its successful development as legislation that enhances our criminal justice system, delivers robust protection, appropriate penalties and a better framework of justice for the public. I believe our government amendments achieve this, and I will respond in due course to the views of members. I commend these amendments to the House.
Question is that new clause 86 be read a second time. Opposition front bench, Alex Norris.
Thank you very much, Mr Deputy Speaker. Well, we've finally got here, 18 weeks since the committee stage was completed. I know the government are running scared, but not just of us on these benches, but their own members too. But we very much welcome the huge piles of concessions made and the clauses withdrawn. And credit goes across the benches for holding the government to account. Surely this bill must be one of the best examples ever of how not to create new legislation, with dozens of government amendments at committee stage and now dozens more for report stage, as well as many new clauses from ministers. By Friday evening there were as many as 70 pages of them from the government alone. I will.
The honourable gentleman's point, because he seems to be suggesting that the government front bench shouldn't be listening to cases made by people on both sides of the House.
Well, I mean, it's to the government's credit that they have listened to people across the piece. However, there are huge numbers of clauses and new ideas that have been brought forward by the government which weren't originally actually tabled even for committee stage or even mentioned at second reading stage either. As my honourable friend, the member for Limehouse and Poplar said, this is not the way for us to do business. But I'll now move to address the many new clauses and amendments from the government, those in my name and my partner in crime here, the honourable member for Birmingham Ladywood, and others. So starting with Amendment 56, in the name of my honourable friend, the member for Nottingham North, and Government New Clause 86. The creation of deepfake pornography is a modern phenomenon. I always found that word difficult, but one with a very traditional intent to cause humiliation and distress, to cause public embarrassment, to weaken the victim's relationships. It is right that as the technology becomes more sophisticated, so do legal protections. At second reading and committee stage, we welcome the bill's provisions relating to intimate photographs or films and voyeurism. Sexual offending in the online and digital world continues to grow at a terrifying pace. The rise in deep fakes is concerning for a variety of reasons, not least the impact they have on political debate and the spread of false information. I have also been horrified by reports of their use to sexually harass and humiliate individuals. The exponential rise in the use of explicit deepfake images demands urgent legislative action, and creating an explicit deepfake without someone's consent is a deeply violating act, one that causes victims to feel embarrassed, alarmed and unsafe. I also commend my honourable member for Luton North for her work on New Clause 43. It would create an offence of creating or sharing misleading content. Such content can reach a wide audience in a short space of time, with questions over legitimacy coming far too late. The harm has already been done. My honourable friend recognises the impact that abuse of this technology is having on our democracy. As we said in committee, we felt that there was a gap relating to faked imagery, which had similar to, or the same intent as the real image, and felt that possible victims ought to have similar protections. We were disappointed that the government knocked this back at committee stage, but we welcome that they have now tabled their own version at this point, with Government New Clause 86, which of course we will support. We also welcome... Sure.
Sorry, the honourable member for giving way. In terms of New Clause 86, does he not share the concern of many women outside of this place with regards to the almost backward step the government has taken by not focusing in on a base offence of people giving consent to their images being used? I thought we'd won that argument, and it now seems to have evaporated. That was central to the online safety bill. Why is he not pressing for that change, as others are outside of this place?
The honourable member makes a strong point, and I think it's up to the government to respond to that. But we do believe that we should be extending all protections to women in all circumstances. Now, we welcome Amendment 160 in the name of the Chair of the Women and Equalities Committee, the Right Honourable Member for Romsey and Southampton North. The Online Safety Bill made significant progress on the matter of intimate image abuse and revenge porn. This is an abhorrent crime, and it is right that we continue the good work done then with further provisions in this bill too. We therefore support Amendment 160 to treat the non-consensual intimate photograph or films as a priority offence under the Online Safety Act 2023. This will ensure this heinous practice is treated seriously and dealt with proactively to ensure the harm that it causes is reduced. Turning to New Clause 87, the manslaughter sexual conduct aggravating factor makes the fact that an offence of manslaughter involves sexual conduct an aggravating factor, as well as making the same provision as regards the corresponding service offence. The government had support from across the House when it restated into statute that a person is unable to consent to the infliction of harm that results in actual bodily harm or their own death for the purposes of obtaining sexual gratification in the Domestic Abuse Bill 2021. So it will not surprise the government to have the support of these benches in relation to this measure as well. We are all aware of the high-profile cases in which women have been killed in the context of consensual or allegedly consensual sadomasochistic acts of violence during sex. We share the government's ambition to do more in recognition of the serious public concerns about these horrific cases. Amendment 57 in my own name would ensure the court satisfies itself that staff would not be put at risk when ordering a defendant to attend sentencing, while Government Amendments 149 and 150 lower the threshold for the availability of the new power to order an offender to attend a sentencing hearing, so that it applies in relation to offences that are punishable with imprisonment for 14 years or more. Clause 28 comes in the wake of a dismaying trend in high-profile criminals opting not to attend their sentencing hearings. Former neonatal nurse Lucy Letby did so in August last year. She refused to attend her own sentencing hearing for the murders of 7 babies and the attempted murders of another 6 entrusted to her care. Having also refused to attend via video link, she remained in the cells below Manchester Crown Court as bereaved family members delivered victim personal statements, and the judge passed the whole life order in her absence. In April last year, Thomas Cashman had exploited the same procedural rule by refusing to attend his own sentencing hearing. He travelled to Manchester Crown Court but declined to leave his cell, claiming that he had been provoked by court officials. He received a sentence of life imprisonment with a minimum term of 42 years for the fatal shooting of 9-year-old Olivia Pratt-Corbell in her own home. We share the view that wherever possible, defendants ought to hear the victim impact statements setting out how victims and families have been affected by their crime. In committee, the Minister, the Honourable Member for Newbury, accepted that the judge now has discretion to make such an order, but said they found that it is not evenly or always applied. As in the case of Lucy Letby, the judge did not compel her attendance. The Minister said by putting the measure in the bill, there will be a power in statute for a judge to order a person to compel them to attend their sentencing for any serious offence where the maximum is a life sentence. The Government's pages of amendments include those to Clause 28, and we are supportive of all efforts to improve the bill's workability. Our Amendment 57 would ensure the Court satisfies itself that staff would not be put at risk when ordering a defendant to attend sentencing. I raised in committee that there was nothing in the Government's explanatory notes about the resources needed to deliver the policy. Likewise, there was little, if anything, about how the staff who will be at the sharp end of delivering a defendant to court will be protected. The charity Justice previously raised concerns with me that this policy puts staff at risk. This is questionable whether the discretion of use of force in proposed clause 41b4 is real or merely apparent in view of subsection 6. I will.
The Minister for giving way, and I have a lot of sympathy with the points that he makes, because we do accept that it's right that there should be a power. I think we all agree that to prevent vile offenders showing cowardly behaviour, not facing up to the relatives and hearing their sentence in person. But there is a concern he rightly raises, both with the Prison Officers Association, and we know prison officers already, of course, put their lives on the line every day with their jobs because they could be subject to violence going about their work in prisons. But there's a particular concern that very often, now we're extending it to a wider range of offences, very often the people who are bringing the people to court and may be charged with this may be contractors, sometimes Circa or people like that. They may not have the experience or the training at the present time to be able to deal with these rather difficult situations. That's perhaps all the more important. There's proper consultation with the workforce that's actually going to be at the sharp end, as he rightly says.
Indeed, that's very much the case, and a few paragraphs down in my speech I will address that very specifically, as I did in committee. The subsection provides that a person is to be treated as having complied with an order under subsection 2 if they've done all that they reasonably can to secure that the offender is produced before the court for the sentencing hearing. Given that subsection 4 provides the authority to use reasonable force, failure to use such force when it is available arguably places those responsible for securing production at risk of being held in contempt themselves for failing to comply with a court order. Prison governors and custody officers are accordingly placed in an invidious position. In her letter to me dated March the 1st, the Minister, the Honourable Member for Newbury, said, "Prison officers and prison escort and custody service staff are trained in control and restraint techniques, and we would expect them to use skills to enforce a lawfully given order that an offender should attend court. Further guidance, training and, if required, personal protective equipment will be provided to ensure that prison and escort staff are fully supported to affect such court orders. The security and safety of prisoners," said the Minister, "and the well-being of prison officers will remain a priority." Now, when first considering this clause, I made inquiries about how reasonable force is currently used by prison officers to deliver a defendant to court. It came as a surprise to learn that this involves 3 prison officers in full riot gear, including overalls, gloves, steel-toed boots, helmets and shields, approaching the prisoner, securing them and getting them into the transport vehicle. Their job is then complete and responsibility passes to the private security firm staff to deliver the defendant to the court. Unlike the prison officers, neither private security staff nor receiving court staff are equipped with either the personal protective equipment or the training to transfer the defendant first into the court cell and then to the dock. And this is exactly the point being raised by the chair of the Select Committee. So I want to raise again with the Minister the question of whether this clause will ensure all staff involved in producing a prisoner at their sentencing hearing are protected from the cells all the way to the dock, and probably within the dock as well. I bring this amendment back in lieu of clarity from the Minister, thus far from how it would work in practice. I want to understand how it will work in practice and would welcome her further comments. Amendment 58 would introduce exclusions on the type of prisoner that could be issued with a warrant to serve their sentence in a foreign country. It excludes people with less than 6 months to serve, those serving indeterminate sentences for public protection, and those who need to be detained in the UK for education training purposes or for legal proceedings, for example, parole. And I accept what the Minister said when she made her own speech. Now, I raised at committee stage the failure of the bill and accompanying notes to provide the detail of exactly how the scheme to transfer prisoners abroad will work, who the partner countries will be, nor where their responsibilities will actually lie. When I raised this amendment in committee, the Minister's response was that the amendment raises sensible points, but the Government, as she said, believed that they are best addressed through policy based on expertise from within the prison system, not set out in primary legislation. The Minister also stated it was her understanding that no prisoners would be moved to countries not covered by the ECHR, and I welcome what she said today. She also referred to me and she said I had asked about the availability of legal advice. And first of all, the whole landscape of court procedure, she said, has changed in the last few years. Receiving legal advice can be done remotely, and court proceedings often take place remotely via a live link. That's supposed to mitigate the fact that somebody's in a cell abroad. Now, the Minister was also at pains to point out that 10% of prisoners are foreign nationals, and so family and primary care considerations are already rather different. Perhaps there's a clue there, Mr Deputy Speaker, that it's foreign offenders and not British nationals the Government really want to send overseas. And the Minister has talked of only 600 prisoners being affected by this policy, and I welcome very much the fact that there will be no women, as the Minister said. Now, I know the Government are negotiating with some countries about where they will go, but we don't have the fine detail that we need in order to understand whether this will be an effective policy. And as the Minister even acknowledged that there is not much detail in the bill, they are developing primary legislation to create the framework for the agreements that have not yet been made. But policy changes all the time, so we need to nail down the provisions in the bill and who will be included and excluded. Amendments 59, 60, 61 and 62 amend Clause 35 relating to the transferring of prisoners to foreign prisons. Amendment 59 would require the Controller to make a report to the Secretary of State of any breaches of the arrangement between the foreign country and the UK. Clause 28 provides for the Secretary of State to appoint a controller role to keep them under review and report on the running of any rented prison spaces abroad. It also extends the power of His Majesty's Chief Inspector of Prisons to inspect and report on the conditions of such places. The bill, however, places a great deal of unaccountable authority in the hands of the Executive to make provision for any arrangements by means of secondary legislation. It is silent on how these subject to this arrangement will be treated. Similarly, it provides no guarantee that the prison rules and secondary legislation which govern crucial issues including segregation, complaints and the use of force would apply. I would hope that the Government would agree that any agreement made between the UK and a foreign state should be subject to full parliamentary scrutiny and oversight. Amendment 59 would help to enable that by requiring the Controller to report any breaches of the arrangement to the Secretary of State. Amendment 60 would ensure that the Prisons Inspectorate must conduct the duties specified in proposed new subsection 5D in section 5A of the Prisons Act 1952 and would ensure its consistency with the legislative basis for its role in England and Wales. We are concerned that the oversight of both the Controller and His Majesty's Inspectorate of Prisons will ultimately be subject to negotiation with a relevant partner country. The wording in the bill relating to the powers of His Majesty's Inspectorate of Prisons differs from the Prisons Act in that it states the Chief Inspector may inspect rather than shall inspect. The implication is that inspections could take place only by invitation of the foreign state rather than by a statutory requirement. That leaves open to future negotiation crucial aspects of HMIP's role and methodology, such as its ability to conduct unannounced inspections, to speak to prisoners in private, and to access records, such as those relating to the use of force. This would mean a lower standard of independent scrutiny would be applied to the treatment and conditions for UK prisoners held under such arrangements. Amending the bill to ensure the HMIP's role can be performed in accordance with its duties under OPCAT would provide an important safeguard to ensure rigorous independent scrutiny. Amendment 61 would ensure that HM inspectors of prisons can inspect escort arrangements under which prisoners are transferred to foreign prisons. Clause 28 specifies that the Chief Inspector may inspect or arrange for the inspection of any prisons where prisoners are detained under an arrangement between the UK and a foreign state. The Inspector's powers to inspect escort arrangements were made by amendments to the Prisons Act in Section 46 of the Immigration, Asylum and Nationality Act 2006. It is particularly important that the Inspectorate should also be able to inspect the escort arrangements for the transfer of UK prisoners to foreign prisons. Our amendment would bring the legislation into line with the Inspector's powers in relation to prisons in England and Wales by also enabling it to inspect or arrange for the inspection of escort arrangements. A foreign state with which the UK makes an agreement could potentially be many thousands of miles from the UK. The transfer of prisoners could involve a lengthy journey, including a variety of modes of transport, including potentially prison vans, planes, trains and ferries. The potential for trouble appears limitless. The probing Amendment 62 seeks to clarify how the Government intend to apply their obligations under Article 2 of the Right to Life of the Human Rights Act, under the Human Rights Act, through ensuring that the duties of the coroner also apply to any death involving a prisoner subject to a transfer agreement with a foreign country. It is our view that the nature of the arrangement to send individuals to overseas prisons will establish the UK's jurisdiction over any deaths that occur. Given the unprecedented nature of these arrangements, it is crucial that the responsibility of coroners to investigate overseas deaths be established clearly in advance. To do so otherwise would invite significant uncertainty and likely legal challenges if any individual were to die while imprisoned overseas. New Clause 2, in the name of my right honourable friend, the member for Camberwell and Peckham, who can't be with us today after a fall, and I'm sure everyone here will want to send her their best wishes for a speedy recovery. Her clause addresses parental responsibility for men convicted of sexual offences against children, whilst the Government's new Clause 103 falls short of that, in that those offenders captured by the clause would be restricted to those sentenced for the rape of a child. They address the same key issues. How can an individual be considered too dangerous to work with or be around other people's children, yet be allowed to have responsibility over a child's life so long as that child is their own? I am glad to see that the Minister has taken away some of the concerns that were raised in relation to this issue during the committee stage, and that the Government has, in responding with new Clause 103, which goes some way in the right direction on this issue raised by my right honourable friend. I'm not so sure that she has totally accepted the explanations offered to her so far in this regard. As I said, my right honourable friend can't be here today, but I wanted to pay tribute on her behalf, not just to the ministers and the BBC's Sanchia Berge, but also to the bravery and persistence of Bethan's family, who fought to protect not only their own child, but everyone else's as well. I would be interested to hear the Minister's explanation for restricting the provisions to those who have been convicted of rape of a child only. There was some discussion in committee about the wideness of the scope of including all sex offences in such a provision. However, it seems to me that the Government has gone too far in the other direction, albeit making a concession. Only including those convicted of a rape of a child is a narrow scope, and as such will leave the scope for men who have been convicted of other very serious sex offences against children in control of important aspects of their children's lives. It very much begs the question, why should any child be subject to any form of control by a convicted child sex offender who is unlikely to be part of their lives for years ahead and possibly forever? New Clause 7, in the name of the Right Honourable Member for Chingford and Woodford Green, and the Government's new Clauses 94 and 95 and new Schedule 4, makes it an offence to exercise control of another person's residence for the purpose of criminal activity by means of coercion, threats or abuse of a position of vulnerability. In committee, I proposed this new clause that would make cuckooing a specific offence. I am pleased not only that the amendment has since been tabled in the name of the Right Honourable Member for Chingford and Woodford Green, but subsequently that the Government saw sense and followed suit. As has been clear in the committee's discussion on cuckooing, the level of harm caused by cuckooing is very substantial, so I am keen to hear the Minister's thoughts on that matter. I do, however, remain supportive of new clauses 94 and 95 and new Schedule 4, which together create the offence of exercising control over another person's dwelling for the purpose of enabling it to be used in connection with the commission of certain offences. When I moved the amendment, the new clause in committee, I received support from the Police Superintendents Association. It said, there is a clear need for legislation of this kind, with evidence showing that cuckooing is a widely used tactic in many serious offences, including those linked to serious and organised crime, such as county lines, drug supply and human trafficking. Cuckooing is a terrifying experience for the vulnerable adults who are targeted by these criminals. I do not think that any of us can comprehend what it would mean to have our home taken over in such a way. I suspect there's not a member here who doesn't know a vulnerable adult in their constituency or someone who lives alone who could be targeted by such unscrupulous criminals. Police do work with local authorities to deliver a safeguarding response for victims of cuckooing. For example, the Metropolitan Police Service has dedicated cuckooing officers who work with partners to safeguard victims and divert them from the criminal justice system. However, it's not defined in legislation and is not a specific offence. So today's news from the government, or the amendments put down by the government, are actually very, very welcome. My honourable friend, the member for Swansea East, raises the issues of profiteering from prostitution. New Clause 8, as she did in committee. She explained that this would enact the recommendation of the Cross-Party Home Affairs Select Committee to make it a criminal offence to facilitate or profit from the prostitution of another person online or offline. There are clearly gaps in provision if our laws mean it is illegal to pimp offline but not online. I note that in her response at committee, the Minister suggested that the clauses drafted would also prevent individuals who lawfully sell sex from doing so online where they feel safe, and as a result these individuals may be forced then into additional danger by having to advertise on the street or underground in some way. I certainly recognise the Minister's concerns. Any provision must ensure that those who it is intended to protect do not actually and inadvertently come to additional harm. I am, however, sceptical about her claims that the measures included in the Online Safety Act, whereby online platforms for individual advertising are responsible and accountable for the content on their sites, will do as much as she claims in addressing these issues. New Clause 9, in the name of the Honourable Member for Bishop Auckland, is intended to create a specific offence of one-punch manslaughter with a minimum sentence of 7 years. My honourable friend, the member for Birmingham Yardley, moved this clause at committee, but it wasn't pushed to a vote. We, however, commend the honourable member for Bishop Auckland for her efforts on this, and understand she continues her discussions with ministers, and we hope there has progress been made behind the scenes. New Clause 12, dealing with controlling or coercive behaviour by persons providing psychotherapy or counselling services, is an interesting clause in its own right. And there was a good discussion on the content of the clause in the other place when the provisions were tabled as an amendment to what is now the Domestic Abuse Act. The clause aims to address controlling and coercive behaviour effected by charlatan therapists that can have ruinous consequences on the lives of their clients. Clearly, any instance of such manipulation and abuse is deeply concerning, especially given the trusted role psychotherapists and counsellors are put in by their clients, who often engage their services when they're in a particularly vulnerable place. I'm interested to hear the Government's thoughts on the scale of the issue and what other measures may be implemented to address this problem. There was a suggestion in the debate on the Domestic Abuse Act that regulation and accreditation would be the appropriate response, although several members pointed out that charlatans don't tend to go through with the effort of accreditation. Nonetheless, I am concerned by the reports of individuals, often young women, being harmed by such practices, and am keen to hear from the Government on how it may be addressed. With reference to New Clause 16, in the name of my honourable friend, the member for Merthyr, Tidwell and Rhymney, I know he is in his place today and can speak to the tragic case in his constituency that this Clause 16 seeks to address, and I want to reiterate what we said at committee stage. The Road Traffic Act 1998 provides vital protections to all of us. It bars certain behaviours that we know are dangerous. It is a loophole that those sort of behaviours can be exhibited on private property without sanction. It is reasonable to bring into alignment the RTA 1998 laws with respect to private property in the interests of public safety. In committee stage, the government seemed to be of a similar mind. However, it has been one of the few areas that they haven't proposed their own version of today. We hope the Minister will signal their intent to do so at a later stage, or if not, will accept my honourable friend's version, which we support. In addition to this, there are new clauses 35 and 36 in the name of my honourable friend, the member for Bootle. He made a strong case for these new clauses at committee, and I hope the government have had the chance to reflect on his proposals and respond to them positively. Turning to new clauses 18 and 19 in the name of my honourable friend, the member for Nottingham North. Together, these new clauses would update Section 1 of the 1990 Act, which prohibits unauthorised access to computers. Simply put, the current legislation inadvertently criminalises a large proportion of legitimate vulnerability, security and threat intelligence research by UK cybersecurity professionals who are committing a crime if they use legitimate techniques to check for vulnerabilities, to carry out research or to build defences. We are asking them to put themselves at risk in order to do something that is clearly a social good, so the new clauses would seek to update the Act. In the UK alone, there was a 77% increase in cyber threats last year. We know that their impact on individuals' lives can be hugely consequential, but the legislation that provides the foundation to take on that sort of cyber threat is more than 33 years old. Legislation has not kept pace with modern cybersecurity defence techniques, so it is vital that we take the opportunity to act now and update the law accordingly. New clauses 18 and 19 will do this. In a similar vein, new clause 38 also seeks to update the statute book to ensure the law keeps pace with change, this time in relation to liability for corporate offences. The new clause also in the name of my honourable friend, the member for Nottingham North, and he pays tribute to our honourable friend, the member for Barking, for her continued campaigning on this matter. New clause 38 introduces individual liability so that senior executives can be held liable for criminal activities committed by a company or partnership on the basis of negligence. This offence applies both to crimes committed by the company or partnership and to a failure to prevent these crimes from happening. The UK has a serious accountability gap when it comes to senior executives. Despite corporate scandals and failures such as the miscarriage of justice at the post office and water companies illegally discharging sewage into our rivers, too often those at the helm of large companies that engage in such wrongdoing rarely face any consequence at all. This leads to poorer corporate governance standards and greater risk that the huge costs of corporate failure and misconduct are borne by ordinary people. It is also unfair directors in the smaller business sector tend to face the vast brunt of prosecutorial and regulatory action. Regulatory fines alone are not sufficient to drive real behavioural change. Without holding the senior executives at these companies criminally liable, fines become a cost of doing business rather than a deterrent to bad behaviour. We need to reform the law so we can hold senior executives criminally liable for deliberately turning a blind eye or creating a culture of misconduct and lower the risk of further corporate failures. New clause 38 makes this change. New clause 25, the offence of possession of guidance on creating child sexual abuse content, and new clause 26, offence of simulating sexual communication with a child. Now, the honourable member for Chelmsford, new clause 25, would expand the existing offence of possessing guides about abusing children sexually to include guides on creating child sexual abuse content, including through the use of artificial intelligence or machine learning, whilst our new clause 26 would create an offence of using, creating or sharing online or digital tools which simulate sexual communication with a child. Now, we know that the increased presence of children on the... We know that the increased online presence of children in the latest technological developments create new opportunities for abuse. Ofcom agrees the sexual exploitation and abuse of children online is a persistent and growing threat with devastating consequences for those affected. New risks are emerging as the way we interact online continues to evolve, including through extended reality, end-to-end encryption and generative AI. In a BBC report, makers of child sexual abuse images were found to be using AI software called Stable Diffusion, which was intended to generate images for use in art or graphic design. But the BBC has found it is being used to create lifelike images of child sexual abuse, including of the rape of babies and toddlers. Under Article 34 of the United Nations Convention on the Rights of the Child, that states parties have an obligation to protect children from all forms of sexual exploitation and abuse. The criminalisation of online sexual exploitation and abuse forms part of a state's party's obligation to protect children under Article 34 of the CRC. In General Comment number 25/2021, the CRC Committee affirms this by calling upon states parties to put appropriate legislation in place to protect children from the crimes that occur in the digital environment and to allocate sufficient resources to ensure that crimes in the digital environment are investigated and prosecuted, which includes online child sexual exploitation and abuse offences. Under international standards, legislation concerning child sexual abuse material should be introduced or amended to incorporate technology-specific terminology and specifically capture child sexual abuse material available online. It says child sexual abuse material includes live performances and arguably computer-generated child sexual abuse material, which are images that have been created with the purpose of conveying the impression that they depict children. I will refer to a recent report by the International Watch Foundation entitled How AI is being Abused to Create Child Sexual Abuse Imagery, in which the IWF recommends the Ministry of Justice to commission a review of the laws that apply to the removal of this content online to ensure they are fit for purpose to tackle the threat of AI CSAM. This includes ensuring the exchange of hints and tips and paedophile manuals on how to generate this content are made illegal. In oral evidence to the House of Lords Communications and Digital Committee, Iain Hogarth, chair of the UK's AI Foundation Model Task Force, spoke of how some of the open-source image generation models have now been fine-tuned by malicious actors to generate child sexual abuse material. These systems are being used for really some of the most heinous things out there. Criminals are finding new ways to harm children. As technology moves forward, it is right that the legislation aimed at protecting children from online harm must move forward with it. New Clause 38 would clarify the definition of joint enterprise or secondary liability so that an individual must make a significant contribution to an offence committed by another to be criminally liable. There have been considerable discussion in the House recently in relation to reforming joint enterprise, including as a result of the tireless campaigning by my honourable friend, the member for Liverpool Riverside, who has been advancing a private member's bill on this issue as well. It seems to me that the consensus from the many discussions that the House is having is that reform is clearly needed. There is no doubt that cases of injustice that have been arisen from the application of joint enterprise law. As my honourable friend, the member for Lewisham East, said in her speech on the Joint Enterprise Significant Contribution Bill that I have just mentioned, it is an important tool in our criminal justice system that has helped to secure convictions that otherwise would not have been successful, including some of the men who killed Stephen Lawrence. It has also been successfully used to prosecute paedophile rings and those who commit economic crime. But the doctrine is certainly in need of reform. Labour has previously stated that it would look to reform joint enterprise, and that remains our ambition. There is, however, ongoing work at the CPS collecting data on joint enterprise prosecution. The initial tranche of data collection revealed matters of huge concern. Black people make up only 4% of the UK population, but according to the CPS, under joint enterprise cases, black defendants make up 30% of caseloads. It was also revealed that joint enterprise prosecutions disproportionately affect young people and children. The data collection has now been expanded into all CPS areas, and to ensure that any reforms made have the best chance of addressing the ongoing issues with the application of the doctrine, it is essential that it's based on a strong evidential base. Once a stronger evidence base has been built up through the CPS data collection, we will be better placed to know how to reform the law to tackle the issues that there is such serious cross-party concern about. This amendment is reasonable and commendable, but it is important that we take action when we take action to reform, we do it right first time. Only a fuller picture provided by robust evidence can ensure that we do that. New Clause 29, in the name of my honourable friend, the member for Swansea East, seeks to align the definition of human trafficking in UK law with that of the UN definition. My honourable friend, the member for Birmingham Yardley, made the case for this new clause well at committee and highlighted the lack of convictions under the current framework. I hope the Minister can set out what the Government intend to do to rectify this. New Clause 32 would include offences motivated by hostility towards an individual's disability status, sexual orientation or transgender identity or perception thereof in those which are aggravated under the Crime and Disorder Act 1998. We are in support of this amendment in the name of the Honourable Member for Carshalton and Wallington, all the more so as it is identical to the new clause I tabled at committee, and it is Labour Party policy. This amendment would address the disparity between existing characteristics and current hate crime legislation. It would create a parity for maximum possible penalties for all 5 characteristics defined under the Sentencing Code. Under current hate crime legislation, hate crimes based on race and or religion can have higher maximum penalties than their base equivalents, whereas hate crimes based on sexual orientation, transgender identity and or disability cannot. This creates a 2-tier system of justice. The Law Commission's recommendations that offences motivated by hostility towards an individual's disability status, sexual orientation or transgender identity should be encompassed within the aggravated offences under the Crime and Disorder Act 1998. New Clause 32 comes in the context of soaring levels of hate crime reporting. Over 145,000 cases were reported in 2022-23. Across all monitored strands of hate crime, the numbers of offences have soared since 2011-12. Racially motivated hate crime rose by over 200% in the period, topping 100,000 instances for the first time in 2021-22. Meanwhile, the hate crime motivated by religion increased by a massive 433%. By sexual orientation, it has increased by 493%, and by transgender identity, it has increased by 1,263%. Violent crime or crimes against the person rose as a proportion of hate crime offences from 29% in 2012-13 to 41% 22-23. The number of violent hate crimes has risen sixfold from 12,739 to 63,895 in 2022. LGBT plus people and people with disability should be able to live their lives free from fear, abuse or violence. Labour is committed to take back our streets and be tough on hate crime. We will do so by strengthening and equalising the law so that every category of hate crime is treated as an aggravated offence, to ensure that everyone who falls victim to a hate crime is treated equally under the law. I hope that the Government will support New Clause 51. The Minister said in committee the Government intend to publish later this year a full response that will address each recommendation of the Law Commission's report, and that it would be premature to make decisions before the formal Government response is published. I would, however, urge the Honourable Member for Carshalton and Wallington to stick with his new clause, and we would see it move to a vote if not accepted by the Government. It is always a pleasure to speak to my honourable friend, the member for Yardley's, Birmingham Yardley's amendments. Her tireless mission to stand up for victims in all forms is respected across this House, and I think she's still due a huge number of answers from the ministers relating to her amendments, which have been retabled. New Clause 44 would amend the Sexual Offences Act 2003, specifically in sections 52 and 53, to replace prostitution for gain with sexual exploitation of an adult. The reason for doing so ultimately lies with shifting perceptions. Adult sexual exploitation is a form of sexual abuse that is poorly understood and rarely recognised across many sectors. Victims of adult sexual exploitation are falsely identified as consensually engaging in sex work, and the labelling of that abuse as prostitution in law only serves to perpetuate it. That mislabelling has led to countless people across the UK falling through the gaps and not receiving necessary support as their experiences are not recognised. New clauses 45 and 46 would address the gap in law that can lead to unjust stigmatisation and criminalisation of victims of sexual exploitation. This would do so by decriminalising conduct falling within Section 1.1 of the Street Offences Act 1959, in other words, street prostitution offences, and establishing through the bill a mechanism to expunge criminal records for street prostitution offences. I look forward to the Minister's response on that. New Clause 47 would make an aggravating factor of grooming in certain adult cases, including around domestic and sexual abuse. My honourable friend moved her new clause in committee and spoke of how little is understood around grooming of adults, despite there being considerable overlap of perpetrators and perpetrator behaviours and tactics of those seen in cases of child sexual grooming. Grooming is a deliberate process of limiting the freedoms of a person by gaining control over them and creating a dependency. It is widespread and prevalent in every part of the UK and is underrepresented in UK legislation. It seems sensible to seek to include adult grooming victims on the same footing as children. I do not feel the Minister, the Honourable Member for Newbury, addressed this point adequately in committee, which is why I feel it is important to invite further comment today. New Clause 48 would classify strangulation as an aggravating factor in sentencing murders. It follows new laws on non-fatal strangulation which were introduced under the Domestic Abuse Act 2021. My honourable friend raised in committee that common understanding of the role of strangulation in domestic abuse is changing. It is now understood as a form of coercive control and an accurate red flag predictor of homicide. It is clear there is a need for a review in this area and to look holistically at sentencing rather than attempting to amend the criminal justice system based on piecemeal changes. Now to new clause 49 and 50. The Charity Centre for Women's Justice say the bill does not address the gaps in law and practice that can lead to the unjust criminalisation of victims of domestic abuse and other forms of violence against women and girls and exploitation. New clause 59 would amend the law on self-defence and is modelled on the provisions for householders in Section 76 of the Criminal Justice and Immigration Act 2008. This would allow survivors acting in self-defence against their abusers the same protection as householders defending themselves against an intruder. In other words, the self-defence proposal. New Clause 50 and Schedule 1 would introduce a statutory defence for survivors modelled on Section 45 of the Modern Slavery Act 2015. This would give survivors of domestic abuse similar protection to victims of trafficking who are compelled to offend under the Section 45 proposal. Research by CWJ and others have made clear that law reform is needed to address the difficulty faced by victims of domestic abuse in establishing reasonableness and proportionality when accused of using force in these circumstances. Again, I would welcome the Minister's contribution on my friend, the member for Birmingham Yardley's new clauses to the bill, in which he seeks to improve the law for victims. New Clause 55, the offence of child criminal exploitation. Now, there have been numerous calls to do more legislatively to address child criminal exploitation, including by creating a statutory definition over the course of this Parliament. I recall my honourable friend, the member for Rotherham, speaking powerfully on these issues back in our committee sessions on the Police Crime, Courts and Sentencing Bill. Honourable members on this side of the House have been pursuing the issue again through the Victims and Prisoners Bill. It is clear that reform is needed to tackle the appalling scale of child criminal exploitation. Research carried out by the Children's Commissioner found that 27,000 children who were at high risk of gang exploitation had not been identified by services and consequently were missing out on vital support to keep them safe. The research found an even higher number of children who were experiencing broader risk factors linked to exploitation, with 1 in 15 teenagers falling through the gaps in education and social care. Thousands of children are being criminally exploited, and this demands more of a response from the government. Well-reasoned amendments have been made to a number of government bills in recent years, as I have just outlined, and indeed as this amendment in the name of my honourable member from Moyle Valley demonstrates, they are coming from across the House. So what will it take for the government to engage constructively with members who are deeply concerned about the issue and the dangers that are facing our young constituents? I should engage more constructively. New Clause 57 is an interesting clause, and given the increase in e-bikes and cycling in general, we recognise the need for some change in this area of law. That said, we are keen to understand exactly how the provisions of the clause would work, the impact they would have, and the number of potential cases which are likely to be created. We are not sure that the clause is fit for purpose, so we will also be interested to hear from the Minister, but we are satisfied that it is an area in which we would wish to legislate after the general election, given our success. Turning now to the serious issues raised in New Clause 59 by my honourable friend, the member for Nottingham North, in relation to knife crime. Knife crime destroys lives, devastates families and creates fear and trauma in communities. Many of us will have constituents deeply impacted by knife crime. Sadly, the situation is getting worse, not better. The latest statistics show knife crime up again in the past year. It is now 80% higher than in 2015. The opposition have always been clear that we will work with the government on this matter so we can take dangerous weapons off the streets and save lives. It is in this spirit that my honourable friend tabled this new Clause 59, which proposes a ban on ninja swords. Many will be quite frankly shocked that such weapons are not banned already. In the wrong hands, these weapons can cause significant harm, and they should be taken off the streets without delay. New Clause 59 would introduce such a ban. Of course, there is a wider point here about the ease with which such weapons are bought and sold, mostly online, and then end up in the hands of young people. New Clause 60 and Amendment 69, also in the name of my honourable friend, the member for Nottingham North, seek to address this point. The prevalence of banned weapons found online marketplaces is shocking and must be tackled. Yet there seems to be no accountability for this. We need tougher criminal sanctions on the senior tech executives who allow such knife sales on their online marketplaces. New Clause 60 would introduce such sanctions. More likely, we need a complete end-to-end review of online knife sales from the point of purchase through to delivery, and particularly to strengthen ID checks and checks conducted by Royal Mail and Border Force for UK-bound parcels. Unfortunately, we're seeing too many gaps and loopholes in efforts to tackle knife crime. We need to identify them and deal with them before they're exploited further. Amendment 69 will place a duty on the Secretary of State to conduct such a review and begin this process. Taken together, new clauses 59 and 60 and Amendment 69 form part of Labour's plan to tackle the scourge of knife crime on the streets. As I've said already, the opposition will work with the government on this issue. Young lives depend on it, and I hope we can make progress on this soon. I now turn to new clauses 91 and 92 in the name of the honourable member for Westmorland and Lonsdale, which create an offence of failing to meet pollution performance commitment levels for water quality and individual senior management responsibility. And I spoke of this earlier in my speech as well. It is Labour policy to bring forward legislation to strengthen the law in this area. We would put the water companies under special measures, strengthen regulations so law-breaking water bosses face criminal charges, and we'll give the regulator new power to block the payment of bonuses until water bosses have cleaned up their filth. We would also end self-monitoring, force all companies to monitor every single water outlet so companies can no longer cover up illegal sewage dumping, and introduce severe and automatic fines that no water bosses can ignore for illegal sewage discharges. These new clauses, however, we feel are too narrow, but we would legislate in government. In conclusion, Mr Deputy Speaker, I would like to pose a few questions to the Minister. What impact will the provisions of this bill have on the criminal justice system and in particular our crisis-hit prison service? As I said at the outset, many of the government's own new clauses and amendments didn't come until a few days before today's report stage. What impact assessment has been carried out and when can we expect to see it? May I just remind the Government that we're still waiting on the economic impact assessment for the Police Crime Sentencing and Courts Act, which received royal assent 2 years ago. And finally, again, addressing the prison crisis. Some of the proposed sentences in this bill are numbered in months. How does that sit with the Government's position on the presumption against short sentences and its current policy of giving a whole host of prisoners up to 70 days off their sentences so they can make way for new ones? Clearly, Mr Deputy Speaker, ministers have a balancing act to perform, but it's clear that despite the merits of some of the clauses in this bill, they're creating more problems without solutions further down the system. But we look forward to the bill progressing and to day 2 of the proceedings, assuming, of course, that will actually come before the general election.
Yeah. Well done. Order. Before we proceed, I'd like to make a couple of observations. These are very serious and sensitive issues, and they deserve and are clearly going to get proper debate. The honourable gentleman in his closing remarks indicated that there are 2 days of this debate. Earlier, an honourable member intervened on the Minister to raise a subject that she had not commented upon. There's a very good reason for that. It's not listed on the order paper for today. It's listed on the order paper for the second day. Could I ask honourable members to make quite sure that when they are discussing these issues, they are discussing those that are on the order paper for today, and the understanding there will be a second day. There are 18 honourable members, I think, I may have missed one, there may be more, wishing to stand. Now, at the moment, we have plenty of time, but could I gently urge conciseness rather than self-indulgence, and that relates particularly to interventions, which should be interventions and not speeches. Caroline Nokes.
Mr Deputy Speaker, I rise to speak to Amendment 160, tabled in my name and supported by members of the Women and Equalities Select Committee and other colleagues across this House. I will endeavour to be as brief as I can and can reassure everybody that it is on the order paper for today. But before I move on to that, can I just thank my honourable friend the Minister for her comments around deep fakes. There has been a problem where if you're Taylor Swift, you can get a deep fake made of you taken down very quickly, but if you're an ordinary woman or indeed man from across the UK who is not famous, has no platform, then it is very difficult to get deep fake imagery removed. I really welcome the steps that the government is taking on that. I would also like to thank the Shadow Minister for his comments about this amendment. I wasn't aware that the opposition were planning to support them, so I thank him for that and would urge my honourable friend the Minister to pay close attention to what I and I suspect other members of my Select Committee might say with regard to this amendment. I would also like to apologise to my honourable friend. I recognise that this amendment comes at the 11th hour at report stage, but it is specifically due to the evidence that my Select Committee heard last week, both in private and in public, from victims of revenge porn. I welcome the changes that have been brought in under the Online Safety Act to support victims of non-consensual intimate image abuse, but it is clear from the evidence that we heard that the legislation in its current form simply does not go far enough. It does not give Ofcom the teeth that it needs to effectively tackle the fast-spreading, uncontrollable virus that is non-consensual intimate image abuse. It does not force platforms to remove harmful content in its entirety or require ISPs to block access to it. In short, what it does not do is make the content itself illegal. The sharing of it is illegal, but the content itself, even if there is a criminal conviction, is not regarded as illegal content. So last week, the Women and Equality Select Committee heard from a number of survivors of non-consensual intimate image abuse. In sharing their experiences with us, they have spoken of the catastrophic damage the abuse has had on their lives, their confidence, their relationships. They told us of their fear of applying for jobs, of meeting new people, of daring to have any social media presence at all. But with all their cases, there was a common theme. Even though they had secured a conviction against their perpetrator, their non-consensual content continues to circulate on the internet. despite relentless work by organisations such as the Revenge Porn Helpline to report the content and get it taken down, there is no legal obligation for the platforms to remove it. I give way to my honourable friend from Basingstoke.
Can I thank the Chair of the Select Committee who's making an excellent point, really in support of the point I was making earlier, that if this bill had a consent-based creation offence in it, it would outlaw the very images that the people she's talking about are finding so difficult to get off the internet. Surely this is the opportunity to create that consent-based creation offence rather than the current proposal, which is potentially providing lots of loopholes, particularly to online apps, to use intention as a way of trying to evade the long arm of the law.
Well, I thank my right honourable friend for that intervention, and she makes exactly the point. It should be about consent. And when these images are non-consensual, they therefore should be regarded the same, in my view, as if the individual has been digitally raped. There are also many thousands of cases where a conviction has not been achieved, or even sought, where the victim just wants the content taken down or blocked. They too are being denied that peace of mind due to gaps in the current legislative framework. This amendment calls for non-consensual intimate photographs or film to be added to the list of priority offences in the Online Safety Act, thus making it priority illegal content. This amendment would ensure that non-consensual content, regardless of whether or not a conviction had been achieved, would be, by its non-consensual intimate nature, illegal. It would place duties on platforms to remove it, and it would require internet service providers to block access to non-compliant sites and platforms, including those hosted outside the UK. This is precisely the way in which child sexual abuse material is handled. Children cannot provide consent, and the adults in these images have not provided their consent for them to be taken, shared, or both. So why should the content be treated so differently? Indeed, when my honourable friend, the member for East Renfrewshire, put it to my honourable friend, the Minister, during her recent appearance before my Select Committee, that adult content should be handled in the same way as child sexual abuse material via a registry to identify, classify and therefore allow for the removal of non-consensual intimate images, the Minister said it would be a very good idea. But in order to do that, we need to make the content illegal. It is important to note that intimate imagery does not just refer to photos and videos which are sexually explicit. Indeed, as we heard from David Wright, the Chief Executive of SWGFL, which runs the Revenge Porn Helpline, within certain countries and cultures, being photographed with your arm around somebody or to be filmed without a hijab can have catastrophic implications for a woman. That is why it is so important that any legislative change uses the term intimate, not sexual, when referring to non-consensual content. To bring this back to the evidence we heard last week, and we had in front of the Select Committee Georgia Harrison, who very famously was the victim of revenge porn perpetrated by her then partner Stephen Bear, who later received a criminal conviction for his actions and indeed was sent to prison. Georgia made the point repeatedly that this was like a house fire, that when those images went up, they spread very quickly, and that the solution was to get them taken down as quickly as possible so that they would not proliferate. We as a committee also described it as being like a virus that just spreads out of control. But this can't just be about Georgia Harrison. This cannot just be about famous women with a platform that they can use and make sure that their voice is heard. We also heard from an anonymous victim of Operation Begum. Now, the perpetrator in that case had many thousands of victims. He received a 32-year prison sentence. But let me tell you, that young woman is too afraid to have any sort of social media presence because she's terrified that her image will be seen and will be put through reverse image searches and that she will be identified as a victim, because there are thousands and thousands of the Operation Begum images still proliferating online, and nothing can be done about it because the content itself is not illegal. It remains online. It remains accessible to people in the UK despite that 32-year prison sentence. That simply cannot be right. and we will be letting down the victims of that abuse and all other cases of non-consensual intimate image abuse if we fail to act. The final point I would leave the Minister with is that we also heard about the Criminal Injuries Compensation Authority and the fact that intimate image abuse is simply not on their list as a violent crime. So when applying to the authority, expecting or hoping for some small nugget of compensation, a message in effect that yes, you are a victim, that you can put the blame and shame to one side, that you have been a victim of a criminal act, actually that isn't even there for them. Now, I have no doubt that is because the list of violent criminal offences was dreamt up many moons ago and this simply hasn't been added to it. Well, it simply should be added to it, and the point that I would make, which I referred to earlier, is that for a woman or indeed a man who has had their intimate images put online, circulated freely, proliferated all over the place, that is like digital rape. And it is a rape that continues day after day after day, to be brutally honest, with no end in sight. Those are the reasons why my committee has tabled this amendment, why we would urge members to support it, to give it serious consideration. I hope that my honourable friend the Minister will be able to make some comments from the dispatch box that might indicate how the MOJ could incorporate this into existing law. But if the message coming back to me is that the content is already illegal, it's not, and we have to find better ways of getting it down.
Yeah. Liberal Democrat spokesman Tim Farron.
Thank you, Mr Deputy Speaker. It's a pleasure to serve under your guidance this afternoon. I want to start by saying I also will seek to be brief and will principally speak to the two amendments in my own name, but just a quick run through and to say that I fully support the new clause 86 promoted by the Right Honourable Member for Romsey and Southampton North, and likewise pay tribute to her colleague, the Honourable Member for Bishop Auckland, new clause 9 on one-punch manslaughter, which we also would seek to support. And again, sticking on the Conservative benches, the Honourable Member for Gloucester, amendments 33 to 41, covering the issue of spiking, an incredibly serious issue, a serious offence, and his amendments are ones that we would also seek to support. And to move on to these benches, there are many others I could refer to, but I won't because of time. New clause 35 in the name of the Honourable Member for Bootle, the crime, the offence of failing to stop at a traffic accident and seeking to rectify that and to deal with that loophole to make sure that justice is done in those circumstances. But because of time, I'll just focus, if I may, Mr Deputy Speaker, on the two amendments in my name, new clause 91 and 92. 91 creates the criminal offence of failing to meet pollution performance commitments, and new clause 92 would make senior managers criminally liable for such an offence. I guess if there was any doubt at all that these amendments, these new clauses were needed, they may have been dispelled by a quick look at the news earlier today. We have revealed, and it was only discovered by some of us just yesterday, that earlier this year 10 million litres of raw sewage was dumped into England's largest and most popular lake, Windermere, at the heart of my constituency, our communities in Westmorland. This incident happened for 10 hours. United Utilities did not alert the Environment Agency for 13 hours. The outrageous scale of this brings into question the extent to which the current framework is adequate. This is a personal issue to us. This is a lake which is the centre of the Lake District hospitality and tourism economy, which brings in 20 million visitors every year, the biggest number of visitors to any part of the United Kingdom outside of London. We are proud of that. It is an industry that employs 60,000 people and is worth £3.5 billion when it comes to a local economy, contributing hugely to the national economy. But this is permitted to happen at the heart of the jewel in our crown, of our tourism economy in this country, is an utter outrage. And of course the ecological side of this is also even more utterly appalling. So I think, Mr Deputy Speaker, what this shows and what the revelations of the last day or so have proven is the regulatory framework is utterly and totally broken, and so the call for these new clauses and the creation of a criminal offence in this case and criminal liability is absolutely 100% justified. Of course, the offence that I've just spoken about is just the tip of the iceberg. In 2023 alone, I'll talk principally about my own water company in the northwest of England, United Utilities. That company spilled sewage 97,000 times for almost 700,000 hours. At the River Kent at Kendal, just 2 sites. One of them spilled on 42 occasions, one on 69 occasions. The River Ear at Cark on the Cartmel Peninsula near Grange over Sands, the most egregious example in the whole of the northwest of England, 281 times for 6,471 hours last year. The River Eden at Kirby Stephen, 172 times for 3,225 hours. At Coniston Water, just celebrating being given bathing water status at 4 sites only the other day, to which I paid tribute to Suzanne Pender, the local councillor, and the local parish councils for achieving that really important classification. Nevertheless, 178 times in 2023 on 141 days sewage spilled into the beautiful Coniston water. Across England, across all the water companies in England, 464,000 separate spills in 2023. That was a 54% increase in 2022. The water companies and indeed ministers themselves said, oh, well, that's because it rained more last year. Not 54% more, it didn't. And so these spills are unjustifiable. We're left in a situation where only 14% of England's rivers are in an ecologically good standard, and of all the rivers in England, not one, a fat 0% of England's rivers are at a good chemical standard. So I would say that these amendments are necessary, and the creation of a criminal offence is absolutely called for because the regulatory framework is failing. Regulators repeatedly let the water companies off the hook. The data that they have to work upon is incomplete. Now, ministers will say, and rightly, that until relatively recently there wasn't a right lot of data available at all and monitoring didn't happen. But who does the monitoring? The water companies do the monitoring. They mark their own homework. The Environment Agency, underfunded and the victim of many, many cuts over many years by this government, is only obliged to come out and inspect at a spill site if the water company invites them. How ridiculous, how weak. Ofwat's attempts to tackle egregious acts by the water companies are inadequate. They're too little, they're too late. For instance, Ofwat has dragged its feet to get round to merely consulting on plans to ban bonuses, maybe sometime next year, with the outside possibility that this could come into force. A process that River Action, the excellent campaign organisation, described rightly as far too slow. Again, Ofwat have taken until now to consider fines of up to 10% of water companies' turnover for the worst forms of poor customer service. Why so long? Why only now? The Office of Environmental Protection found that the government was set to miss its 2027 targets to improve the state of England's rivers, lakes and coastal areas by a significant margin. I quote them. In the Liberal Democrats policy paper, which we entitle Are You Drinking What We're Drinking?, the Liberal Democrats propose a new regulator with new powers to issue fines to top executives and to initiate proceedings. But given we are where we are, Mr Deputy Speaker, I would simply ask you to, or this House to consider these two amendments, New Clause 91 and 92, as a crucial way of being able to tackle the most egregious acts of sewage dumping in our lakes, in our rivers and in our coastal waterways. I would say that for those of us in and around the English Lake District, this matter is personal. It is offensive to us. We consider ourselves, if it's not too grand to say this, as custodians of England's Lake District, not protecting them for us, but protecting them for the whole country, for the world, and indeed for posterity, for the generations that come after us, for the people who will make use of the lake, and indeed for the ecology that it supports at the heart of the stunning beauty of the Lake District, which is, after all, a World Heritage Site. For us, this is personal. We are determined to tackle this problem. I want to pay tribute to all of those campaigning, such as Matt Staniak and all the others involved in the Save Windermere campaign and others who are determined to make a difference. But I also want to say that, for example, citizen science projects that are going on the River Kent and the River Eden are equally important, more low-key, but absolutely vital to trying to get to the heart of this problem. But all the data in the world will not solve this problem if we do not have the laws to prevent them and to hold people to account. So in conclusion, the regulatory framework has failed Windermere, it's failed the Lake District, it's failed Westmorland, it's failed Cumbria, it's failed the whole of our country. Now is the time to criminalise those who callously disregard the regulations that exist and pollute our waterways.
Greg Clark.
Thank you very much indeed, Mr Deputy Speaker, and I'm grateful to the Government for signing New Clause 62 that I and my honourable friend, the member for Chatham and Aylesford, first tabled. And we're both grateful to our honourable friend, the member for South Basildon and East Thurrock, who moved a similar amendment at the committee stage of this bill. This is a distressing subject matter for an amendment to a bill. And we regret having to bring this subject matter to the attention of the House. It relates to a criminal trial that took place when, in 2021, David Fuller, as the Minister mentioned, was convicted of the murder of two young women in Tunbridge Wells, Wendy Nell and Caroline Pierce, in the 1980s. And that conviction, that recent conviction, followed a forensic lead that eventually led to his identification. In the course of the police's gathering of evidence for his murder conviction, for which he received a whole life tariff, video recordings that Fuller made of himself were found. And in context, Fuller was an electrician employed at the Maidstone and Tunbridge Wells NHS Trust. And this gave him access to the mortuaries of the hospitals. And what he did was to film himself, showing him sexually assaulting the dead bodies of women and girls in these hospital mortuaries. And there were over 100 female victims of this abuse that were discovered in his possession. They ranged in age from age 9 to 100. He was convicted for some of these offences for the sexual penetration of dead bodies, which under the current law carries a maximum sentence of 2 years in prison only. Now, as I say, it so happens that his conviction and whole life tariff was for two particularly abhorrent murders. But had that not been the case, the maximum sentence available would have been 2 years for each of these offences. Now, the evidence that was gathered by the police showed that Fuller also seriously sexually assaulted victims in non-penetrative ways. And I won't go into detail here, but I can tell the House that these crimes were extensive and grave. And given the 100 victims that were identified and identifiable, there are 33 members of this House who have families of the victims known to the police and to the NHS Trust. So this is something that spreads right across the country. All of Fuller's crimes are frankly unspeakable. But as well as the current sentencing limit being absurdly inadequate to deal with, in effect, the rape of dead bodies, it does not cover at all any form of sexual assault that is non-penetrative. The Minister, in her opening speech, made reference to it being an unusual thing that this House considers an area of the criminal law that has simply not been addressed before. So there is clearly a gap that I hope all members of the House will agree needs to be closed, and that's what this new clause aims to do. So the new clause...
Sorry, my honourable friend give way.
Of course I will.
Grateful to my honourable friend for giving way. It is certainly in the 14 years that I've been here one of the most harrowing pieces of casework that I have been involved with. My honourable friend will remember that the gap, as he's just referred to it in the casework, was identified to us by one of the police officers who was involved in the horrific task of going through the evidence, who himself said that this case shook him to the core, as I'm sure that it will with many people. So will he join me in paying tribute to the police officers and, of course, the civilians that support the police in terms of going through this evidence at the forensic level, something that I'm sure many of us not only can compute but certainly wouldn't be able to comprehend.
I'm grateful to my honourable friend, and I completely share her desire to pay tribute to the police officer that brought this gap in the law to our attention, but to all of his colleagues who had the painful duty of viewing these images, and indeed more generally to the family liaison officers of the police who had to support the families, the 100 families of these victims, and indeed the staff of the Maidstone and Tunbridge Wells NHS Trust, who knowing in many cases this individual, were devastated to discover what had gone on completely unknown to them. So this clause is an important change in the law. It increases the maximum sentence for the sexual penetration of a dead body from 2 years, as it is at the moment, to 7 years, and creates a new offence of sexual activity with a corpse, which will carry a maximum of 5 years to cover non-penetrative offences. Victims of Fuller were robbed of their lives and then their dignity, and then his families have been robbed, the victims' families have been robbed of adequate justice. The devastation of the families of Fuller's victims has been heartbreaking, as my honourable friend and other colleagues in the House will know. They suffered the deaths of their daughters, sisters, nieces, aunts, wives, mothers, and grandmothers. And then, having laid them to rest and grieved for their lost lives, hundreds received a knock on the door one night from the police, who had to tell them that the body of the person that was so precious to them had been desecrated in the most sickening ways by this vile individual in a place, a hospital mortuary, that they thought was sacrosanct and was safe and protected. And so for many, they will never get over the shock and the disgust that they felt when that news was imparted to them on that evening, and that stays with them even now. And nor, as my honourable friend says, will the police officers who had to view every second of hundreds of hours of images that are the most depraved that they have ever been confronted with. And my honourable friend said one of the officers was in touch with us and called upon us to close this gap in the law. He and his colleagues and the families of the victims will never have restored to them the peace of mind that Fuller destroyed. Their memories of their loved ones will be forever tainted by the association of that thought of what Fuller did to them. We can't correct that, very sadly, in this House, but what we can do is to ensure that these offences are recognised for having the gravity that they do. Very grateful to the Minister for supporting our new clause and giving the government's backing to it.
Yeah. Peter Dowd.
Thank you, Mr. Speaker. It's a pleasure to see you in the chair. And I think I'd like to thank the Right Honourable Member for Tunbridge Wells for speaking on that particular issue. For those of us who were on the committee, many of us are here today, the experience could have been, and was, in many cases, quite distressing, listening to so many of the anecdotes, the experiences that so many people had had over the years. And it's a tribute to members on that committee and to members today that they're actually here to pretend to listen to those experiences of people. My new clauses 35 and 36, are in relation to traffic collisions. New clause 35 seeks to require drivers who are involved in a collision with a pedestrian or cyclist or motorcyclist, for example, to ensure that they do not flee the scene of the collision and report the collision to the police or face the consequences of their decision not to report and to flee the scene. And new clause 36 reduces the amount of time from 24 hours to 2 hours that the driver involved has to report the collision. Technology has moved on. This is an old element in the Act. The capacity to report something very quickly is there for anybody. But I'd like to, before I move on, I would like to put on record my thanks to those honourable members who put the names to my new clauses. Mr Deputy Speaker, I sat on the Criminal Justice Bill, as I said, for several weeks, and we went through it line by line. And as I also indicated, we listened to harrowing, distressing accounts of victims. And in that case, it was victims, literally, from the cradle to the grave. And we've heard that again today. And colleagues who spoke in the committee will no doubt be bringing to the attention of a wider audience of honourable members today those accounts. And we've just heard one, we've heard others. And they are more than worth, they're worth listening to. And for my part, I want to bring to the attention of colleagues the reasons why I've tabled my 2 new clauses and the many groups who've supported me in bringing these, Road Peace, Cycling UK, Action Zero, Action Vision Zero, amongst others. Mr Deputy Speaker, on the 21st of November 2021, reference was made to 2 petitions gathering over 100,000 and 165,000 names respectively, calling for tougher sentences for, as it was colloquially known, hit-and-run drivers who caused death in offence of causing death by dangerous driving, and that should be widened to include failure to stop, call 999 and render aid on scene until further help arrives. Now, the Department of Transport spokesman said in response to those, the government takes this issue seriously. The Department for Transport is looking into the issue of such incidents of failure to stop resulting in death or serious injury and exploring whether there are various options that can be pursued. So, Mr Speaker, that was well over 2 years ago. And what have the government done? And what have the Department of Transport done? And it appears to me to be not a great deal in response to that. And Mr Deputy Speaker, I raised the issue of leaving the scene of a collision in the committee earlier this year. And I didn't push my new clauses to the vote. I understood that either the Justice Department or the Transport Department, who were working on this, that they could have liaised, especially given that the Department of Transport had already recognised that some assessment of the situation needs to be undertaken, and ostensibly had committed to that. And in fact, Lord Paddock, in the other place, withdrew an amendment on the 8th of November 2021 to the Road Traffic Act 1988, given that Baroness Williams of Trafford said, ministerial colleagues at the Department of Transport understand the concerns that have been raised and are, quote, exploring options, including the available penalties and how the offence operates as part of a long-term and wider work on road safety. And I did write to the Minister earlier this year indicating that I wasn't tied to the letter of my new clauses and the penalties therein, and I don't appear to have received a response to that. And I think that's regrettable. And if I did receive a response, I apologise, but I don't believe I did. I assume there was some liaison going on between the departments on this particular matter. And at the committee, I indicated why I was pursuing this in a bit more detail. And I go back to the point about how long it's taken the government to get to a position that it hasn't moved on from. It's 10 years since the government said that they would undertake a full review and consultation on traffic offences. And regrettably, that hasn't happened. Yet there seems to be an irrefutable case for that to happen. And how much does it take before the government looks at these issues affecting our constituents? And a few stats for people on this one. Let me put into context. About every 16 minutes someone is killed or seriously injured on a road in the United Kingdom. And that's a stark figure. And that's over a 10-year period. It means 31,000 men, women and children were killed or seriously injured on roads in collisions out of a total of 135 casualties right across the piece, including very minor collisions, I accept. In a year, 1,766 people were killed, 1,711 in Britain, 55 in Northern Ireland, and 28,941 seriously injured. And road deaths have increased to pre-pandemic levels. Serious injuries are up 8%. Now, I do stand to be corrected, as I said earlier, on these figures, but that's an average of about 85 people killed or seriously injured every year in each of our constituencies. 85 people on average in each of our constituencies. Meanwhile, many drivers simply get off from the scene of the collision. As many as 17,000 people, according to the Motor Insurers Bureau. Now, not all of those are related to injury or fatality, but many families are left knowing that their son, daughter, husband, brother, sister, their relative has been left on the road, dead or dying, by someone who just decided to go off. Now, that's a decision that they make. I completely accept that's a decision someone makes, that they're going to drive away and leave somebody dead or seriously injured on the road. But they have to face the consequences of that decision. It seems to me it's pretty simple, and explain in due course why you left the scene of the crime, whatever it was, but you're going to have to face the consequences, well, that person is, of doing what they did. And in the committee, I also indicated that, do I have to tell members some of the examples that families had to go through? I don't want to, because it was harrowing and distressing enough at the time to hear these examples, like the Right Honourable Member for Tunbridge Wells did. There were huge amounts of these examples. I don't want to repeat them. People know. People don't need to have this drawn out graphically, in my view. But what I did say at the committee, and I say it again, what would you say, what Mr. Deputy Speaker, would we say to a constituent who said, we have the power to take action? What would we say to them? What a shame, there's nothing much I can do about it. Sorry to hear that. What happens if the constituent said you have the power, the capacity, the wherewithal to change? Would we just shrug our shoulders and say, nothing to do with me, I'm sorry, there's nothing I can do? Would we sit there in silence? Would we look at the data, look at the information? What would we do? Well, I know what I want to do. I want to try and change the law to make sure that those people who leave people dead and dying in the road are held to account, and that they face they face up to the actions that they have taken. And it's our duty, our solemn duty, to protect our constituents. And if we can't protect them from people who decide to leave them dead and dying, we've got to try and at least send a message to the family who don't seek retribution, they seek justice. And that's what I want to do. And I'll finish in relation to this. There was a study done by Dr. Matt Hopkins at the University of Leicester, who he interviewed dozens of hit-and-run drivers as to why they failed to stop. And a fair proportion of the hit-and-run collisions, as they're called, related to drivers who don't have valid insurance. They tend not to have a valid licence. Others had had a ban at the time of the collision. Others under the influence of drink and drugs. And they were just trying to avoid the responsibility, not for just that action of potentially killing someone, but also their actions in being drunk, drugs, whatever it was. And I understand people might leave in a state of panic, but they'd still nonetheless have to face up to their responsibilities. So my new clauses were an attempt to send that message out, not in a super-duper emotional way, not trying to threaten, but to just send the message out that if a person driving, in whatever circumstance, decides to leave the scene of an accident, they must face the consequences of those actions. Now, and I've definitely finished on this point, I'm not wedded to whether that is 5 years in prison, 6 years in prison, X amount of fine. That's the point about the debate and the dialogue that we can have, that I hoped I could have had, and regrettably have not been able to have, hence why I brought these new clauses back today. I haven't said I'm going to push them to a vote. I don't want to do that. I just want people to bear that in mind, to think about the impact that these actions can have on families, and those people have got to be held to account.
Dehenna Davison.
Mr Deputy Speaker, and I know this place can have a reputation for being a home of nothing more than Punch and Judy, but I think it's on debates like today that we actually see the best of this House, with people raising the experiences of themselves, of their constituents, and working, often in a cross-party fashion, to bring forward changes to legislation that really will have the right sort of tangible impact for everyone right across our country. On that basis, there are a number of amendments that I will be supporting today, including those of my honourable friend from Chisholton and Wallington, from Romsey and Southampton North, and of course from Tunbridge Wells and Chatham and Aylesford, and I'm glad that that has already been accepted. But I rise today, to no surprise of anyone in the House, to support new Clause 9. Before I go any further, I'd just like to thank the Minister for her very kind words about my dad, and I hope she won't mind me saying I'm sure her own father and constituency predecessor will be incredibly proud of the work that she is doing in her ministerial post and in her constituency. So forgive me for indulging one, hopefully last time in the Chamber, of the story of my dad. Dominic Davison was a 35-year-old self-employed stonemason, a brilliant dad, a brilliant family man, and a great friend to all who knew him. On a Friday night in 2007, he went to the pub with his friends and he never came home. He'd regrettably been involved in an altercation that resulted in him receiving one fatal blow to the head, a blow so significant that he was dead before he even hit the ground. And that is why since then I've dedicated much of my campaigning time to trying to prevent any further families from having to go through the horror and shock that my own family had to go through. But today is not about my dad, it's not about me, it's not about my family, because as I've campaigned, it has transformed for me from something deeply personal into something much greater, which is the resilience of all of the families who have experienced these horrific tragedies, pushed through and are campaigning for change. And so it would only be right for me to pay tribute to the incredible work of Maxine Thompson-Curl and her partner Tony, who run a charity called One Punch UK, based in the brilliant North East, which again came from a terrible tragedy. Maxine has long spoken of the story of her son Christian, who was in his late teens. He'd gone to pick up his friends from a nightclub, the designated driver, a great lads, and he'd gone to the loo while his mates were finishing their drink. A guy had approached him in the toilets, asked whether or not he had a cigarette. He said no. The result of that was that Christian received a single blow to the head. Christian fell over, hit his head on the ground, and was in a coma for, I believe, about 10 months before regrettably passing away. And Maxine has dedicated her entire life since then to campaigning not only for improvements to the criminal justice system, but more broadly to improve awareness so that fewer people out there feel that the first step they should take, if they're aggravated, if they're frustrated, is to raise their fists. And the work of One Punch UK going into schools, talking to young people about the dangers that can occur from having that one split-second moment of silly action and how it can ruin not only the lives of those who lose their loved ones, but also the life of the young person who throws that blow. I really do commend them for the work that they've done. But in talking to families from right across the country, from constituencies far and wide, we have pulled out a few key themes of where the system at present isn't working in the way in which it should and in the way in which many of us would expect. And regrettably, the core theme around that does tend to be around sentencing itself. A few cases that I can raise here: the case of Sean Hardy, whose perpetrator received a sentence of just 27 months, of Lee Burns, who received a 2-year suspended sentence, of Robert Holland, who received a sentence of 3.5 years. There have been improvements in recent years to the length of sentences passed, but even now, it's believed that the average sentence for taking a life through this violent punch is around 4 years. And so the question that we have to ask ourselves in this House is, what is the price of a life? What is the price of losing your loved one? Now, I can safely say from experience that no sentence would ever be enough to make up for the tragedy, the trauma and the anguish that individuals who've lost loved ones to this face. But 4 years is not justice. 4 years is nothing short of insulting. And that's why I sought to bring forward new Clause 9 to improve sentencing, not just for a sense of justice for those families who are specifically impacted by these horrific crimes, but also to bring forward improvements to faith in our wider criminal justice system, which we know is facing difficulties with members of the public. The amendment that we tabled is based on legislation that's been introduced in a number of Australian states. We use very similar wording to try and make it as specific as possible. And I've been incredibly grateful for engagement from both the Ministry of Justice and the Home Office, including from the Home Secretary and Justice Secretary themselves, as well as, of course, from the Minister. And I do appreciate their concerns around creating discrepancies in the law. For example, as specifically talks about a punch. If someone were to be slapped forcefully, fall over backwards, this would not apply. So, of course, what I don't want to do in this House is allow emotions to dominate here, when ultimately we're here as legislators to make the best law possible, to have the best possible impact for our constituents. And I've been very grateful for the strong levels of engagement right throughout my campaign on One Punch awareness. And I know myself and One Punch UK really do offer our thanks to the government for that, and indeed to members from right across the House who have been involved, who've got involved in the campaigns, come to our awareness days and, of course, signed amendments to try and improve things for the families going through these horrific tragedies. So I'll say now, I don't intend to push my amendment forward for a vote today. And that is because, on my gratefulness to the government, they have come forward with a wonderful package of measures which we do believe will make a brilliant, tangible impact for the families impacted by these horrendous tragedies. For example, we have been offered a full review of low culpability homicides, take into account not just single punches, but any single blow and other such crimes, to look at whether or not sentencing review is needed. Of course, I would say to the Minister we would like that review to get started as quickly as possible, and I know that she recognises the urgency with which we've been campaigning on this matter. But myself and One Punch UK do look forward to working with her and with the Victims Commissioner also to get that review underway. And I will be on their backs making sure that it is a strong review with strong recommendations, and will be pushing for the government to accept those recommendations at the end of it. But sentencing itself is only a part of the picture, because one of the difficulties that we've experienced is actually the expectation gap in sentencing. So let's go on a journey from the perspective of someone whose loved one is lost. The first moment is the knock on the door to say that your loved one has been killed. The second moment is learning the reason why. The third moment is learning that it's going to go to a criminal trial. So in your mind at that point, it doesn't matter what rational explanation you can be given, your loved one has been murdered. And so in your mind, the expectation is that a murder charge will be brought and that person would go away for life. It's emotional, it's not rational, but that is the true experience of victims here. To then find out a lower charge of manslaughter will be put forward, and to find out it's a lower culpability manslaughter, meaning the average sentence will be more along the lines of 4 years, is an incredibly difficult journey for any victim to go on. And most good, law-abiding families do not have intense experience of the criminal justice system, nor should they. And so something that we have been pushing for is a single point of contact specialising in one-punch assaults to be that hand-holding guide right from day one through to the trial and beyond, to allow those expectations to be met right from the get-go, to avoid that horrific expectation gap and the feeling of betrayal by the criminal justice system. So on that basis, I am incredibly pleased that the government have appointed Rob Kirby in that role as part of the National Police Chief Council, and I look forward to meeting him and working with him to design his work stream to make sure that we can get this underway as soon as possible. But ultimately, the end goal is to stop as many families as possible from having to go through this in the future. And on that point, awareness is absolutely key. Again, I must praise once more the work of One Punch UK in going into schools, educating young people, going into prisons, talking to perpetrators about how they can turn their lives around. And on that, there is an individual that I must also praise, which is Jacob Dunn. Jacob was a perpetrator. Jacob threw a single punch. He went to prison. He turned his life around, and he now fights for restorative justice, and himself goes and speaks to young adults who've made bad choices to encourage them that there is a better way. He's worked with James Graham recently to produce a play at the Nottingham Playhouse called Punch, which I'm looking forward to seeing tomorrow. I imagine it's going to be intensely emotional, but I do look forward to seeing it. because I think it'll be a really positive step for raising that awareness and hopefully discouraging anyone else from raising their fists at the wrong moment. And on the basis of raising awareness, once again, I'm very grateful to the Ministry of Justice and the Home Office for the fact they've committed to fund a further tranche of the Walk Away campaign. That's a public awareness campaign, and they're allowing me to help co-design it alongside One Punch UK to make sure that we can spread this message to the maximum possible number of people that raising your fist is not the right answer. Once again, very grateful to all colleagues who signed this amendment. Of course, I would have liked to have seen it passed and accepted, but in this place, I think we all know that you cannot let perfect get in the way of the good. And if you told me at the start of this campaign we would have achieved what we've managed to achieve today, I would have absolutely bitten your arm off. So I was recently asked if I consider this package of measures my legacy. I absolutely don't, mainly because I'm not going to stop campaigning on this even when I've left this place. No, it's the legacy of all of those families who've lost loved ones, all of those campaigners who fought for change, and of course, of my dad Dominic. And I know that he would be as grateful as I am to the government for the positive steps that they brought forward today.
I will be calling those who've got amendments first, and those who are selected for separate decision if that follows through. Jess Phillips.
I wasn't expecting it to be me. Thank you, Madam Deputy Speaker. I do have amendments, and I'm sure everybody in this House will be delighted to hear that I won't be pushing all of them to a vote, because we may be here all night if that were the case. In the amount of work that many people, including my honourable friend, the previous speaker, I wonder if in her summing up, the Minister could give us some idea of whether this bill is actually ever going to make it onto the statute books, because I feel like we are all working quite hard to get things put into the law, and we potentially have basically like 12 weeks left in this place, and it's a pretty long bill to go through the Lords. So I'm often worried about progress being stalled and whether we're actually wasting our breath. But here I am, I'll waste mine. New clause 44 in my name seeks to replace the term controlling prostitution for gain with sexual exploitation of an adult, and provides a definition of adult exploitation through the Sexual Offences Act. In 2015, a significant change was made through the Serious Crime Act, whereby controlling a child prostitute or a child involved in pornography was replaced with the term the sexual exploitation of a child. Children who were once labelled prostitutes are now recognised as being children who've been groomed, abused and in desperate need of support. Unfortunately, no such change has occurred for adult victims of sexual exploitation, and I noted earlier the conversation around the issue of cuckooing and the importance of understanding that a person can be groomed and coerced. Absolutely would be, in the case of people who have properties, rental or owning them, would be adults in that circumstance. So we do recognise that adults can be groomed, it just isn't reflected in our laws. In fact, new clause 47, also in my name, talks about that as well. So sexual exploitation occurs where individuals or group takes advantage of an imbalance of power to coerce, manipulate or deceive a person into sexual activity. This is often done in exchange for something that the victim needs or wants, and it will disproportionately benefit the perpetrator. The impact on lives is devastating. One case study in particular from the Stage Group highlights the sudden change in perception of sexual exploitation as a person reaches adulthood. Mina was 15 when she was introduced to her perpetrator, who supplied her with alcohol and drugs, to the point that she developed a dependency on alcohol. He used fear around shame as a form of control to ensure she didn't speak out about the abuse that he would subject her to. Between the ages of 15 and 18, Mina was seen by professionals and services as a victim of child sexual exploitation, and professionals did all they could to safeguard her. At 18, the exploitation was continuing. However, since moving into adult services, the police and adult social care have questioned whether Mina was making unwise choices and whether she was getting something out of these exchanges. Mina had a missing episode and she was finally located following a sexual assault. However, the responding officer informed her support worker that this experience could not be sexual exploitation because Mina is over 18. The lack of legal definition and the continuing label of sexual exploitation of adults as controlling prostitution for gain has led to the continued abuse of countless women like Mina and the lack of response from safeguarding agencies. New Clause 44 would play a vital role in changing the perception of adult victims of exploitation. As I said, New Clause 47 would make an aggravating factor of the grooming in these cases, in adult cases, just as we do in cases of childhood sexual exploitation. Since 2019, the Stage Partnership Against Adult Sexual Exploitation, which I declare I am the chair of, has supported over 700 adult women who have experienced grooming and that is just in the North East and Yorkshire. Stage's work has confirmed that grooming is a common technique used to manipulate people for sexual exploitation. There are considerable overlaps of perpetrators' behaviour and tactics to those seen in cases of child sexual grooming, and it has a devastating negative impact on people's ability to consent, make capacitated decisions, and it is a deliberate process of limiting the freedoms of a person by gaining control over them and creating dependency. However, for adults who have experienced grooming, this is often reduced again to making poor life choices because of the belief that grooming can only happen to children. Adult victims of grooming are repeatedly asked victim-blaming questions such as, why did you get back in the car? Why did you stay with them? Why didn't you leave? I don't know if members of this house have seen the TV programme Baby Reindeer. It is one of the best examples I have ever seen, and it's interesting because it is about a man. And therefore, I think actually as a nation we might be readier to believe it. The incidents where he goes back to somebody with some more power than him, who has hold over him in his career, who is feeding him drugs for dependency, and he goes back, he would not, in our current laws, be considered to have been groomed. That wouldn't be a mitigating factor in any case that he could take. It would be if he was a child, and nobody is arguing against that. I absolutely will give way.
Making a really important point. In all of this comes back to how we view vulnerability, because it displays itself in very different ways. In almost all of these cases, there is some base vulnerability. A drug addict or a person that has been accused of various things realizes that on balance they better just do what they're told or are coerced into. And that's the real point, I think, is it not?
I absolutely agree, and it can really truly happen to anybody. I mean, we have seen even in this house how people can be coerced into things. It is dangerous. And if criminal charges go against people for blackmail or sexual violence or whatever it is, there should be an element where there is an aggravating factor of grooming a person, regardless of the age of that person, on the basis, as he quite rightly says, of a differential of vulnerability. Until grooming of adults is recognised in legislation, it will continue to be misunderstood by law enforcement and the criminal justice system, and victims will not be adequately protected. On to those who have been groomed, New Clause 45 is essentially to decriminalise the offence of loitering or soliciting for purposes of prostitution and repealing Section 1 of the Street Offences Act. Tens of thousands of sex trade survivors who are convicted of this offence endured violence and abuse from punters and pimps, while they were criminalised for offences arising from their exploitation. The exploiters and abusers remained at liberty, continuing to offend, while we criminalised the victims. In the case that I was told of, a young woman was 15 when she was first exploited into prostitution by a man posing as her boyfriend, who became her pimp. As well as sexually abusing her himself, he made her sell sex on the street, where she often feared for her life. For years, she suffered violence and abuse from her pimps and punters and was regularly arrested by the police whilst they exchanged friendly greetings with her pimp. That currently, by the way, is essentially protected in the law in our land at the moment. This is an area that needs some heavy review. As a consequence of this history, which dates back to the 1980s, she has 39 convictions for soliciting and loitering, which will remain on her record for life. Despite having exited prostitution over 30 years ago, she is one of the thousands of women who have lived through this experience. Times have changed. Those in much of street prostitution are now widely understood to be the victims and are usually no longer arrested. This is the reality. This new clause would provide the necessary recognition that women convicted of these offences were not criminals. The new clause would ensure that the UK complies with international human rights obligations to women exploited in prostitution and replicate the majority of the Council of Europe states that have fully legalised, decriminalised prostitution or adopted the sex buyer model, which decriminalises only those exploited and not those who profit or benefit from prostitution. New clause 46, which is connected, would see a mechanism for the convictions that I just talked about for those who had received it for loitering and soliciting for the purpose of prostitution to be disregarded. We have seen quite a push in this House over the criminalisation of people from the post office to quite rightly have those instances quashed. I am asking us to consider that young children and very vulnerable women who were criminalised, and it will remain on their criminal records for until the survivor reaches the age of 100. This means women who were convicted continue to be disadvantaged by the mandatory retention of these records, which are a result of being historically subject to violence and exploitation. Despite recent changes to the disclosure regime, women are still at risk of these records being disclosed to certain circumstances. And I think in the post office drama, it was that one of the women couldn't go into her kid's school to do a painting session. Like that's what we're talking about here. We're talking about women who've been exploited and then basically saying they can't have, they wouldn't be able to go into our kids' schools. New clause 48. New clause 48 argues that strangulation should be seen, and the Minister sought to address some of these issues, seen as an aggravating factor in the sentencing murders. Working with many families of murdered women, many of them speak to me of the horrors of how their loved one was killed by strangulation. Strangulation is unfortunately not a weapon. Weapons obviously have different sentencing regimes. In this instance, a man's strength is their weapon. They bring a weapon by bringing the strength to strangle and kill somebody. We have gone over the debates and the amazing work of Carol Gould and Julie Davey to look at the differentiation in those who kill a stranger in the street with a knife, or not even a stranger, just kill anyone in the street with a knife, getting a 25-year minimum sentence. But if you kill your wife with a knife in your home, you get a 15-year minimum sentence. It's fundamentally wrong, and actually Section 21, Schedule 21 needs a massive review. But one of the things we could definitely do is we could put in aggravating factors specifically, as Claire Wade suggested, on strangulation. New clause 48, 49 and 50 are, we debated extensively in committee around the issue of whether victims of domestic violence deserve defences in the law. I imagine this will get an even bigger run out in the Lords, where there are many very learned members of the other place who very much wish to see these mitigations made in cases where women commit crimes as a pattern of the abuses that they have suffered. And so I look forward to that being the ongoing debate down there. So new clause 39, which we didn't debate actually at committee, and so just to talk about it, and I like this as a policy because it doesn't cost anything. The Minister would be pleased to hear if she made new clause 93, calls for the sentencing code to be amended to require judges to consider making compensation orders where there is evidence of economic loss or damage as a result of the offence. I know from my constituents and the charity Surviving Economic Abuse that even when a survivor is lucky enough to have her case reach court and her abuser handed a prison sentence, she is living with the long-lasting impact of the abuse. 5.5 million UK women have had their money, belongings controlled by their current or former partner in the last 12 months. 5.5 million. Many economic abuse survivors often end up homeless, destitute, damaged credit scores prevent them from rebuilding their lives. While the Sentencing Code requires judges to consider awarding compensation when making their judgments, in reality they are not. Research by Surviving Economic Abuse looked at successfully controlling or coercive behaviour prosecutions that featured economic abuse between 2016 and 2020 and found that despite evidence, the loss and damage caused by the perpetrator in these cases, just 2% resulted in the perpetrator being ordered to pay compensation. So this amendment would help ensure judges are considering whether the compensation order is appropriate in cases of economic abuse. And that is the end of my amendments. However, she has had many a mention here today. The Right Honourable Member for Camberwell and Peckham, who cannot be here today, has asked me to make some remarks on NC2 on her behalf. And also, I'd make them very much on my own behalf with one particular question to the Minister. I have already asked the Minister about the issue of it being under 13. Personally, I don't think that if somebody came to me and the father of their children had raped a 14-year-old, that I would be particularly happy that I still had to go through the family court process. So I very much hope that when the Minister says this is an iterative process, that is actually going to be the case. Because I still think there are massive safeguarding issues. The new Clause 2 would change the law to protect children of convicted child sex offenders by taking away their father's parental rights. It will be hugely significant, and it will lay down that fatherhood is a privilege, not a right, and you will forfeit it if you are a danger to your children. This is a major change. The patriarchal hangover whereby a father's rights over a child were sacrosanct will, at long last, give way to the priority of protecting the child. It's long been recognised that children need protecting from sex offenders. Whilst in the 1990s we brought forward protection for children with sex offenders register and those restrictions on people who've been convicted of serious sexual offences, we didn't tackle the issue of parental rights and protect the offender's own children. Somehow the patriarchal view that a father's rights over their own children mustn't be disturbed was a carve-out. And obviously that was wrong, because it is the right of the child which should be at the forefront, not the rights of the father. A spotlight was put on this by a recent family court case in Cardiff, when the father of Bethan's daughter was sent to prison for child sexual abuse. Bethan was horrified to discover that despite being in prison, he still had rights over their child. When he was sentenced, he was given an order banning him from any future contact with children, but that ban did not extend to his own children. Bethan spent £30,000 going through family court, fighting to protect her child from him. If the courts and the law that should step forward to protect children, it should not be left to the mother. If she can, especially because in most of these cases the mother will be a victim as well. The court should strip the father who's done the offending of the rights of his child. Now, as the government have said, this change has been adopted. I have already said that I have concerns about some of the limitations of it with regard to the offence type. I mean, let's be honest, I don't believe in the right of fatherhood over parents when they're abusive at all. But I just have one question I would seek an answer from while I close my remarks. And this is what working with the member for Camberwell and Peckham is always like. There's a lot of messages. So the slight concern that the way that the legislation has been drafted has been essentially copied and pasted from previous campaigns that we worked on with regard to Jade's law around homicide. And there is a worry that this in the drafting about 10B, which is copy and pasted over, that requires local authorities to make an application to the family court to review the decision to remove the sex offending father's parental right in every case, even where there's no issue at all with the mother. And I wonder if the Minister could, in her closing remarks, answer that.
I would urge colleagues to be considerate of each other in the length of time that they're taking, because I'm trying to make sure we get everybody in, and the debate will finish at 7:20, so that means kind of about 10 minutes, 12 minutes each. Iain Duncan Smith. Sir Iain Duncan Smith.
Madam Deputy Speaker, I rise to speak in favour of Amendment New Clause 57 and what was New Clause 7, but is now the government has copied it on cooking, and its new clauses 94 and 95. So let me very briefly deal with 94 and 95. I very much welcome the government's position to, after having discussed the matter, to have essentially adopted the original amendment. There are some modifications taking place, and I agree with all of those. It's important to note that cooking is as an offence itself is really critical, because it has gone, and when we talked to the police about this, they were very clear throughout that the problem was that they couldn't get into houses where there were problems or even maybe criminal activity taking place, because there was no offence of having taken over the house. And therefore, in a way, it will make the police's job a great deal easier, that they won't have to be able to demonstrate that there is a criminal act taking place in the house on suspicion. What they have to do is just simply believe that the house has been essentially cuckooed, and now then they can go in and discover lots of stuff. And many of the criminals take over these houses for the very simple reason they know it will take a while for the police to get their act together and able to get inside. Now this will be speeded up, and that, I think, will ultimately be dramatically helpful to them. And victims often, and this is the point of vulnerability that I made to the Honourable Lady who's just finished speaking now, but I made the point, vulnerability plays a massive part in all of this. Who knows what defining vulnerability is, but some victims have drug, alcohol, physical and mental health problems, and may have learning difficulties and other disabilities. We forget about the learning disabilities element of it. Vulnerability can encompass someone's lifelong failure through all the systems of education and everything else, and they are vulnerable, but they may not display those vulnerabilities to public cognizance, but they are vulnerable, and therefore cuckooing, taking over that house, using somebody like that, is what happens, and hidden behind those doors, these victims therefore go unnoticed. Yes, I will briefly. Yeah.
Just very briefly, does my right honourable friend, building on the point he's just made, also accept that sometimes, in fact, vulnerable people might appear to be exactly the opposite? They might put up a facade, a show of great confidence, sometimes even of arrogance, including in a criminal justice process, which I've witnessed myself as a magistrate, and we need to look very carefully behind that, so we really can assess whether somebody is indeed arrogant or vulnerable.
Yes, I couldn't agree with my honourable friend more. This is why I was very much insistent that the government puts into the guidance, it's very clear that coercion and other acts therefore negate the idea that superficially the individual is declared to have given their permission. This needs to be investigated deeper by the police before they go, it's all right, they gave their say-so, it's fine. It's not fine, and that vulnerability needs to be examined. So I'm grateful to him for making that point. And I'm grateful to the Minister for having made it very clear at the beginning these will be in the guidance that we talked about earlier on. And its research from the Centre for Social Justice and Justice and Care highlighted that despite the terrible impact on victims taking control of persons' home in this way, it's not specifically a crime. And a specific offence of cuckooing is therefore needed to rectify the harm done. And until now, civil orders, they were claimed endlessly do the job. They don't, because they're short-term, they can be got quickly, but they're not lasting, they don't do anything, and they're back into the process because they're not criminal. And that's the point. Make this a criminal offence, and suddenly these perpetrators will have to think twice. So I'm being brief on this, Deputy Speaker, because I welcome, therefore, the fact the government has decided to amend their own bill with this and put this into law, and I'm grateful for that, and that will be celebrated, I think, up and down the land by many people who themselves have felt abandoned, and it's linked in many senses to what the Honourable Lady was saying earlier on about vulnerability, and maybe we'll open a wider debate about what vulnerability really is recognised in the criminal law. Can I move to Amendment New Clause 57? This is, creates an offence of causing death by serious injury and dangerous, careless or inconsiderate cycling. If accepted, it ensures cyclists are held accountable for their actions, enhance road safety and provide justice for victims and their families. It's very simply an amendment to try and bring what has been, for some reason, left completely out of the normal criminal codes and the highway code with regards to the nature of some of the problems. With the increase in cycling, and let me just make it absolutely clear, I'm completely pro and very keen for more cycling to take place. It's absolutely very good for individuals and it's also good for the environment. I recognise all of those. This is not, as often accused by people who say anything about it, anti-cycling. Quite the opposite. It's about making sure this takes place in a safe and reasonable manner. And I want to raise the case of Matthew Briggs, who has been campaigning for a law recognising death and serious injury. He is, at the moment, here witnessing these events. His attempt to get a cyclist prosecuted after his wife was killed in central London in 2016 involved a legal process that was so convoluted and difficult, even the presiding judge said afterwards, since she's retired, that this made a mockery and therefore it needed to be addressed, that the laws do not cover what happened to his wife and is happening to lots of other people. They had to use a Victorian law made in about 1850, which was about wanton and furious driving. This referred to horse riding, and nothing has been done ever since. It's quite a different offence, to be quite frank with you, but it certainly was not about cycling. And as far back as the 1950s, it was recognised that juries are slow to convict in motor manslaughter cases, which is recognised in a report which I'll come to in a second, which led to major changes in the law for drivers. And the case for change in the law concerning cyclists is now urgent. And by the way, that is not just me saying it. That is, in fact, back in 2018, the Department for Transport commissioned an independent inquiry into this very issue. And some of the points they make are really, really relevant, but nothing has been done in the period from 2018. And their opinion stated here is that there is a persuasive case for legislative change to tackle the issue of dangerous, careless cycling that causes serious injury or death in order to bring cycling into line with driving offences. It's interesting they compare this to a number of countries that do incorporate this in. It hasn't led to a fall-off in cycling there. It's actually still increasing, but at the same time they do so on a lawful base. And they quote from this one of the key components through a barrister, and I just want to quote this quickly. And they said, "I consider that this legislative change would have a positive effect on all road users." And they went on to say it would have a positive impact purely and simply on the basis of cyclists being well aware that if they were to ride in a careless or dangerous manner and were unfortunate enough to kill somebody, they would recognise that there were laws that would proceed against them. And they went on to say, "I would like to think that it would have a positive impact for people. I think I'm going to slow down. I'm not going to do anything stupid because actually it could put me in danger within the code." Now, that was an independent report back in 2018, but since then nothing has been done, which is what's made this more important. And Matthew Briggs and others campaigning on this have faced quite often a lot of abuse from people who simply don't want to see this happen. And I think this is time now for us to recognise the impact on this. Under the current 1861 law, even if someone had a bike, or called a pedestrian, they are only jailed for a maximum of 2 years. This creates a clear discrepancy between the different forms of dangerous behaviour on the roads. Punishment doesn't always fit the severity of the crime or achieve justice for the victims. And Mr. Justice Mitting, in one of the cases, made this very interesting statement, and I quote, "If the vehicle ridden by the suspect had been motorised, he would have had no defence to a charge of causing death by dangerous driving, an offence which carries a maximum sentence of 14 years' imprisonment." And so there have been calls for legislative change for some time. I mentioned the report, but there are growing numbers. And it's worth just having a look at some of the cases, recognising that Mr. Briggs's case is far from isolated. Families who have lost loved ones or have had injuries are desperate also to see change. In July 2020, Peter Macombi, 72, was killed by a cyclist, Emil Loka, who jumped a red light. In June 2022, Stuart McGinn, 29, jailed for a year after he sped on his bike round a corner in Monmouth, South Wales, hitting Jane Stone, who was 79, who died 4 days later. In June 2022, Hilda Griffiths, and this is a case very important, aged 81, was run over by a cyclist who was racing along at 29 miles an hour in a 20-mile-per-hour zone on a high-performance racing bike. She died subsequently. And quite interestingly, the extent of Hilda's injuries was so severe that all of the NHS medical profession at St Mary's Hospital could not believe that the collision had been with a bicycle. At the time, they were thinking they had misread the notes and that there must have been a motorbike or a vehicle that caused such extensive, life-threatening and dangerous injuries. Interestingly enough, they've never been able to proceed with this because the speed limit does not apply to cyclists. So these are anomalies and need to be resolved. On the 1st of May 2024, I met her, Paula dos Santos, that's quite recently, was knocked unconscious after she was hit by a speeding cyclist overtaking a car on the same spot, overtaking a car. She suffered several facial injuries and now requires reconstruction surgery for the upper jaw socket. Without this initial surgery, she would have lifelong discomfort and pain and would not be able to use her mouth properly, chew or anything else. Diana Walker, 76, died when a cyclist hit her in Pewsey, Wiltshire in 2016, and in June 2020, Iain Gunn, 56, died in South Manchester. The cyclist was cleared of wanton and furious driving. Now, it's interesting, I'm not just talking about deaths here, I'm talking about injuries. And I hope that colleagues in this House will recognise the age level of most of these people. This is older people that are getting affected by this, and it's worth recognising this is a real problem. So the Department for Transport produced statistics on pedestrians involved in road collisions in Great Britain, as reported by or to the police. Between 2018 and 2022, essentially 2,000 pedestrian casualties in Great Britain occurred in a collision involving a pedal cycle. Of these, 9 were fatal, 657 were very serious injuries, and 1,292 were injuries. The number of pedestrians hit by cyclists has increased by a third since 2020, and in 2022, the most recent year for which figures are available, there were 462 collisions between cyclists and pedestrians that were recorded by police. According to the data from NHS England, 331 pedestrians were admitted to hospital after a collision with a cyclist between 2022 and 2023. 6 of these patients were over the age of 90 and 11 were under the age of 4. So you can see the pattern here. The elderly and the very young become the people that are most affected by this. Most, bear in mind, of these injuries and accidents are not actually reported to the police because most people don't think anything will happen. And so that is one of the big problems that we've got. They are underreported as opposed to motor accidents. And I take the point made earlier on, our honourable gentleman's not here at the moment, but even there in motor vehicles, people try and abscond, and so there are changes in that. Sorry, who was trying to give it? Okay, very quickly, because I bear the Deputy Speaker's...
With regards to the specific point about road traffic accidents, and we're talking about the Criminal Justice Bill and support for victims, driving without insurance, you know, the maximum you can get is up to £300 fine or 6 points, or if it goes to court, unlimited fine and disqualified from driving. Irrespective if it's your first offence or if it's your 10th offence, does he not think we now need to address that with regards to making our roads safe as well?
I'm grateful for his intervention. He'll forgive me if I don't go down that road at this particular point because I'm dealing with a very focused amendment, and I will come to this in a second about what will happen at the end of this. But the reality for me is we need to at least, and this is de minimis really, this is what we need to do to get things back into balance and to let ordinary pedestrians, ordinary people recognise that there is in fact a problem and it needs to be rectified, and I hope the government will do this. And bear in mind that there is now an explosion of electric bikes. I have to tell you, the other day, by a small primary school with children coming out, I watched as somebody went straight past us, just avoiding the children at the last moment. I genuinely believe he must have been doing over 30 miles an hour, coat flapping in the wind, not a care in the world, no protection on him, and certainly not concerned at all about those young children that were entering the school. It was really quite a shock to many of the mothers who stood there, but I watched this astonished at the arrogance of the individual who was cycling. So with the explosion of electric bikes on the roads, reports that some bikes are adapted so they can go faster than the legal speed limits for those vehicles as well. So these are developing issues. These are not simply retrospective issues. So in summary, Deputy Speaker, the amendment, I believe, will achieve equal accountability, just as drivers are held accountable for dangerous driving results in death. Cyclists, I think, should face similar consequences for reckless behaviour that leads to fatalities. Deterrence, stricter penalties for dangerous cycling can act as a deterrent, as said in the previous report. Victim justice, families of victims deserve justice and closure. Outdated laws do not adequately address cycling-related fatalities, which leave victims of families bereft. And finally, public safety, updating traffic laws can contribute to safer road environments for all users, including pedestrians, cyclists and motorists. So this amendment, tabled by myself and many colleagues on both sides of the House, I recommend to the government. The reality is I recognise this amendment isn't perfect, as said by the Honourable Gentleman opposite. But what should happen is it should be adopted, I hope, by the government, and then it can be modified where necessary in further debate in the other place. But to simply try not to have this now is to deny the fact that there is an existing problem. So this, I believe, will be called, and Amendment New Clause 57, I intend to move it when it is called. I hope and believe the government has a chance of adopting this amendment, though we don't have to divide in that regard, because I think it would be a relevant and good position to take. And I want to end, Madam Deputy Speaker, by commending Matt Briggs. Matt Briggs has campaigned and has been vilified by many parties who didn't want this for some time, bravely. His wife died. He has been without her for a number of years, but he's never relented on that campaign. I heard him on radio for a week, just over a week ago, and his testimony so moved me to the whole point of this that I decided we had to start acting now. I make no apology for it. It's not by any means absolutely perfect, but action is better than inaction in so many cases, and I commend this to the House.
Gerald Jones.
Thank you, Madam Deputy Speaker. I'd like to speak in support of New Clause 16, which is in my name. The clause seeks to amend the Road Traffic Act of 1988 to provide that dangerous and careless or inconsiderate driving offences may be committed on private land adjacent to the highway. I'm grateful to my honourable friend, the member for Swansea, for presenting and supporting my new clause at the Bill Committee. I'm grateful for the positive comments at committee from my front bench colleagues, the shadow front bench, and from government front bench too, as outlined by my honourable friend, the member for Stockton North earlier. I'd like to give some background to the clause, if I may, Madam Deputy Speaker. And it started August 2017. A 22-month-old child, Pearl Melody Black, from Merthyr was tragically killed when walking with a father and a brother. Pearl was killed by an unoccupied vehicle that rolled from a private drive in Merthyr onto the highway, down a hill, crashing into a wall that subsequently crushed Pearl and injured her father and brother. In the months after the incident, officers from the Serious Collision Unit at South Wales Police worked tirelessly in putting a case together to provide justice for the family. In short, all tests concluded that the car was mechanically sound and it had rolled because the handbrake was not fully engaged and the automatic transmission was not fully placed into the park mode. The case was sent to the Crown Prosecution Service and was worked on by the London office as well as independent QC hired by the CPS to consult. Everyone was hopeful of a conviction under the death by dangerous driving category, and the CPS also looked into other possible options. In June 2018, however, the CPS stated that it was unable to send the case to court as a glitch in the law states that the vehicle must have started its journey on a public road to make a prosecution under the Road Traffic Act 1988. So, even though Pearl was killed on a public road, the fact that the vehicle started its descent from a private drive has meant that the prosecution was not possible. The coroner stated that the vehicle was in fact well maintained, and it seemed that the issue was very much driver operation. The inquest heard that the handbrake had not been fully applied in the park mode. The inquest into Pearl's death was heard in October 2018, and the outcome was accident. However, with the support of South Wales Police and the CPS, Pearl's parents sought to change the law and are continuing to do so, to stop other families being in a similar situation of not being able to secure justice due to a legal loophole, following such a tragic and completely preventable incident as this. As Gemma and Paul acknowledge, it would not help to bring justice for Pearl, as legislation is not retrospective, but if this law can be changed to prevent anyone else from suffering this injustice again, that may provide some comfort. I put forward a 10-minute rule bill to amend the 1988 Act, and that 10-minute rule bill had cross-party support. However, as with most 10-minute rule bills, it fell due to the lack of parliamentary time. Therefore, a new clause to the Criminal Justice Bill would allow for this change to be made. I believe that it is wholly wrong that in such cases, including those as tragic as the one that I've outlined, justice cannot be achieved. There is no conviction simply because the land on which it takes place is not classified as public. If the law were changed in relation to driving offences occurring on private land, adjoining public land, it would be a very powerful deterrent to road users showing carelessness, as well as to those who have no doubt exploited the current loophole in the law to avoid conviction when they've undoubtedly been at fault. People would be likely to take more care and pay more attention when driving or parking on private land close to public land, in the knowledge that there could be serious consequences for careless or reckless behaviour. There are instances where public land adjoins public land and it's regularly used and potentially dangerous to those around, including residential driveways, as I've outlined, but also schools, nurseries, supermarkets, shopping centres and doctors' surgeries, to name some of the most common. When we consider some of these examples, we can see that driving on that specific category of land can present a very high risk to people in everyday situations, especially children, the elderly, and some of the most vulnerable among us. I'm sure that all honourable members and right honourable members would agree that nobody who has suffered the loss of a loved one or had an accident or injury as a result of a driving offence should have to endure the injustice of seeing those responsible go free simply because of a loophole in the law. Prosecutions for driving offences, and indeed any illegal action, should be based on what happened, not where something happened. I'm hopeful that if these changes are made, it would give people such as Gemma and Paul Black and many others the peace of mind that there are consequences for dangerous driving no matter where it occurs, and help to prevent such needless and avoidable tragedies happening in the future. The Criminal Justice Bill is the first opportunity in a number of years to amend the Road Traffic Act 1988, and I understand the Justice Department have been supportive, but as the matter relates primarily to transport, it is for the Department of Transport to provide a workaround, and I am therefore grateful to the Minister for Roads, the Honourable Member for Hexham, for meeting my constituents Paul and Gemma Black a few weeks ago. The Minister offered some hope and offered to do what he could to help, and I'm also grateful for the positive conversation with the Minister, the Honourable Member for Newbury. And whilst there is work in progress on a complex issue, there isn't any sort of definitive progress as yet, and I hope that perhaps the Minister could give some indication as to the Government's current thinking when she winds up the debate this afternoon. I look forward, I will continue obviously to chase progress in this matter, because I believe this matter is one of common sense and justice, and I hope that the Government will offer some support to give my constituents, Paul and Gemma, but also no doubt many others across the constituency, that hope and peace of mind. Thank you.
Vicky Ford.
Thank you, Madam Deputy Speaker. I beg to move amendments 25 and 26 in my name. But before I do so, I just wanted to say what a huge honour and privilege it was to serve on the Bill Committee. A huge amount of work is done on this bill. We'll all be able to see elements of this bill that affect our own constituencies from a Chelmsford point of view. The new laws that will outlaw those scanners that thieves use to intercept our car key signal and then drive away with our vehicles. I really welcome the Essex Police Commissioner campaigned for the new laws on knife crime. I campaigned and lobbied the Minister, along with others, for the new amendments she introduced on spiking. I've also supported amendments that have been tabled today by colleagues on a huge range of different matters, including the ones on dangerous cycling, on cuckooing and on revenge porn. These all show how incredibly wide the scope of this bill is. It's providing the opportunity to update many crucial laws in so many areas. If we had a faint-hearted or cowardly minister, they would not have given us a bill with such a broad scope. They would have shied away from the risk. They would have so many amendments. There would be so many areas of controversy that some colleagues would table amendments that were clearly politically playing political games, and they wouldn't have taken that risk. But they have done the right thing by giving such a broad scope to this bill. They've recognised that even the best laws sometimes do need a fresh pair of eyes because situations change, and they want our laws in this country to be the best they possibly can be. So I would like to thank the ministers for not shying away from the work and for being so brave to have come forward and allowed these discussions to happen. My amendments are far from political game playing. My amendments cover the extremely important laws to protect children from the vilest of vile crimes, and those are the crimes of child sexual abuse. In particular, the laws on online child sexual abuse. There's a good reason why for so many decades it's been illegal to have images of child sexual abuse on your computer. That is because we know that people who look at this sort of content are more likely to step from the visual world into the real world and go on to abuse children. And I will argue that people who are abusing children in the virtual world are even more likely to go on to abuse our real children. My new Clause 25 will update our laws on paedophilia manuals to include AI-generated material, and new Clause 26, which also updates the laws for the rapid involvement of AI, is going to make it illegal to use digital tools such as bots or avatars to simulate sexual communication with a child. This would include acts such as creating a bot or an avatar to rape a child in a digital world. I'd like to thank the Internet Watch Foundation for their work on these amendments. They're supported by the National Police Lead on Child Sexual Abuse and others. AI is developing extraordinarily rapidly. There's been an explosion in AI content, and the consequences for this in the dark world of child sexual abuse are devastating. AI-generated images are becoming so widespread on the internet that just between September and October, the Internet Watch Foundation conducted a snapshot study on just one dark web forum. They discovered over 20,000 AI-generated images of child sexual abuse that had been uploaded in just that 1 month on that one forum. These images are now so realistic that it's incredibly difficult for law enforcement agencies to tell the differences between real images of real children who need real safeguarding and those who have been generated using artificial intelligence. Regarding Clause 26, under Section 15A of the Sexual Offences Act of 2003, it is an offence to communicate sexually with a child. My new clause creates a new offence of simulating sexual activity with a child. This includes using, creating or sharing bots or other tools to simulate sexual communication with children. I'm told that in online paedophile communities, there's always a desire to utilise technology to bring the fantasies of child sexual abuse closer to a reality, and that the evolution of AI technology is seen as the ultimate solution. It's grim. It allows child abusers to feel as close to the sensation of interacting and abusing with a real child as possible, without actually committing the physical act of abusing that child. However, given that just as we know that a person who regularly views images of child sexual abuse is more likely to sexually abuse a real child, it is absolutely clear that a person who abuses a virtual child or directs an online companion or bot to abuse that child is much more likely to go on to abuse a real one.
My honourable friend, give way.
Yes.
Honourable friend's dealing with an issue here which I think demonstrates the type of issue that's pervading all of this bill. And again, I just want to really pay tribute personally to all of the people who sat on the committee of this bill who've dealt with such a difficult range of issues. They've done a great service to our House.
Thank you. Thank you. And on behalf of all of us who sat, but I'd especially like to say that the ministers and indeed the shadow ministers to do a huge amount of work on this bill. To put it simply, the online act of abuse lowers the bar to physical offending. There's huge concern regarding the development of AI chatbots and the ease, speed and quality at which text-to-image-based generative AI tools have been developed. And furthermore, it's really important to recognise that this is becoming a risk to massive numbers of children. The National Crime Agency estimates that approximately 680 to 830,000 people, between 1.3% and 1.6% of the adult population in the UK today, pose some form of sexual threat to children. Now, Android and iOS app stores have a plentiful supply of AI companion apps. These enable the user to create an imaginary online friend, choose what that friend looks like, and then direct them what to do. The three largest apps have already received well over 1 million downloads each. Within minutes of downloading one of these popular apps, law enforcement operatives were able to have an interactive communication with an AI chatbot discussing the abduction, sexual abuse, torture and murder of an 8-year-old girl. Furthermore, through monitoring offender discussions online, we know that technically capable users are actively building AI chatbot companions specifically for the purpose of having realistic paedophilic role plays involving AI child avatars. Iain Critchley, the National Police Lead on Child Protection, has warned that the metaverse creates a gateway for perpetrators to commit horrific crimes against children. And there are many stories of child avatars being subjected to the most hideous of rapes. In evidence to the Education Select Committee, of which I'm a member, the Children's Commissioner described a child who had been virtually raped and sexually abused in an online world. She said, we mustn't think that this type of rape is not traumatic just because it's happening in an online world. It is traumatic. It is abuse. It can be part of grooming. She warned us as legislators not to underestimate the safeguarding issues. This type of behaviour normalises the sexual abuse of children. It encourages those with sexual thoughts about children to act on those urges. And we know that this type of behaviour can and does lead to contact offending in the future. It's putting real children's life at risk of significant harm, and that harm will impact them for their whole lives. And furthermore, Madam Deputy Speaker, you will be concerned to hear this. Many of these AI-generated tools have been trained on real material involving real children. This type of interaction is far from being a victimless crime. It's very clear, my honourable friend, the Minister, the AI chatbot technology has to be more tightly controlled. It needs to be regulated. At present, there is no responsibility on an individual or on an entity for creating or sharing these vile digital tools, let alone on someone for using them. And my amendment will change that. Briefly on new clause 25, this covers paedophile manuals. There already is an existing offence of possessing guides about sexual abuse of children. These are so-called paedophile manuals. The amendment will update these to include guides which give advice on creating child sexual abuse content, including using generative artificial intelligence or through machine learning. Specifically, Section 69 of the Serious Crime Act 2015 prohibits the creation, distribution and use of paedophile manuals. However, it's only applicable as an offence if it relates to directions of sexual abuse of real children, and it specifically omits pseudo-photographs. The Section 69 makes no reference to the offence of directing people to use technologies such as text-image-based generative AI or machine learning to create sexual image abuse material of children, or providing hints and tips on how to create those images. Let me give you one recent example. A recent manual of 210 pages long contained detailed information and instructions on how to extort images and videos from adolescents. The guide advised to first set out and ask the child to share images such as the child wearing swimwear, a bikini or underwear. And then, once these images have been obtained, the guide discusses how to use new-defined AI technology to remove the clothing from the child. And then it explains how to blackmail the victims into sending nude images themselves, and the guide goes on to explain how to use those images for sextortion. Then the guide contains information on specific devices, apps and websites that the perpetrator can use to protect themselves from detection. Now, sextortion is another crime that is growing incredibly quickly. The US Centre for Missing and Exploited Children globally reported over 26,000 cases in 2013. That's compared to just 10,000 the year before. We've also seen an explosion in the UK, so that the NCA actually wrote to schools very recently about the growing risks of sextortion. You may have heard that 4 weeks ago, 16-year-old Murray Downey from Dunblane died by suicide after becoming a victim of sextortion. It's a heinous crime, it's a growing crime, it's a scourge, and just imagine how much worse it will be if we allow it to become rocket-fuelled by AI-altered images. So Amendment 25 will make sure our laws preventing paedophile manuals also cover digitally generated and the digital generation of material. So, lastly, I'd like to just thank the government for New Clause 65, which introduces a duty to report child sexual offences. I would like to just mention to the Minister that it will be very important to give further clarity on how that provision works in practice. Amendment 25 is not scheduled to be moved today. I hope the Minister will confirm that they will introduce an amendment to cover the paedophilia manuals in the other place. I know colleagues in the other place intend to retable the amendment. Regarding Amendment 26, I hope the government ministers will accept the amendment. I don't think the government whips want to call upon Conservative colleagues to walk through the no lobby against an amendment that is tackling rape of children. I'm going to listen closely to what the Minister says in her closing speech.
Kim Johnson.
Thank you, Madam Deputy Speaker. I rise to speak to New Clause 28 in my name. This afternoon we've had some really strong amendments that will strengthen this criminal justice bill, but there are some amendments seeking to criminalise homelessness, further restrict peaceful protest and vastly expand police surveillance powers. But today I want to focus on my new Clause 28, which continues the campaign to fix the law on joint enterprise that I began with the support of the amazing campaigners at Jengba, Liberty and many others with my private member's bill back in February. I was grateful to receive the support of nearly 40 colleagues who backed this amendment, as well as a commitment from my own front bench back in February for Labour to seek to review and reform joint enterprise as and when we get into power. As it stands, a charge of joint enterprise too often leads to an assumption of guilt in the courtroom. The defendant is forced to prove their innocence, turning our justice system on its head. This is a failure of our justice system, supposedly the best in the world, and an affront to the taxpayer who is left footing the bill for sloppy sentencing. My amendment today would enshrine in law that only where a person is proven to have significantly contributed to a crime can they be prosecuted under joint enterprise. This would raise the bar for prosecution and provide the jury with the tools to differentiate between defendants who deserve to face a mandatory life sentence for the role they played in a serious crime and those who do not. This is a miscarriage of justice, worse than the Post Office Horizon scandal, because it involves children as young as 13 being convicted and incarcerated for a crime they did not commit and given a whole life sentence with little or no option for appeal. Campaigning by Gender and Liberty led to a 6-month pilot data collection project by the CPS, who have now agreed to fully and permanently roll out the scheme. The analysis of the original data revealed that over half of those prosecuted under joint enterprise were aged under 25, with black youth 16 times more likely to be prosecuted under joint enterprise laws than their white counterparts. And I personally welcome the commitment from the DPP to further investigate these disparities. The evidence clearly shows that this legislation is being widely used as a dragnet to maximise convictions. You only have to scrutinise the daily court list for the Old Bailey to witness how widespread this is. Joint enterprise allows the prosecution to use a racist gang narrative to imply guilt and persuade juries using prejudicial stereotypes in place of cold, hard evidence, often described as a Russian roulette. Human rights group Liberty submitted one such case last year to the Criminal Cases Review Commission after 11 defendants, all black, were collectively convicted and sentenced to a total of 168 years in prison for a single murder. Evidence included a rap video made online a year earlier, photos of some of the defendants using hand signs, and the alleged favouring of the colour red. And I hope that the CCRC, who rejected Andrew Malkinson's request to review 2 times, will look at this more favourably. In this and similar cases, the prosecution called police officers as experts to give their opinion on alleged gang culture, a concept that still evades legal definition, but one which carries with it a racist stereotype intended to sway a jury, and extremely prejudicial when considering the relationship the police have with black communities, when black people are disproportionately represented in the criminal justice system. New data from experts at Manchester Metropolitan University has revealed that nearly £250 million is spent each year on processing defendants in joint enterprise cases. For the 1,088 people on average convicted under joint enterprise every single year, the total future punishment cost to the taxpayer is a colossal £1.2 billion. With prisons not only chronically overcrowded but unsafe, as highlighted by the recent Prisons Inspectorate or urgent notifications of Wandsworth and other prisons, and with violent crime on the rise, enough is enough. Joint enterprise is costly and ineffective, and it's time for a change in the law. If the social cost of joint enterprise wasn't conclusive, the economic cost must be the final nail in the coffin for this shocking miscarriage of justice. It has been a decade since the evidence was first presented to Parliament, yet our prisons are dangerously overflowing and failing to rehabilitate, and the taxpayer is still footing the bill for thousands of people who have been wrongly jailed for the crime of another. If someone does not make a significant contribution to a crime, they should not be prosecuted for it. It's as simple as that. Joint enterprise is a stain on our justice system, and it must be reviewed and changed to stop this dragnet. It is possible to both uphold justice for the victims of crime and to put an end to this injustice. My simple change to the law will do just that, and I hope members in this House today will recognise the need for urgent change and support my amendment. Thank you.
Elliot Coburn.
Madam Deputy Speaker, and I rise to speak to my amendment, New Clause 32, which would address the disparity between existing protected characteristics and current hate crime legislation. Presently, hate crimes related to race and religion carry higher maximum penalties compared to those associated with sexual orientation, transgender or perceived transgender identity, and disability. And this has established an unjust, dual-tiered justice system. Now, this proposal on my amendment aligns with the prior expansion of aggravated offences, such as the inclusion of religiously aggravated offences in 2001, following the Crime and Disorder Act of 1998, which initially only legislated for racially aggravated offences. It also builds on the back of the Law Commission's 2021 report, which emphasised the necessity of parity and protection across all protected characteristics, and has garnered substantial support from disability and LGBT+ organisations. Now, many people have asked if this is some sort of woke frontier. We know that there's a lot of pearl clutching that happens in this place when we mention trans people. But I just want to reassure the House and for those concerned about such things that this is no such thing. This is no woke crusade. Indeed, I do not intend, as part of this amendment, to divert from existing legal definitions in law of LGBT+ identities, nor do I seek to redefine the barriers of aggravated offences. This is simply closing a loophole which the Law Commission identified, where some protected characteristics are treated differently to others in the legal system, and I can see no good reason as to why they are. There has also been the question, and we've debated many times, why this doesn't include sex and or gender. However, the Law Commission themselves recommended and was accepted by the government in their response that it should not do so because it actually would, in some cases, lead to a situation where the offence would be harder to prove, and therefore it was suggested by the Law Commission that they go down a different route in legislating for offences against women and girls, which the government accepted. The government has not yet responded to the Law Commission's 2021 report specifically on these issues. In committee stage of this bill, the government asked for additional time to do so and did not accept almost the identical amendment. In fact, I think it may have been identical at committee stage. I just want to emphasise some of the context and the background as to why I think the time has come for us to close this loophole and why I hope that the government will agree to do so. This is being done on a backdrop of increasingly escalating rates of hate crimes, which I think underscore the urgency of why we need to act. Because between 2011-12 and 2022-23, incidents across all monitored strands of hate crime have surged dramatically. Notably, racially motivated offences more than doubled, exceeding 100,000 cases in 21-22. Similarly, hate crimes based on religion, sexual orientation and transgender identity have also seen staggering increases of 433%, 493% and 1,263% retrospectively. Furthermore, violent hate incidents have surged, comprising a growing proportion of overall hate crime statistics. So I do believe that under this backdrop, the time has come for us to make sure that all protected characteristics are treated equally in law, and my amendment seeks to do just that. Now, if the government is not minded to accept the wording that I have proposed, then I would be very interested to have a conversation with ministers in the lead up to the Lords looking at this, and if a commitment is made from the dispatch box that a government amendment will be tabled in lieu of mine in the Lords, then I will be happy to back away at this time. However, if not, I will be pressing forward today. Because I do believe that it is imperative that all people, regardless of their disability status, their sexual orientation, or their gender identity, feel secure and protected from fear and violence. I can see no justification in law for treating these protected characteristics differently, and by treating these all as an aggravating offence, we can ensure equitable treatment for those who are victims under the law. So I do hope that either the government will support New Clause 32 in advancing this critical objective, or be willing to table its own in the Lords in lieu of mine.
Carolyn Harris.
Thank you, Madam Deputy Chair. Members here today may be shocked to learn that some forms of pimping are still legal in this country. One of the most significant examples of this are pimping websites. These websites are dedicated to advertising people for prostitution. They function like online brothels, making it as easy to order a woman to sexually exploit as it is to order a takeaway. Despite it being an offence to place a prostitution advert on land, for example in a phone box, our laws have failed to keep up with technology, meaning those same adverts can be legally placed for a fee on pimping websites. A win for the website owners, some of whom are generating millions of pounds of profit every year, and for sex traffickers who can easily and quickly advertise people for prostitution and connect with a wide customer base across the UK, but certainly not for the victims in this, the people who are being advertised and sold for sex who have no legal protection from their perpetrators. As a member of the Home Affairs Select Committee, I heard some harrowing evidence on the danger of these sites. Shockingly, one pimping website admitted to the committee that they allow single individuals to advertise multiple women for prostitution at the same time on their site, as well as allowing the same contact number to be used across multiple different adverts. These are both red flags for sex trafficking. The committee also heard of a trafficking gang who spent £25,000 advertising a group of young Romanian women. Rather than alert the authorities, the website owners allocated them an account manager to help them spend more money, showing a total disregard for the women's welfare. It is quite clear that these pimping websites are now a key component of the business model for sex trafficking, and they must be stopped. The provisions in the Online Safety Act do not close the legislative gap that allows online pimping. That is why the Home Affairs Select Committee recommended a new offence of enabling or profiting from the prostitution of others, which I have tabled as New Clause 8. New Clause 8 would make it illegal to advertise another person for prostitution, regardless of whether it takes place online or offline. I'm delighted to have cross-party support for this, including from the Chair of the Home Affairs Select Committee, the Right Honourable Member for Hull North, the Co-Chair of the All-Party Parliamentary Group on Commercial Sexual Exploitation, the Member for Inverclyde, the Right Honourable Member for Chingford and Wood Green, and the Honourable Member for Rotherham. It is an absolute scandal that pimping websites are allowed to operate in plain sight, and I urge the Government to support my amendment. I will now speak to New Clause 29, which is also designed to combat human trafficking. The definition of human trafficking in the Modern Slavery Act is out of line with the internationally agreed definition of human trafficking, and it is the traffickers who are benefiting from this. The United Nations Protocol on Trafficking, the Palermo Protocol, does not require victims to have been physically travelled from one place to another for it to be recognised as trafficking. However, our Modern Slavery Act does. Essentially, this means that an exploiter who forces a woman into prostitution, advertises her on a pimping website, controls how many men she has to have sex with each day, and takes her money from her, could get a substantially lower penalty simply by virtue of not physically having transported her. The maximum penalty for controlling prostitution for gain is 7 years imprisonment. For trafficking, it is life. It is vital that we send a message to all traffickers that there are no get-out clauses to this offence. If you trade in human beings, if you profit from women being raped and abused, the absence of a car journey or a flight should not exempt you from punishment. New Clause 29 would bring the UK definition of human trafficking in line with international standards and remove the opportunity for these perpetrators of crime to play the system. This too was a recommendation of the Home Affairs Select Committee, and I again urge the Government to support these amendments.
Thank you. Sir Paul Beresford.
Speaker, I'm restricting my interest today to new clause 55 in my name. The new clause is to set up the offence of child criminal exploitation. In other words, Fagan's law. The essence of the name Fagan's explains the bill in the new clause. In simple terms, if an individual, whether an adult or a child, approaches a child with the intention of persuading the child to engage in criminal activity, that of itself is a crime. This would apply whether the child ultimately engages in the criminal act or not. Now, I'm delighted to see the policing minister on the front desk, because I'm blaming him for my actually going to deal with this, because we discussed it in a meeting, and I put it to him that we really ought to be looking at the grooming legislation and adapt it or bring forward new legislation to deal with criminal exploitation of children. Like a normal minister, he said, well, can you go away and sort it out and come up with something for me? Which I did, which he's now going to possibly refuse this evening, but I hope he doesn't, because I'm going to keep on coming back. Now, the most obvious targets of crimes would be county lines, organised shoplifting, independent shoplifting, pickpocketing, carrying goods from pickpocketing, carrying weapons or proceeds of crime of some behalf or other. Usually it's an adult grooming the child. There's been some mention, quite some mention as always, of course, the prostitution and sex activities, and finally, horrifically, child for terrorist purposes. They wrap the child in a bomb, send the child off to wherever it's to go, and press the button. Horrific, absolutely horrific. Now, I've had considerable discussions with a few very senior, very knowledgeable police officers. They, unlike what the Minister may feel, are very enthusiastic that this tiny bit of legislation goes through. One of the senior officers is specifically targeting county lines and has explained to me that they are relying mostly on trying to fit the Modern Slavery Act to this particular problem, but it's a poor fit. It's been pointed out to me that this approach is already covered in legislation. Paragraph 44 of the Serious Crime Act 2007. Now, in an answer to a recent parliamentary question of mine, I was informed that Section 44 was used 93 times in 2021-22 and 60 times in 2022-23, which is pathetic. These figures are further diminished when you actually look at them a little closer. They relate to the number of offences, not to the number of individual defendants, and I'm not sure whether some or any of them involve a child. Now, a second, even more senior police officer I've worked with has a special interest in child protection. That's his job. He's made it clear that he is enthusiastic for this move, and I'm sure he will thank the policing minister if we nod it through today. He's made the point to me that while there are provisions within the Serious Crime Act 2007, just mentioned, the Modern Slavery Act 2015, and the Misuse of Drug Act, and others, relating to trying to make this fit, their point is, and his point particularly, is that it's a poor fit. It doesn't work because it's not specific to a child. In essence, the senior police officers point out to me that these pieces of legislation are really rarely used for stopping child criminalisation. They also make the point that if it was adapted ever so slightly and referred to a child, it would make it different. Any of us who are parents here, had care of children, etc., will know that children, lots of them, not all of them, most of them, are persuadable. And one of my villages, one called Begum, has a petrol station and a shop attached to it on the A246. The shop is big, well known, open 24 hours, and late one evening, the single man in there looking after the customers noticed that there was a single person in the shop, and it was an 8-year-old child in a dressing gown. And she was helping herself and obviously going to zip out the door with her pilfering. And when he approached her, she said, "If you come any closer, I'll open my dressing gown and I've got nothing on underneath." Now, she wouldn't have thought of that. She couldn't have thought of that. She's only 8. And she was quite clearly doing that for somebody, probably sitting outside with a camera. And this is the sort of thing that we should be stopping. Whether I can persuade the Minister or not, of course, I'm going to find out in due course. Now, the Child Protection Officer's opinion, as I've said, is that what we've got isn't fitting. And he and many other senior police officers in this area want further legislation to specifically equate grooming through criminal exploitation along the lines of that within the Sex Offences Act 2003, targeting at child protection. All the officers I've discussed this with, who have an interest in the protection of children, have pointed out that the very key difference with this legislation, this new clause, compared to Section 44, is that it is specifically targeted at the child. I've been impressed from my discussion with police officers on the deterrent effect on criminals who may be prosecuted for a child offence. This, I understand, tends to make life in jail even more difficult than it might otherwise be. As a number of senior lawyers, including colleagues, have pointed out to me, there is overlap and duplication within British law. I'm no lawyer, but many, including ones in the House, have said this to me. Now, the tariff, if we had such an allegiance, if my paragraph new clause went through, the tariff applied to the crime would be that would apply for the crime that the persuasion for the child was being attempted for. If it's murder, it's life. If it's just pilfering from the shop, it's something very, very much less. Now, as many will be aware, I have for many years pushed for improvement in legislation for the protection of children. I've also worked particularly as a counsellor in the inner cities, so I know they're vulnerable. If this new clause is accepted, it would bring a huge change in the protection of children against a life of crime.
Dame Diana Johnson.
Madam Deputy Speaker, I think there have been some excellent speeches this afternoon in this first day of the report stage of the Criminal Justice Bill, and many of the amendments that have been spoken to I support. I particularly, though, just want to focus in my remarks on amendments which have been tabled by honourable and right honourable members, and which the Home Affairs Select Committee has also recommended in a number of our inquiries. And I want to start with new clause 8 on pimping websites, an offence which the amendment seeks to establish an offence of enabling or profiting from prostitution, tabled by my honourable friend, the member for Swansea East. And I wanted to commend her on her speech this afternoon and setting out so clearly why this is important. The Home Affairs Select Committee has recommended this change, and we concluded that it is imperative that the government make it a criminal offence to enable or profit from the prostitution of another person in order to reduce and deter trafficking for sexual exploitation. During our inquiry on human trafficking, we were really shocked to find out not only do pimping websites used by traffickers enjoy impunity, but actually, and I hope the Minister is listening to this particular point because this is about his officials, the Home Office officials and the National Crime Agency, we found, collaborate with these pimping websites. They sit in meeting rooms with the operators of these websites and I quote, encourage them to only provide services which minimise the likelihood of illegal or high harm activity. Yet the National Crime Agency, when we questioned them about this approach, was not able to offer any evidence that this approach has led to any reduction in trafficking on these sites or has helped the safeguarding of victims. The committee was forced to therefore conclude that collaboration has been a resounding failure. And what our inquiry laid bare is that websites advertising prostitution are a significant facilitator of trafficking for sexual exploitation, and the Online Safety Act is not going to solve the problem. The Online Safety Act does not outlaw pimping websites, and in fact, disturbingly, draft guidance published by Ofcom would actually provide a defence for pimping websites to ignore warning signs of sex trafficking. And very, I suppose actually quite helpfully, I have just been to a meeting with Ofcom to challenge them on this draft guidance, and I was not impressed by the answers that they were giving me in terms of what they would expect from website providers in carrying out a risk assessment, because the Home Affairs Select Committee was quite clear: if one man was advertising 10, 20, 30, 40 women on these pimping websites using one telephone number, that to us was a red flag that there was exploitation going on, most likely trafficking going on, and yet what we were being told by Ofcom this afternoon was that that didn't necessarily mean that, because perhaps out of the goodness of his heart, this man might be helping to allow women who were choosing to advertise sex on these websites, and therefore it would be wrong for Ofcom or for the website operator to infer that there was potentially trafficking and exploitation happening. So I hope Ofcom might read this debate and might listen to the criticisms of that draft guidance that they've produced so far. The Home Affairs Select Committee heard from witnesses, websites advertising prostitution, and we took the view that these websites are a market-expanding force. They centralise, as my honourable friend said, they centralise and concentrate the customer base for traffickers, men who pay for sex, basically, and as a consequence, they are a magnet for traffickers. Even if the sites were not flagrantly ignoring the signs of sex trafficking, which they are at the moment, and may well be able to do so under the new guidance from Ofcom, I don't believe, and the committee didn't believe, that there was any way to make those sites safe. It's very easy for traffickers to cover their tracks on the site by, for instance, simply making their victims upload their own adverts to the websites. And that's why the Home Affairs Select Committee backs the change in New Clause 8, and I hope that the Minister will look again at that amendment. I also want to support my honourable friend's amendment New Clause 29, which is about the definition of human trafficking. And the amendment that my honourable friend is proposing would bring the statutory definition of human trafficking in line with the internationally agreed definition of trafficking. Firstly, by removing the requirement for the exploitation to actually have involved travel, and secondly, by clarifying that the consent of the victim is irrelevant, not just in relation to the travel, but in relation to the exploitation itself. And again, this legislative change was recommended by the Home Affairs Select Committee as a result of our inquiry on human trafficking. We concluded it was vital to remove the requirement of travel and clarify consent to exploitation is irrelevant to whether or not a crime has been committed, in order to strengthen law enforcement's ability to bring the full force of the law against perpetrators of exploitation. And it's simply too easy for sex traffickers to operate in this country right now, as my honourable friend has set out in her speech, and I again would ask the Minister to look at what the amendment would actually achieve. I also want to talk to the amendments 32 to 41 on spiking, tabled by the Honourable Member for Gloucester, and I would like to start by paying tribute to the Honourable Member for his dogged determination to ensure the government gets it right on spiking. And there's one thing I've learnt in this place over the number of years that I've been here, and you do have to persist and persist and persist until you get the outcome that you want. 2 years ago, the Home Affairs Select Committee published the results of our inquiry into the crime of spiking, and we found that spiking can have a deeply damaging impact on victims' physical and mental health, and that urgent action was needed to improve the reporting, investigation and prosecution of incidents, as well as to support victims. Crucially, the committee determined that the absence of a specific offence of spiking, in addition to limited reporting and investigation, meant that there are few deterrents for offenders. We concluded that introducing a specific criminal offence would act as a deterrent by sending a clear message to perpetrators that this is a serious crime which attracts severe penalties. It would also facilitate police work to identify perpetrators and patterns of offending by enabling the police to collect better data on the prevalence of spiking incidents, as well as encouraging victims to report spiking to law enforcement. Amendments 32 to 41 will tighten up the new clauses in the Criminal Justice Bill that relate to spiking, ensuring that they cover attempted spiking and spiking perpetrated to humiliate, to annoy, or for entertainment. And I'm pleased to add my support, and the government would be well advised to accept the honourable members' amendment so that we can finally have a robust law on spiking that deters offenders and ensures accountability. I also just want to mention Government New Clause 86. The Home Affairs Select Committee is currently conducting an inquiry into non-contact sexual offences, which encompasses a range of sexual offences involving no physical contact between the perpetrator and the victim, such as voyeurism and indecent exposure. There are significant concerns that this form of violence against women and girls is not taken seriously enough, with perpetrators too rarely held to account. So I'm pleased to see that the government are taking some action relating to non-contact sexual offences in Government New Clause 86, which creates an offence of creating a purported sexual image of an adult without consent. The Home Affairs Select Committee is developing a range of recommendations to strengthen action against non-contact sexual offending more broadly, and I do look forward to sharing those recommendations with the Minister and the Government in due course. I also just wanted to mention as well the amendments that have been brought forward by my honourable friend for Yardley, which I support, and I wanted to pay particular tribute to New Clause 9 and congratulate the Honourable Member for Bishop Auckland on her campaign over many years on this important issue. And I also want to support the Chair of the Women and Equalities Committee on the amendments that she's put forward to the House as well. Thank you.
Yeah.
Richard Graham. Thank you, Madam Deputy Speaker. There are so many things in this important bill on which it would be a great pleasure to talk, but you will be relieved to hear that I want to focus my comments today on the amendments in my name. Can I just start by saying that earlier this morning, Madam Deputy Speaker, I had two of my constituents and two people who live about a mile outside my constituency. I want to pay particular tribute to Hilary and Henry Stinchcombe. Hilary's daughter, and indeed her daughter's daughter, were murdered by Hilary's daughter's husband some years ago on the edge of Gloucester. And what that family has been through, as they said today, reminds them and me and everyone here of how incredibly important it is that criminal justice bills do address some of the most horrific crimes that anyone can go through. And so I'm grateful to the government for having done so much work on this, and particularly grateful, Madam Deputy Speaker, today, talking primarily on these 10 amendments in my name, amendments 32 to 41, to so much help from so many colleagues. The 23 members who signed the amendments, the 43 who've spoken in 2 debates and accompanied me in 2 10-minute rule bills, the terrific support given by the Right Honourable Member for Kingston on North, who led a Home Office Select Committee investigation into spiking and has given me a huge amount of moral support. This is an entirely bench, cross-party, cross-everything issue, spiking. And it is important because a bit of legal history is being made. This will be the first ever appearance of the word spiking in draft law. And because in the year to August the 2022, which I think is the last year for such data, the National Police Chiefs Council recorded just under 5,000 reported cases of spiking, divided almost equally into cases by needle and drink, with a much smaller number of reported cases primarily from food. That is why this matters so much. Anyone who does not believe that the word spiking deserves to be in law is, I suggest, missing a point that is much bigger than any of us realise. So it's been a long journey, as the Right Honourable Member of Kingston on North alluded to, and she will be interested to learn in her absolutely correct observation that persistence is perhaps the number one thing that any of us in this House need to have if we want to achieve changes in legislation. Persistence, the Latin word prorsum, was the motto of HMS Gloucester. So I take my inspiration from both the Latin and the English word, and she's right to mention it. So it has been a longer journey than members on all sides might have imagined from the size and the scale of the data. Endless meetings with Home Secretaries, Safeguarding Ministers, Justice Ministers, Select Committee members and other colleagues have eventually led us here. And, Madam Deputy Speaker, it's almost 3 years now since I first became aware of the importance of the issue, as so often happens to all of us, through my own constituent, Maisie Farmer's experience and indeed the support of her mother, Rosie. So what has made the difference to the atmosphere in which ministers have now been able to bring this forward in legislation? Well, I'm no doubt that the ebullient support and the anecdotal evidence from Dawn Dines, founder of Stamp Out Spiking, the first-hand experience from members like the Right Honourable Member for Romney and Southampton and the member for Mid-Sussex have made a difference. The fact that the actress in Coronation Street who plays a spiked heroine on the programme was comfortable to come and talk about the huge amount of correspondence that she'd had as a result of playing that role. And indeed what others, like the journalist Kate McCann, have been through and are now able to talk about. All of these things, I think, have had their influence. But today, we're here with the word spiking on the front page of the legislation, above all, because both the current Home Secretary and Justice Secretary get it. In fact, they got it some time back. And because the Safeguarding Minister, my honourable friend for Newbury, has researched and done the detail, we are able to look at the specifics of the legislation being proposed. Now, what effectively this bill does is to update sections 23 to 25 of the 1861 Offences Against the Person Act with clearer, modern, post-Sherlock Holmes language. And by the way, I imply no disparity to the great man or his casework successes. But this is exactly what I called for in our January 2023 debate, because language matters. And behavioural change is a valuable side effect of legislation. Records do need to show that spiking is the cause of both the primary and sometimes the secondary offence on police records. And the former police drugs lead specifically said, Jason Harwin, that we need a spiking offence in law because that would help identify the picture more quickly. So today, the Minister, not the Safeguarding Minister, but the Minister on the bench, if he can just tune in briefly, could he now confirm that this is the case, that the offence that is covered by these changes will be known as spiking, will come under that umbrella word of spiking and will be recorded by the police as such in their data, so that we can, for the first time, really get an accurate sense of how many cases of spiking there are, both primary and secondary. Can he also confirm that the bill will apply equally to both genders and transgenders? Can he respond to my concerns that the draft legislation may not necessarily cover the point by the Association of Police and Crime Commissioners, quote, that the creation of a separate criminal offence for spiking would send a clear message to perpetrators and victims? Because if this isn't a separate offence, can he confirm that that message will be absolutely clear and the methods through which it will be relayed? Can he also confirm, therefore, that the analysis of the data and incidents will specifically be about spiking and named as such, because this should encourage more victims to come forward? And then, Madam Deputy Speaker, there's the question of motive. The bill, understandably, focuses on harmful substances, which is indeed what most spiking cases involve, but not all, because as we know, the motivations for spiking vary. And there are some elements of spiking which are clearly about creating fear and causing humiliation without actually having harmful substances, but it does have a harmful impact. And therefore, we do need to be able to make sure that harmless as well as harmful substances are covered, even though, of course, they will waste a lot of potential investigation time. We do need to make sure that everyone is clear that so-called harmless substances intended to humiliate the victims are not acceptable and will be punished in law. Then, of course, my amendments are really designed to fill the potential gap by replacing language which is about definitive action, so administer or administering or attempt or attempting, into an intent to injure, an intent to aggrieve, an attempt to humiliate, and making sure that whether the action has actually taken place or whether it was prevented or stopped or decided not to be launched, that that attempt is absolutely covered in the law. And I'm hoping that the Minister will give me the reassurance that the Safeguarding Minister implied from the dispatch box earlier in answer to a question that the Criminal Act of 1981 does very much cover the attempt to spike as well as the actual spiking. And in the case of Amendment 41, this is to add the words to annoy or humiliate the other person or for the purposes of the entertainment of the person or any other person. That specifically would cover the non-harmful substances issue, i.e. the act of spiking as a lark, for fun, just for amusement, but not at all funny, Madam Deputy Speaker, for the victims involved. So those are the main points that I really wanted to highlight. Let me just summarise. All 10 of these amendments seek the same 3 simple objectives. Firstly, to ensure that this section of the amended 1861 law will be known to the police for their record keeping as spiking offences. Secondly, to ensure that attempts to spike, even if frustrated, are covered by the bill and its proposed tariff of punishments. And thirdly, that attempts to injure, humiliate, be amused by non-harmful substance spiking is covered. Now, Madam Deputy Speaker, these are probing amendments, and if the Minister, either the Minister in his place or his colleague, the Safeguarding Minister, is able to give me the absolute assurances, quoting as far as possible from relevant legislation, that these aspects are in fact all covered, and that we can have those reassurances, then I will certainly consider not taking these forward to a vote. And I believe that all colleagues who have supported me, including the Chair of the Home Affairs Select Committee, would accept that situation. And of course, ultimately, this really is about trying to help everyone be clear that spiking is now explicitly in the law, is a criminal offence, whether the substance is harmful or not, whether the spiking was successful or not, whether it was a joke or intended to be a joke. It is an offence that causes mental distress as much as physical harm. And if my honourable friend can convince me on these points, then we will have the tool to get to grips with spiking, to support parents, the nightlife scene, the police, the NHS, university students, and wider society, that we are getting a grip on spiking. That, in turn, would be a fantastic legacy from this Parliament, in line with the Prime Minister's support and commitment to reduce violence against women and girls, who are predominantly the victims in spiking, and the unstinting work by the Home Secretary, the Justice Secretary and the Safeguarding Minister to support us in getting spiking into the law now. Thank you.
John MacDonald.
Deputy Speaker. The Honourable Member for Birmingham Yardley, I think it was said, that is not sure whether this legislation will ever reach the statute book because of the time that we have available to us in the run-up to the next general election. I'm hoping that some of the issues that are dealt with in day 2 of our debates, some of those sections of the bill don't get on the statute book, but there are elements here today that from across the House, I think there's been an interesting setting of an agenda for certainly the next stage of the debate in the Lords on this bill, but maybe after the general election of the issues that and maybe an incoming Labour government that will have to deal with as well. And they reflect a number of the concerns that we have or we deal with as constituency MPs. So I want to congratulate the Honourable Member for Gloucester for bringing forward a series of amendments on spiking, because it is an issue that affects many of our constituents. I'm hoping the government will respond positively, work through the detail. Maybe we can have something in the Lords that reflects some of the government's, overcomes some of the government's concerns about this. I agree with him that using the expression spiking is important so that those people out there know we're dealing with it.
My honourable friend give way.
Certainly.
Just on that one, I welcome the amendments by the Honourable Member for Gloucester, and I think it's important that we also indicate that the Honourable Member for Bradford South had also been involved in moving amendments in this particular matter. I think it's a cross-party issue, and I welcome that cross-party agreement.
It looks as though the committee itself has worked really hard to try and reach consensus on some of these issues. The other issue, the right honourable member is not here for Chingford or Wood Green, but cuckooing has become a critical issue in some of our constituencies related to the most vulnerable people having their accommodation taken over by drug dealers and feeling intimidated, and often they are the most vulnerable, often those with educational special needs or mental health problems. So I think it's an issue that has occurred. It's a relatively new issue that's come to light in some of our constituencies, but it does need to be addressed. Can I also say, with regard to my friend from Bootle, brought forward his amendments. He didn't, I think, in a very dignified way, didn't want to go into the detail of individual instances that have brought this about, but there have been cases in my constituency. We had 3 youngsters, 17, one age 17, 2 age 16, killed by a hit-and-run driver. And again, the issue there, that driver was eventually caught, a drunk driver was eventually caught. The issue there was the fact that not just that they broke the law, but the fact that they didn't stick around to actually help in any way or even report the incident so that emergency vehicles could get there more quickly to assist those that had been harmed by the attack. The other issue, the 2 issues I wanted to draw attention to specifically are the ones that I've been involved in the campaigns. The Honourable Member for Liverpool Riverside brought forward her amendment on joint enterprise. I think we're all getting long in the tooth on this one. We've been campaigning for years, decades, to try and get some clarity of the law, which exactly as her amendment sets out, which does not operate as a dragnet, which draws in people. In some instances, we've had cases where the individual that's been drawn into it is not on the scene of the crime or distant from the scene of the crime, and yet at the same time have been prosecuted for serious crimes, often murder. And for that reason, the amendment's significant contribution, I think, reflects the discussions and debates that have had within legal circles, but also in the courts themselves. It's a simple amendment that would bring some justice to many of the cases where people, unfortunately, I think, have experienced what I believe is a miscarriage of justice. The second issue, the Honourable Gentleman is also not in his place at the moment, is the Honourable Member from Carshalton and Wallington, which is with regard to the more effective use of the law to tackle hate crime. The issue that I wanted to raise was
I convened a meeting of disability groups a few weeks ago. There is a wave of hate crime against disabled people at the moment on a scale that we haven't seen for a number of years. And we've had incidences of not just abuse in the street, etc. We've even had people pulled out of their wheelchairs. I don't want to become party political on this, but actually I have to say statements by some individual ministers about lifestyle choice on benefits, etc., has not helped. In fact, it's directed some hate crime towards people with disabilities. It's something we need to recognise happens. We shouldn't sweep it under the carpet, and therefore we should have an effective legal response to that. And I actually think the amendment, New Clause 32, that's been put forward by the member for Carshalton and Wallington, is an effective way of ensuring the message goes out there to people that if you commit this type of hate crime, it is a serious offence, and you will be prosecuted for it, and the sanction for it will be effective and will be serious. And that's why I'm hoping the government will accede to the new Clause 32, but if the honourable member does put it to the vote, I shall certainly be voting for it. Can I raise just one final thing, which really I just find preposterous, to be frank. And the Right Honourable Gentleman, who's the Chair of the Justice Select Committee, made reference to it, and this is the issue with regard to prisons overseas. I agree with him. I tend to think this is a stunt. I don't see it as a practical way of dealing with the overcrowding problems within our prisons. The way that we deal with them is exactly as the Justice Select Committee has been saying for a number of years. You send fewer people to prison, particularly those for whom prison is inappropriate, those with mental health problems, drug problems, etc. And then if you are going to send people to prison, you build the appropriate prisons so that we can maintain them, but more importantly, we can rehabilitate them. What this does, I think, flies in the face of all we know about rehabilitation. The things we've learned over the years, and I declare an interest, I'm an honorary life member of the Prison Officers Association. Everything that we know from the professionals involved, whether it's probation officers, prison officers, or others working within the system, is to rehabilitate people. One of the best things that you can do is, first of all, make sure they have access to their families, because they're families who actually urge them to behave, rehabilitate, come out as quickly as possible. Second thing is to make sure they have full access to training and education to rehabilitate them, but also that they have proper legal advice, that they know the situation that they're in, they come to terms with it, and yes, they understand the law as it applies to them. My fear with this is that if we depend on prisons in foreign countries, that access to family will be limited. It's inevitable. The second thing is there's no assurances here that I can see that we'll have the appropriate training or rehabilitation. And thirdly, access to legal advice within the UK system will inevitably be restricted. Therefore, I just think it flies in the face of everything we know about how prisons should work, and also actually does fly in the face of many of the things the government said itself about how the system should operate to maintain safety, but at the same time maintain rehabilitation as well. There's a number of amendments that have been put down based upon advice from others. I think it's true professional advice. I would urge that certainly the government accepts that we will not be sending prisoners abroad who are within a limited period will be faced with the potential of release. I agree also that IPP prisoners shouldn't be doubly harmed by sending them abroad as well, and that there needs to be proper consideration about the inspection arrangements. I think it's going to be almost impossible to maintain an appropriate inspection arrangement for both the prisons and also for the escort service when they're located abroad in that way. Or, if it is to be maintained, it will be extremely expensive. So I just think this is not worth the stunt that it is. And I think, again, it's a short-term measure that will, I think, at the end of the day, ministers will have egg on their face. And that's why I support those amendments that have been put forward, at least to, in some way ensure that there's a proper inspection of it and there'll be a report to Parliament on a regular basis on how it's operating. I just wish the government wasn't going ahead with it. As I say, I don't think this bill will reach the statute book, but there are a whole range of issues here that on a cross-party basis that we can take forward into whatever legislation is forthcoming, because there's so many others that amendments that people have put forward that I won't mention because others have more effectively than me, that I think does really set a really good agenda for the discussion about criminal justice in the future, even though, as I say, the next day of the debate on a number of issues I don't think will be as constructive as we've had today, because some of those proposals are impacting upon our civil liberties and human rights and can't be supported. Thank you, Madam Deputy.
Dame Maria Miller.
Thank you, Madam Deputy Speaker. And I think the Right Honourable Gentleman's speech, the Right Honourable Gentleman for Hayes and Harlington's speech has just served to demonstrate the extraordinary breadth of this bill. And Madam Deputy Speaker, sitting here this afternoon, hearing the incredible work of colleagues across the House on such an immense range of issues, I think really does underline to our constituents the very hard work that many members do on very difficult issues. The Honourable Lady from Kingston and Hull calls on us to be persistent, and I think she's right, and she'll think I'm a very persistent Member of Parliament on the issues that I'm going to be talking about today around New Clause 87, I think it is. Intimate image abuse is something that I've been talking about for nigh on a decade. She's right, we have to be persistent, and that pays off. Madam Deputy Speaker, I'll just touch briefly upon a couple of the amendments that have been talked about, and then I'll move my comments on to New Clause 86. New Clause 2, I just wanted to reiterate my support for the Mother of the House's amendment around parental responsibility after rape. It's an important amendment, and I hope the Treasury bench are listening very hard to that. And I pay tribute to my honourable friend, the member for Burton, who has also spoken out movingly on this issue. My honourable friend, the member for Gloucester, his amendments on spiking are an absolute testament to persistence. He deserves all of our gratitude for the incredible work that he's done, not only getting this to this stage, but also keeping us all so well informed of the work he's doing. Amendment 160, in the name of the chair of the Select Committee, my right honourable friend from Hampshire, Romsey, it picks up on some of the issues that I'll be talking about with regards to the way we treat non-consensual sexual images. The government needs to do more work on this, must try harder, is my suggestion. New Clause 62, my honourable friend, the member for Tunbridge Wells, made a very moving speech on the way he is bringing forward legislation to deal with the most appalling of crimes, the sexual abuse of people who are in the safety of a mortuary after they've died. New Clause 26, New Clause 25 and 6, which were moved by my honourable friend, the member for, right honourable friend, the member for somewhere in Essex, Chelmsford, that's it. I hope the Treasury bench were listening very closely to the very compelling case that she was making with regards to the rapid way in which the online world is moving and the way we need to keep law up to date. But as I said, Madam Deputy Speaker, I will speak solely on New Clause 86, which I'm in many ways very pleased the government has put onto the face of this bill. As an amendment, even though they knew it needed to be addressed after the online safety bill, it shows that the government continues to understand the importance of making intimate images without the permission of the person in the picture, that they should be made a sex crime. But yet again, we're trying to tackle this as if it were more about why the picture was taken, rather than the fact that the picture was taken in the first place. That is the wrong approach. It's as wrong now as it was when we debated it last time in the online safety bill, and I thought we'd sort of dealt with that argument, but clearly not. It was out of scope of the online safety bill to make the making and taking of an intimate image without consent a crime. So, as I say, I really welcome the fact it's being dealt with now. The online safety bill tackled the distribution of those images, but we did argue successfully in the online safety bill that when it comes to sexual offences, and New Clause 86 is creating a sexual offence, then first and foremost, Our law needs to be about consent, whether or not it's there or not about whether the perpetrator intended to cause distress or alarm. And despite the response to my intervention earlier on, it remains unclear to me why New Clause 86 is not constructed in the same way as the Online Safety Act provisions, given it works hand in hand with those. So what are we talking about? We're talking particularly about whether it should be a crime for somebody to take or make an intimate sexual image of another person without their consent. And at the moment, the bill says that it will be a crime only if the Crown Prosecution Service will be able to prove, beyond reasonable doubt, that the person taking or making the picture had the intention to cause the victim alarm, distress or humiliation. Well, Madam Deputy Speaker, the victims I've spoken to are as much victims, and indeed one of my honourable friends earlier made reference to sort of online rape, and that is the terminology that many of the victims use. They are as much a victim of that crime, whether or not the perpetrator had the intention to cause them alarm, distress or humiliation. Now, what is even more concerning, Madam Deputy Speaker, is the government knows already from evidence that many people who create these images do so not at all to do harm or distress or to alarm their victims, but they do it for money. Yeah. They do it sometimes, very oddly, for fun. They do it for their mates. They do it because they've got a collection of similar pictures. Now, all of those people who've had those nude images created or taken are no longer victims if their very good lawyers can prove that they had no intention to cause alarm, distress or humiliation. Now, that's got to be wrong, and I call on the Minister who's sitting there, and indeed both ministers, to quite frankly think again. They haven't got this right. The harm is creating the sexually explicit image without consent. The bill sets out that that is not the way the law will treat things, that they will have to prove an intention. There needs to be a motive of the perpetrator. Proving sexual gratification, as all the lawyers in this room, and I'm not one of them, knows, is incredibly difficult. A consent-based approach would focus on the core wrong of non-consensual sexual conduct. The motives are not required in most sexual offences. And I think what's even more concerning, Madam Deputy Speaker, and one of the honourable members speaking earlier talked about the way in which some organisations have removed nudification apps from their websites. Well, I'm afraid when they work out that they could use the motive that they were just trying to make money, then they wouldn't be breaking the law at all if they allow those notification apps to continue to be available. And I am also concerned as to whether or not the government have actually talked to Ofcom, the regulator, about how they will be able to limit the appearance of these images with the way the law is currently framed. So, Madam Deputy Speaker, 2 questions from me. Will the Minister urgently reconsider New Clause 86 and bring it in line with the Online Safety Act? I've got a very simple idea for her in terms of the amendment to this, which is to amend the amendment so that the base offence is consistent. It's consistent with the Online Safety Act to have a base offence to include production of a sexual image, which can include the taking or creating of an image, or you can amend, or the government could amend the government's proposed creation offence to make it consistent. To make it consent-based, not intention-based. The former, I think, is straightforward. The second question I've got is, yes, I absolutely welcome that some companies are taking preemptive action to remove their nudification apps, something which I called for about 2 years ago in the International Women's Day debate in 2021. But when they see the incredible loophole in the law, they will quickly see that actually having those notification apps, as long as they've got the right sort of legal defence, are entirely within the law. So can the Minister who responds please urgently tell the House how they're going to make sure that they do what people across the nation want to see is to make these nudification apps unlawful and get rid of them once and for all. Mr Deputy Speaker, can I put on record my thanks to Professor Claire McGlynn again for assisting me in interpreting the intentions of the Government Amendment 86, which was only published on Thursday, so I apologise to the House not being able to give a more detailed analysis, but I've only seen it for the last 3 days, and I hope at some stage perhaps the Ministers will be in a position to explain their thinking and I hope change their mind. I know that the Safeguarding Minister put into writing that she wants to send a crystal clear message that making intimate image material is immoral, in her words, and a crime. Well, she needs to try harder to make sure that this bill does just that.
Thank you very much. Emma Lowell-Buck.
Thank you very, very much, Mr Deputy Speaker. I rise to make a short speech in support of my honourable friend for Bishop Auckland's new Clause 9. And I'd like to thank her for her kind words about my friends and my constituents, Maxine and Tony. Maxine Thompson-Curl lost her son, Christian David Thompson, in 2011. He was just 19 years old. His life was taken by one punch. One punch can and does kill. To lose a loved one in such a senseless way at a young age when they were simply on a night out is a pain that I simply could not imagine. Maxine has devoted her life since Christian's passing to raising awareness, supporting others and campaigning for stronger sentencing. She has done this via her charity One Punch UK, which she runs with her husband, Anthony Curl. Using her pain, love and grief, Maxine has always been relentless in educating people to stop, think and walk away instead of using their fists. Whilst it is generally accepted there is a concerning rise in one-punch attacks across the UK, no official figures exist in relation to the lives lost and the lives devastated by a single punch. What we do know is that almost every time a precious life is taken in this way, it is reported that the perpetrator was intoxicated and their sentence for taking the life of another is almost always extremely lenient. The average sentence being 4 years and some walking away after just 4 months in prison. That's 4 months for taking somebody else's life. Justice is a very important cornerstone of our legal system. And whilst there is nothing at all that can bring back a loved one, for many people, an important part of them being able to grieve is knowing that there are consequences for the person who took their loved one away from them. New Clause 9 would put an end to lenient sentences and hopefully act as a deterrent, so people do think and walk away before they use their fists. It would also mean that we have reliable data relating to the prevalence of one-punch attacks. In the first 4 years of similar legislation being passed in Australia, the number of one-punch deaths halved, and one of their Attorney Generals has reported a massive reduction in violence since the legislation was introduced. Over 5 years ago, the then Minister said he was happy to look at what I was proposing in relation to one-punch sentencing. And I am pleased that the Government have looked at this and agreed with the Honourable Member for Bishop Auckland some progress. But my constituents remain of the view that stronger sentencing is needed. It is indeed what they have campaigned on for many years. So with that in mind, I have carefully considered the Minister's response to this new clause in committee stage. And I'm not fully convinced of her argument. She stated that one-punch attacks are already covered under manslaughter, but there is no mandatory minimum sentence for manslaughter. Therefore, no minimum sentence for one-punch attacks. That is why we are asking for it in this new clause. She stated that the Government wished to avoid anomalies in the law, given the example of someone being killed by a punch to their abdomen. But she will know, and other honourable members will know, that a single punch to the head is likely to be more catastrophic than a single punch to the abdomen. It can cause fatal damage to the brain, it can stop breathing, starving the brain of oxygen, as well as causing them to collapse and strike their head on a hard surface. The Minister also stated that they wish to avoid another anomaly, should someone be killed by 2 or more punches as opposed to 1. However, this surely would be viewed as intent to cause serious harm, whereas 1 punch could be viewed sometimes as a mistake and thus resulting in those more lenient sentences which we so often see. I sincerely hope the Minister can address these concerns in her closing comments. Maxine told me this week that she knows full well this new clause may not be accepted by the Government today, but that she is thankful for any awareness and for this being raised again on the floor of this House, because she knows the life-shattering damage that 1 punch can cause. And before I end, I want to pay tribute again to the Honourable Member for Bishop Auckland, who I'm sure will be in her place very soon, for her bravery and determination in pushing the Government to do the right thing for those who are no longer with us and for those who are left grieving for them. As the Minister said in her opening comments, I am sure the Honourable Member's dad is looking on her with pride.
Chair of the Justice Committee, Sir Robert Neal.
Thank you very much, Mr Deputy Speaker. This has been a wide-ranging debate because it's a wide-ranging bill and it's touched upon a number of very difficult, sometimes very sensitive and sometimes quite complex topics. But I think the tone of the debate does do the House a great deal of credit. And I wanted to say I appreciate the tone, I think, of the approach by both front benches to this. There's more common ground in a number of these areas than not. And let's see what we can do to improve things going forward. I particularly appreciate the approach adopted by my honourable friend, the member for Newbury, the Minister, whose engagement I think has been exceptional on all these matters. I'm grateful to her. Can I deal with some of the amendments which have been moved? I certainly congratulate my right honourable friend, the member for Chingford and Woodford Green, on his work on cooking. That is a real issue. I've seen it in my constituency, and that's a gap in the law that we need to plug. I certainly also endorse what's been said by my right honourable friend, the member for Basingstoke, in relation to her amendment and the related matters. The concept of consent is perfectly well established within the law around sexual offences. There would be absolutely nothing abnormal in importing that as being the gravamen in relation to these offences rather than the motive. And in fact, it would bring it more into line with the rest of the canon of sexual offences. So I really hope the Government will think hard about that. And I obviously take on board what the amendments in relation to those moved by my right honourable friend, the member for Romsey and Southampton, and of course the very powerful speech by my right honourable friend, the member for Tunbridge Wells, about the desecration of corpses, a vile, vile concept where clearly the law needs to be amended. If I can then turn to some specific matters which the Justice Committee has looked at over a period of time and concentrate on 2 things. One are the whole set of provisions around transfer of prisoners to serve sentences in prisons overseas. I made it pretty clear I'm very sceptical of the efficacy of this as a measure. I don't say it is unlawful. I don't think the opposition seems to say that either, actually. I do accept that it has happened in limited circumstances elsewhere, and it has happened within member states of the European Convention on Human Rights. The most obvious example being Belgium renting prison space in the Netherlands. There's also an example in Norway and Scandinavia. But the differences are very real from our situation, and I think what did happen in those 2 instances highlights the limited value of it. For a start, in the case of Belgium to Holland, of course, it was very close. It was almost literally, in some cases, up the road, because they're in the Schengen area, and similarly within the Scandinavian situation. That is not the same situation as transferring people overseas some distance away. And I think the practical implications, which the Right Honourable Member for Hayes and Harlington and others referred to, are going to get in the way of this actually achieving anything. I do hope, in particular, the Minister, I was grateful to her recognising some of the concerns that have been raised both by the opposition front bench and by the Law Society. It is absolutely imperative that proper legal advice be available. It is important, I think, that there should be an inspection regime that ensures parity of standards with those in United Kingdom prisons. And I would stress yet again the importance of maintaining family ties, because it is said time and time again, and the evidence, as the Minister who follows these things closely knows, absolutely overwhelming. The three best things for getting people to turn their lives around and stay out of reoffending are a roof over their head, a home, and a family or relationship. If you undermine that family relationship or any kind of close family ties, that it makes it more likely that those people will reoffend. So, given that the number of safeguards that will have to be put in place, not just in terms of convention rights, as the Minister rightly referred to, but also in terms of common law rights, which even predated the convention and our incorporation of that in our domestic law by the Human Rights Act. The number of safeguards make it seem to me highly unlikely that anyone will really ever end up going there, and I would much rather we concentrated on more direct measures to deal with the crisis of overcrowding in our prisons. The overseas jail cells measure is not going to make any difference to the pressures we have in our prison places now. It's not going to make any contribution to the long-term demands in itself either. If we want to return foreign national prisoners abroad, much better to speed up our prisoner return agreements and get them to serving sentences in their home countries. That would be a constructive thing, and we have the measures in place already to do that. The legal framework is in there to do that. We just need to be much more rigorous in our use of it. The other thing, of course, that really, if we want to deal with overcrowding our prisons, we need to do is for the government and the business managers to get a grip and bring back the sentencing bill to the floor of this House. That has really valuable, sensible, balanced measures which will, on the one hand, deal with public protection properly, but also will give a far better suite of measures to reduce unproductive forms of imprisonment and concentrate that very expensive resource of prison upon where it is most needed, the violent, the dangerous, the serious offenders. That will be a far greater contribution. Can I then turn to the question in relation, if I may, to joint enterprise? We have looked at that. There is a problem there. With respect, and I certainly paid massive tribute to my honourable friend, the member for Bishop Auckland, for the work that she has done in this. And it's a case which, as a lawyer, my time at the criminal bar, I have both prosecuted and defended in one-punch manslaughter cases. And I fully understand the impact of these upon families. I've had sometimes to talk to the families when we've had to accept on the evidence manslaughter charges in relation to that. But with respect, very great respect to my honourable friend, I don't think the wording of her new clause as it stands would actually meet what is required to deal with this. And I also have a concern that we're looking at it in a piecemeal fashion. Unlawful act manslaughter is a legally complex area. It is often not easy for juries to understand, not even easy for judges to direct on sometimes, looking at the factual situation. And we saw that highlighted very recently in the decision of the Court of Appeal in the case of Oriel Gray. That's the severely autistic and disabled lady whose actions caused, tragically, an elderly cyclist to fall off her bicycle into the path of a car, and she was killed. And she was originally convicted on the basis of unlawful act manslaughter. The very strong Court of Appeal quashed that conviction. Can I just wait a moment? Quashed that conviction, and that highlights, I think, some of the difficulties that we have around that. I'll give way, of course, to the Honourable Lady.
Honourable Member for Given Way, I'm interested in the comments that he's making. I was just wondering, if possible, as the bill next goes to the House of Lords, would he be able to work with myself and others concerned around one-punch attacks to draft something that he thinks would do what it's supposed to do and would be more legally sound?
I was happy to talk about it, but it's actually my conviction that a single piece of legislation purely in relation to one-punch manslaughter is not the answer anyway. If there's to be legislation, it should be a wholesale reform of the law of homicide. The Law Commission recommended a reform of the law of homicide as long ago as 2006, and it was not then acted upon. That would deal with not just the issue of unlawful act manslaughter, the other forms of manslaughter, including gross negligence manslaughter, reckless manslaughter, and the interplay between murder and manslaughter, where manslaughter is often an alternative verdict, and of course then the special defences in relation to diminished responsibility, which reduces under certain circumstances murder down to manslaughter. That is a slightly complicated field at the moment. It's difficult for juries to follow, and it's, in often terms, using law which is going back almost to the 17th, 18th century. So I think the right way forward are two things. One, all the work that is being done around the information campaigns, one-punch awareness, walk away, that's exactly the right approach, and then let's perhaps, on a cross-party basis, look again at a wholesale reform of the law of homicide, which could then indeed pick up those issues. Joint enterprise remains a problem. I pay tribute to the Honourable Member for Liverpool Riverside's amendment and the work that she has done. Again, I'm not convinced that this is the right wording, but we do have to return to this for the very important reason that many families of those who have been convicted on joint enterprise had hoped that the decision of the Supreme Court in the case of Drogi, which reversed what it described as the wrong turn taken in the law in Chang Wen Sui back in 1985, would see a number of people having their convictions quashed. In reality, subsequent decisions of the Court of Appeal have tended to narrow the approach in Drogi, very often because of the factual situations, which varies greatly. So I think we do need to look at this. Not sure that the wording we've got here will be the answer, but I do hope that we can try and work constructively on that again as we go forward. Because there are certain circumstances where it is clear that there is a role for joint enterprise, but the expansion of it, beyond, I think, that which most people regard as reasonable, is a matter of real concern. So I hope that we'll continue to work on a cross-party basis to find better solutions for this. Give way to my honourable friend.
One of the concerns that the government has raised previously when joint enterprise has been considered is the use of the word significant and a significant contribution. And the government has previously argued that that is too vague a term. But does my honourable friend agree with me that significant is actually a term that is very often commonly used in criminal justice, and that judges and magistrates are actually very experienced at knowing how to advise juries or lawyers to decide what significant actually would mean? So the government will probably need to come up with something a little more compelling than the suggestion that significant is not a meaningful word.
I entirely agree with my honourable friend. I think significant is a good starting point for the work that we need to do. It really isn't tenable, I think, to have the intellectually rather convoluted approach that we have at the moment in relation to joint enterprise. Significant, a jury will understand. That's the key. If you're going to have an indictable offence, you need to have a test that a jury will readily comprehend. Significant is something that's comprehensible to jurors. Of course I give way.
Right honourable gentleman agree with me that in the light of the debate we've had today and the several weeks of the committee itself, it's indicated that there's a lacuna in legislation in a whole range of areas, including some of the issues that are being discussed today. And I think he's suggesting that we'd have to have some cross-party approach to this. But time's running out. Does he agree that there are certain things that can be pushed through, not in a rushed fashion, but that could be considered carefully across the chamber?
I agree with the honourable gentleman's sentiments, because a lot of these things will require consideration and I would hope, for example, involvement of the Law Commission in relation to the homicide. They could be asked to revisit their report in 2006. That, I hope, would be done if there was a buy-in that whatever party was in government, that would be followed through on. Similarly, in relation to sentencing for one-punch manslaughter, and I'm just cautious, let me say, about minimum sentences generally. I understand the feeling that sometimes sentencing is too low, but at the moment, manslaughter can encompass a huge range of facts and a huge degree of culpability. And when you look at sentencing, any sentencer has to balance up the consequence of the act on the one hand and the level of culpability of the offender on the other. And it's that huge range in culpability which I think creates a difficulty with minimum sentences at the moment. What I think would be better then would be to ask the Sentencing Council to review this. And again, if that's being done in the knowledge that there will be a cross-party approach, that I think would carry more weight and will give us better outcomes at the end of the day. And finally, can I touch upon production of defendants in the dock to hear sentence passed? It's sensitive. Again, you can perfectly understand the sense of outrage for victims, families, when people refuse to come up into the dock. It's cocking a snook at the system and at them and their suffering and their grief. But there are practical issues that we have to bear in mind around this, and that's why I do think the government ought to look at some of the safeguards that are proposed in some of the amendments here, particularly because we have a duty of care to the prison staff. I pay absolute tribute to our prison staff who take risks every day. In the prison scenario, it is harder if you are being asked to do that in the holding cells of a court and the passageway up to the court and then into a dock. If one's ever been in there, and some of us have many times professionally, then then you will know that it's not actually, these are tight spaces, it's not easy, you don't have the same defensive and protective arrangements that you would have in the prison scenario. And if you've then got contractors who may not be doing this on a regular basis, there are real risks there. We don't want those people coming to harm. And of course, finally, we must ensure that the discretion ultimately always lies with the judge as to whether this is appropriate or not. Because the last thing we will want for victims' families would be some of the pretty psychopathic and sometimes extremely aggressive defendants actually trying to hijack the sentencing proceeding and actually using their presence in the court to turn upon bile, anger, rage, or, in some cases, as we've already seen, political posturing, for example, in terrorist cases. So there must absolutely be the discretion the judge ultimately has the say. I think that's recognised. That is terribly important in all of these matters. I hope that's encompassed most of the issues that we've raised. There are many others that we don't have time to touch upon. I see my honourable friend for Carshalton and Wallington here. I do hope that the government will think about this, again, because I looked at the Law Commission's report in relation to this. It is very carefully reasoned and I thought very moderately expressed. And I do hope that they'll find a means, either here or any other place in further discussion, to take his legitimate concerns on board. So there has been good progress with this bill. It's better for what it doesn't have in some cases, and we'll come to that tomorrow. And much of what it does have has been improved, I must say. But it highlights the complexities that face the criminal justice system as a whole. And we always have to be careful not to tinker when sometimes we need a more holistic approach, and of course the resource to go with it, which is the other key thing that we need to will. So I'm grateful for all those who've spoken in this debate, and I'm grateful to the Minister for the constructive tone that she has adopted throughout.
Minister.
Thank you very much, Mr Deputy Speaker. It has indeed been a wide-ranging debate. We use that phrase too often in this place, but it's true today. But it is also a pleasure to bring the debate on the Criminal Justice Bill to a close. And I'm grateful to all the honourable members who've taken part in this. And in the time available to me, I will seek to respond to as many of the non-government new clauses and amendments as I can, to answer questions. And if I fail, please give me a nudge and I'll write to you or catch up with you at some point and give you a response. I would just like to begin with new clause 9 and sort of pick up really where I left off. And I was addressing the member for Bishop Auckland and her excellent campaign, and I'd like to set out the steps that the government is taking. She alluded to them in her own excellent speech, but I wanted to confirm what they are. We have worked together with the National Police Chiefs Council lead for homicide, Kate Maynell, to appoint a named lead for one-punch homicides. This person is going to carry out an initial scoping exercise to properly establish how many of these cases are occurring and to understand if there are barriers to investigation and prosecution for these offences. I also took the honourable member's point that we should consider how the offence is communicated to the family and the particular issues that arose in her case. We will also be building on action, including the 3-month walk-away campaign that was launched in December 2023, which I think dovetails very neatly with the work of One Punch UK, and that is something I know that she will be involved in. We're going to establish a lower culpability manslaughter homicide service practice review led by Victim Support, which delivers the homicide service, and this will consider cases of manslaughter where there are lower culpability. I look forward to working with a member for Bishop Auckland and getting started with her on that. And we will be conducting individual sentence reviews into particular cases where there is an objection to the end of the sentence. We'll be looking at the sentencing remarks. She's given the name of a number of campaigners in her speech, and again I look forward to picking that up with her. Turning now to, I just wanted to pick up actually a little bit on new clause 28, the the clause relating to joint enterprise, which was raised today by the member for Liverpool Riverside, also by my honourable friend, the chair of the Select Committee, and others, and I wanted to make a short comment on that. This would caveat and curtail the law of joint enterprise and curtail it only to those who had made a significant contribution. The Honourable Lady knows that joint enterprise is there so that those who act as the burglary lookout, those who provide the weapon in the murder, those who drive the getaway vehicle do not escape the consequences of their crimes which shatter lives. It is already the case following the Supreme Court decision in Joji that the person must have helped or encouraged the commission of the offence and intended to do so. I've considered a number of recent examples of cases where there have been convictions on this basis in recent years. The boy who WhatsApped his colleague to encourage her to conduct a fatal attack, the young lad, 14-year-old lad, who stood on the edge of a woodland as lookout while his friend's gang raped another girl. I have to say, Mr. Deputy Speaker, these cases are really painful cases. And I do think, I will simply say this, I do think that people who participate in this, even on the peripheries, should not escape liability. And actually, I think you can't advance a credible argument that they should. And I think we still on this side of the House think those people ought to be locked up.
And I've not said that we should get rid of joint enterprise, but we know that there are thousands of young people, young children incarcerated. So they've been incarcerated for something that they haven't done. So the law is not being used the way it should be. As Honourable Breton just mentioned in terms of Jogi, you know, we took the wrong turn, we've taken another wrong turn, we need to get it right.
Well, I am going to respectfully differ from the member on that, but I'm happy to have another conversation with her about it. But I'm afraid I say even those on the peripheries often have their hands all over the crime. I wanted to come back briefly to the amendment that's brought by the Honourable Member, the Shadow Minister, in relation to bladed articles. I think that's an amendment that's been moved today. This is the issue of ninja swords. And it was certainly raised by the Shadow Minister, the member for Stockton North, and I wanted to address it. I wanted to just provide the reassurance that there are both straight-bladed ninja swords, which I know that his amendment is directed at, but also curved swords. They're both covered. Curved swords were banned by the government in 2008. He will know that possessing a sword or any knife, even a kitchen knife, in a public place without good reason is already a criminal offence, punishable by up to 4 years in prison. And the reason why straight swords are more difficult to ban is because, of course, some of them are held by military historians and for commemorative purposes. I wanted to provide reassurance to the Shadow Front Bench that the Policing Minister engaged very recently with the MPCC lead on knife crime, who reassured him once again that they were not seeking a ban on the use of straight-bladed swords. In fact, of all the knife crime fatalities in the last year, around about 1% was caused that way. What they are asking for is a clampdown on the online sale of knives for the under-18s. That's something we're doing in the Online Safety Act. They're asking for the power to seize knives in a private place if they think they're going to be used for a criminal purpose. They'll know that this is already in the content of this bill. And they were also looking for a ban on machetes and zombie knives, something that we're bringing in September. So I wanted to provide that reassurance. I wanted to address new clauses 25 and 26 that were introduced by the Honourable Member for Chelmsford, who I can't see, but I'm sure she is in a place. She's just popped out. And well, it was an outstanding speech which illuminated and identified yet more of the nefarious ways in which child abusers find ways to offend against children and conduct some of the most serious offences. She knows, because of her very constructive speech, that artificial intelligence raises unique problems. But I want to agree without hesitation with the force of what she's saying, with the identification of an offence as she has presented it. I recognise it is our duty as parliamentarians to future-proof our legislation, and I want to thank her for the detailed work she's done on this issue. I will commit to working with her and trying as the best we can to get something ready for report stage in the other place, but she's not there. I wanted also to pay tribute to the Honourable Member for Carshalton and Wallington. For the sensitive and thoughtful way he approached the Law Commission's report and the issue of hate crimes and the way that he's introduced the protected characteristics and the amendments to the Crime and Disorder Act. May I just make a couple of comments on this? Of course, I've read the Law Commission's excellent report on this matter, and I can confirm actually that a response to this was always forthcoming this year. I want to give two slight qualifications which may explain some of the delay. Many members in this House will be aware that the Law Commission did not recommend making the protected characteristic of sex something that should be treated as a hate crime. You may remember there was a campaign to make misogyny a hate crime. They rejected that. And that was something that did require some careful thought, because not all the protected characteristics have been treated the same way. One other thing, of course, was the implementation of the hate crime legislation in Scotland that has been both highly contentious and, I'm afraid to say, somewhat chaotic. And, of course, we would wish to avoid replicating their mistakes. But I do want to provide reassurance and say that it's our intention to deal with this subject to all the normal approvals in the House of Lords, and I really hope that he will come and speak to me and work with me on that. The other excellent speech I wanted to refer to is remember for Romsey and Southampton North, and the way that she dealt with. I'm going to just turn up some of the detail I had on her speech, but I think I remember it anyway. She alighted on two important issues, things like cyber flashing and intimate image abuse, which she identified were not on the priority Schedule 7 list under the Online Safety Act. Now, the reason for that is not because we didn't consider them to be important or to be sinister offences. I'm sure she'll need no persuading from everything that we have done on intimate image abuse that the opposite is true. The fact is that they either weren't on the statute book or certainly hadn't been commenced when we passed the Online Safety Act. I know that the Secretary of State is well aware of this, in particular in relation to both of the issues I've just alluded to. I have some degree, I know that she is conducting, as we speak, an urgent review, and I am sure that in the weeks ahead I can give her an update as to where we are on this, but I don't want her to think for a moment that we are dragging our feet. I have got to make just one very gentle point. Yes, of course I will, yes.
Way, and I appreciate that she's seeking to give me an assurance from the dispatch box that perhaps is not quite as fulsome as I would wish. When she says that the priority offences register can be reviewed, I think what would be very helpful would be if we were to have a specific timescale by which this could be added to give reassurance to all those victims of intimate image abuse that those images in their own right will be made illegal, so we can have some hope that Ofcom, the ISPs will work together to get them down, because that's what the victims want. They already have the criminal offence that the perpetrators can go to prison, but they want the images, the repeat offence, to be removed from the internet.
Well, I've listened very carefully to what she said. I agree with every single word of it. She'll know that some of this sits with DSIT, so I would need to have a conversation with the Minister, but she knows exactly that I feel as strongly on this as she do, and I will give her my best endeavour as an assurance at the dispatch box now. I wanted to talk very briefly about all of the road traffic amendments, which were really beautifully presented during the Bill Committee and again today. I know that the members, we've spoken quite a few times, I know the members are well aware that this sits with the Department for Transport, and I understand that, I know you've had engagement and there is an important review that is certainly contemplated on this issue. I also want to say... Oh, yes, sorry, of course.
Thank you, Mr Deputy Speaker. I do apologise that I was just briefly out of the chamber discussing this amendment with the Home Secretary. It is very clear that the AI technology is moving incredibly quickly in a particularly vile and disgusting way that is putting children at risk of child sexual abuse. Could she repeat the commitment that she has given with me? A commitment that she will work with me on the two areas my amendments have highlighted, work with me, the IWF and others, to make sure that the issues that they have pinpointed are addressed as this legislation goes through this House and the Lords. Thank you.
Well, I thank the Honourable Lady for her intervention. I'm sorry that we somehow didn't quite manage to overlap when I made my comments about her. I thought it was an outstanding speech, and I agree without hesitation that she is quite right to say we need to future-proof our legislation. The work that we've done on deepfakes, as I said, I think we're the first, if not the first one of them, to put a creation offence onto the statute book, shows that we are alive and very responsive to this, and I will make the commitments that she's requested.
To be clear, she's giving a cast iron guarantee to me today that these issues of paedophile manuals and using a chatbot to communicate sexually, including raping a child through a chatbot, we will address these by working with the IWF and others to make sure the laws are clear, and those, if necessary, will be amendments in the laws. Thank you.
Yes, I can give her that commitment. And I wanted to. I was interrupted, and I was actually briefly paying tribute to the very passionate speeches that have been made about the road traffic accidents, and these aren't small matters. That's such a painful case, that little girl in your constituency. I know that the Transport Secretary and other ministers have been very affected by it, and you know it's not straightforward. I know the member knows it's not straightforward for reasons that we've discussed, but I do hope that there will be progress on that in a way that helps his constituent. And I also wanted to say to the member for Chingford and Woodford Green, he is aware, he made an excellent speech on the offence of causing death or serious injury by dangerous, careless or inconsiderate cycling. It isn't in dispute that whether it is a car or an electric scooter or whether it's a bicycle, if it's operated in a certain way, it is effectively a dangerous weapon on the road. We are supportive of his amendment. We're going to be bringing it back in the Lords as he and I will be changing it in the Lords as he knows, but we are accepting it, yes. Thank you. And the final amendment, I think I've covered all of the ones that have been selected. Oh, yes, of course.
I assume that Madam meant that she's going to accept this amendment when I move it.
Thank you. Yes, I did mean that. And the final amendment that I wanted to speak to was relating to the new criminal sanction in relation to water companies. Yes, of course.
So no one in this House wants to see and to ensure that our water regulators have all the tools at their disposal that they need to get on top of the sewage discharge issue. But could she explain to the House, as she sums up on her position on this amendment, whether or not it is the case that Ofwat already have the powers that are being sought in the amendment from the Honourable Gentleman from Westmorland and Lonsdale, and if the same powers were given to the Environment Agency, this would be more likely to lead to confusion and a lack of clarity about which agency is taking the lead in such a prosecution, and that might lead prosecutions to fall through the cracks.
I thank my honourable friend for his intervention. The member for Ludlow is quite correct, and this is the basis on which we cannot accept this amendment. Of course, it is the case that everybody agrees that water companies should be punished as robustly as possible, but it is also the case that we have pre-existing offences that apply. Pollution incidents are already the subject of criminal sanctions available to the Environment Agency under the Environment Permitting England and Wales Regs 2016, and there is a serious risk of duplication, not least, and I hope the honourable member for Westmorland won't mind me saying this, but I noticed that the sanction that he had included in his amendment was just more fines, and we already have a fines regime. Let me set out very briefly the basis on which, on a principled way, we're saying no to this amendment. The Environment Regulator, the Environment Agency can and does prosecute company directors and other senior officers under the relevant regulations. They have a power to fine, and there can be convictions for polluting rivers and coastal waters, which can be proved that where it can be proved the offence has been committed. By expanding criminal liability, it would simply create a repetition of these existing powers. It is the government's view that these amendments would create a dangerous and unacceptable risk of double jeopardy across the two regulatory regimes that are administered by Ofwat and the Environment Agency. And this amendment would simply duplicate the existing sanctions, as my honourable friend, the member for Ludlow, put it, for not meeting their performance commitments, and more seriously, that it could undermine the robustness of the Environment Agency's criminal sanction regime. So I hope he will understand on that basis why we don't want to see duplication in an area where there is already the capacity to prosecute, there is already a criminal law regime, and there is already the sanction of fines, which is everything that his amendment seeks to do. Yes, I will, of course.
I fear she was coming to the end of her remarks. However, she said that she had addressed everybody that was to be put today, but she didn't address NC 44, which was my amendment, which I wonder if she has any comment on.
I thank the Honourable Lady actually for reminding me, and I hadn't forgotten, and I was listening carefully to her speech and all her amendments, not all of which are selected, and I wanted to, some of which she raised before, and the issue of the general defence. She will know the Law Commission is currently undertaking a review of the defence of duress in relation to women, in relation to the crime of... I know this hasn't been selected, but I wanted to provide her some reassurance on that, because we continue to think about the issues that she has raised on this side of the House. She's aware of the Law Commission's review into the defence of duress as it applies to murder, and I wanted to provide her with an update and some reassurance that we will take the lessons that come out of that review and consider it more widely, if indeed appropriate, in alignment with, I think, that point that she has made earlier in this debate. In relation to clause 44, she has... This is an important point between us, but I just wanted to say the reason why the government is resisting this is not because actually there's any real dispute of principle, but there is a dispute of a degree. There is a concern that by amending the wordings of sections 52 and 53 of the Sexual Offences Act as so drafted, we could unnecessarily narrow the scope of section 52 as indeed it has been applied in the criminal courts, and potentially add an additional element be proved in relation to section 53, which could make prosecution harder. So we don't do it because we disagree on the principle, but we do, I have to say, disagree on whether it will have the effect which she's looking for. And I did listen very carefully to her speech and the way that she's presented this argument on earlier occasions. Mr. Deputy Speaker. Yes, I will.
I'm very grateful to the Safeguarding Minister for giving way. She will have been briefed by her colleague, my honourable friend for Croydon South, on the exchanges across the House on the key issue of spiking, which makes its first ever appearance in legislation if this bill is to go through. And I did ask specific questions, which I'd be very grateful if she's able to return to, in order to make sure that, although the amendments won't be pursued, that everyone in the country can be reassured that the spiking clauses now injected will cover attempts to spike as well as proven spiking, and will apply to those spiking attempts which may not be considered harmful in substance, but which are incredibly harmful to the people they humiliate. And if she could do that, that would be very reassuring.
Thank you, Mr. Deputy Speaker. Yes, I can confirm that those inchoate offences, the attempt offences, are all captured in the 1981 legislation that I referred to at the top. I wanted also to respond to something that the honourable gentleman mentioned in his speech about whether, by naming the offence of spiking, it would improve police record keeping. Yes, it will absolutely do that. It will remove the discrepancy that existed, say, between the Sexual Offences Act and what might have been called date rape, and what would have been recorded previously as a poisoning act to get under the Offences Against the Person Act. So it is for consistency in recording that we are very pleased to make this change.
For giving way again. On that specific point, what she's effectively saying is that the data collected by the police will now be collected under the umbrella of spiking, so we'll have much better data and know how widespread the problem really is, which I think everyone will be very reassured to hear. And while she's here, can I just thank her and the Home Secretary and the Justice Secretary for their fantastic and immediate support in getting this into the bill, which I very much hope will be passed through this Parliament before the next general election.
Well, I thank the honourable gentleman for his intervention again. Yes, it isn't just the effect of this bill, of this change, that it will improve police recording. It was one of the purposes of the amendment that we would improve police recording, and it will give, I hope, a much more accurate picture of the extent of this problem. I also, just before I close, wanted to respond to the member for Basingstoke and the comments that she has made in relation to the creation offence related to deepfake images about intent. I will consider that very carefully, and I would like to have further discussions on that point. Yes, I will, Begum.
Thank you. I hope that she was perhaps listening to the chair of the Justice Select Committee, who wholeheartedly agreed with the point I was making, that it would be entirely consistent with the sex offences law to remove intent from that and simply focus on consent. That's what we need to hear from her, and I hope she will agree at the dispatch box now that she will consider that very strongly.
Give her that reassurance. And can I say, Mr Deputy Speaker, I look forward to continuing our discussions through the passage of this bill, and I commend these amendments to the House.
Thank you very much. It starts with, the question is that new clause 86 be read a second time. As Madam say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that new clause 86 be added to the bill. As Madam say aye. Aye. No, I think the ayes have it. The ayes have it. We now have 8 new clauses, which will all be put separately, but it's the same procedure. So we will now come to new clause 62, and I call the Minister to move new clause 62 formally.
I beg to move.
Activity with the court.
The question is that new clause 62 be read a second time. Senator, say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that new clause 62 be added to the bill. As Senator, say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to new clause 87, and I call the Minister to move new clause 87 formally.
I beg to move. New clause 87, manslaughter, sexual conduct aggravating factor.
The question is that new clause 87 be read a second time. As Madam can say aye. Aye. As you know, I think the ayes have it. The ayes have it. The question is that new clause 87 be added to the bill. As of that opinion, say aye. Aye. As you know, I think the ayes have it. The ayes have it. We come to government new clause 88. I call the Minister to move new clause 88 formally.
Move formally.
New clause 88. Length of terrorism sentence with fixed licence period, Northern Ireland.
Question is that new clause 88 be read a second time. As many as of that opinion say aye. Aye. As you know, I think the ayes have it. The ayes have it. The question is that new clause 88 be added to the bill. As many as of that opinion say aye. Aye. You know, I think the ayes have it. The ayes have it. Come to new clause 89, and I call the Minister to move new clause 89 formally.
New clause 89, reviews of sentencing time limits.
The question is that new clause 89 be read a second time. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that new clause 89 be added to the bill. As many as that say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to new clause 94, and I call the Minister to move new clause 94 formally.
I beg to move.
New clause 94, cuckooing.
The question is that new clause 94 be read a second time. As Madam say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that new clause 94 be added to the bill. As Madam say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to new clause 95, and I call the Minister to move new clause 95 formally.
Beg to move.
New clause 95, cuckooing interpretation.
The question is that new clause 95 be read a second time. Does Madam say aye? Aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 95 be added to the bill. Does Madam say aye? Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to new clause 103, and I call the Minister to move new clause 103 formally.
I beg to move.
New clause 103, restricting parental responsibility when sentencing for rape of a child.
The question is that new clause 103 be read a second time. As Madam say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 103 be added to the bill. As Madam say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to new clause 104, and I call the Minister to move new clause 104 formally.
Beg to move.
New clause 104. Report on duty to make prohibited steps orders and power to repeal.
The question is that new clause 104 be read a second time. Ms. Melvin, say aye.
Aye.
No, I think the ayes have it. The ayes have it. The question is that new clause 104 be added to the bill. As Melvin, say aye.
Aye.
Contrary, no. I think the ayes have it. The ayes have it. We now come to new clause 26, which has been selected for separate decision. Vicky Ford.
Based on the assurance the Minister's just given, I will not move my amendment.
New clause 26, not moved. We now come even to new clause 32, which has been selected for separate decision. Elliot Colburn.
Not moved.
New clause 32, not moved. We now come to new clause 44, which has been selected for separate decision. I call Jess Phillips to move new clause 44 formally.
Some of us weren't lucky enough to get any assurances. I beg to move.
The question is... Oh, sorry. Off you go.
Sexual exploitation of an adult.
It's been a long day. The question is that new clause 44 be read a second time. As Mr. Friend say aye. Aye. The contrary, no. No. Division, clear the lobby. Order. The question is that new clause 44 be read a second time. As Mayor Levin say aye. Aye. On the contrary, no. No. Tell us for the ayes, Christian Wakeford. Mary Glindon. Tell us for the noes, Mike Wood. Amanda Soloway.
The ayes to the right, 167. The noes to the left, 275.
The ayes to the right, 167. The noes to the left, 275. So the noes have it. The noes have it. Unlock. New clause 57 has been selected for separate decision. I call Sir Iain Duncan Smith to move new clause 57 formally.
I beg to move.
Dangerous, careless or inconsiderate cycling.
The question is that new clause 57 be read a second time. As mayor of that opinion, say aye. Aye! Of the contrary, no. I think the ayes have it. The ayes have it. Consequently, the question is, there's an awful lot of talk. If you want to talk, then go somewhere else. Consequently, the question is that new clause 57 be added to the bill. As matters that opinion, say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. And so we come to clause 59, which has been selected for separate decision. I call Alex Cunningham to move new clause 59 formally.
Formally.
Injure swords.
The question is that new clause 59 be read a second time. As matters that opinion, say aye. Aye. Of the contrary, no. No. Division. Clear the lobby. Order! The question is that new clause 59 be read a second time. As matters that opinion, say aye. Aye. Of the contrary, no. No. Tell us for the ayes, Christian Wakeford and Mary Glindon. Tell us for the noes, Mike Wood and Amanda Soloway. Order! Order!
The ayes to the right, 171. The noes to the left, 272.
The ayes to the right, 171. The noes to the left, 272. So the noes have it, the noes have it. Unlock. New clause 91 has been selected for separate decision. I call Tim Farron to move new clause 91 formally.
Move formally.
Offence for failing to meet pollution performance commitment levels.
The question is that new clause 91 be read a second time. As many as that opinion say aye. Aye. Of the contrary, no. No. The question is that you... no, you're not in the right place at all. Order. The question is that new clause 91 be read a second time. As many as that opinion, say aye. Aye. On the contrary, no. No. Tell us for the ayes, Christine Jardine and Sarah Green. Tell us for the noes, Mike Wood and Amanda Soloway. Order.
The ayes to the right, 17. The noes to the left, 268.
Close. The ayes to the right, 17. The noes to the left, 268. So the noes have it. The noes have it. Unlock. We now come to Government New Schedule 4. I call the Minister to move New Schedule 4 formally.
I beg to move. Schedule cuckooing, specified offences.
The question is that New Schedule 4 be read a second time. As many as that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question is that New Schedule 4 be added to the bill. As many as that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Done schedule 4. So we come now to Government Amendments 142 to 153. I call the Minister to move the amendments formally.
I beg to move.
The question is that Government Amendments 142 to 153 be made. As many as that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Amendment 160 has been selected for separate decision. I call Caroline Nokes to move the amendment formally.
Moved.
Not moved. Thank you. That concludes proceedings. Order. Order. Further consideration, what day?
Tomorrow.
Tomorrow. It being after 7 o'clock, I will now put the 7 o'clock motion, Minister, to move formally.
I beg to move.
The question is, as on the order papers, may I have that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. And so we come to motion number 4 on legal aid and advice. Minister, to move.
I beg to move.
The question is motion number 4 as on the order papers. May I have that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. With the leave of the House, I will put the following motions together. Motion number 5 on representation of the people. Motion number 6 on countryside. Motion number 7 on defence. Motion number 8 on energy. Motion number 9 on energy. Motion number 10 on retained EU law revocation and reform. Motion number 11 on International Monetary Fund, and motion number 12 on financial services and markets. Minister, to move.
I beg to move.
The question is, as on the order papers, may I have that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes